Committee on Elections will come to order. The clerk will call the roll.
Chair Smith,
Here.
Rep. Busey, Rep. Burrows, Rep. Capriglione, Rep. Deala,
Here.
Rep. Manuel,
Here.
Rep. Morales,
Here.
Rep. Swanson, Rep. Vo.
Here.
Quorum is present.
All right, a quorum is present. We are, the chair is laying out House Bill 2809 by Jatan, and will proceed with testimony. The chair calls the birthday boy, Alan Vera. Mr. Vera is 35 again, and
For the fifth time.
you're here on behalf of Harris County Republican Party Ballot Security Committee, and you're for the bill. Is that all correct?
That's all correct?
Well, happy birthday.
Thank you, sir. Appreciate it.
Absolutely. Go ahead.
All right. This bill allows Texas interstate voter crosscheck to become more effective and more cost-effective. Right now, the current system is neither. Think about it. The current ERIC system doesn't include the two largest states in the union and all their registered voters. It doesn't include any of the states that border Texas. That's a key issue for interstate voter crosscheck. The system also is slow. It's very slow. In preparing for the November 8th, 2022 election in Harris County, in 30 days, we were able to cross-check 380,000 voter registration problems in 30 days, whereas the 2 years, Eric is just clunking along. More importantly is the issue of cost effectiveness. Again, for the November 8th election in Harris County, we ran 1.1 million actual voter records through the true NCOA system at a cost of only 0.02 cents per record. We found over 100,000 voters with problems, and that's why we have 21 election challenges in Harris County. Our current system has us limited on the quality of the data and on the cost. We think this bill will let us be more cost effective and more effective. We recommend the committee report HB 2809 favorably to the full House.
Thank you, Mr. Vera. Members, any questions? No, thank you very much. Don't go far. I think we've got something for you here. I know you won't run off, but I'm just making sure. The chair calls Alex Mead. Mr. Mead, you're here on behalf of yourself, and you're against the bill. Is that all correct?
That is correct, Mr. Chairman. Good afternoon. Alex Mead for myself, against the bill. I'm going to start with what will probably sound like a bit of a digression, but I promise it's on topic. Okay. When last week the committee heard a bill that was about adding an ID form to the list of voter IDs, and one of the arguments made against that was that we shouldn't add that form because it wouldn't allow verification of citizenship or registration in the polling, or residency rather, in the polling place. And I found that a bit curious because as an election judge, I have neither the ability nor the authority to verify citizenship or residency in the polling place. I ask the voter, do you still live on Congress Avenue? But that's the extent of it. My job is to verify the identity of the voter. And if the voter has an ID that matches with the list of registered voters, the election code states that I shall accept them into the polling place. So, in order to ensure that the people that are voting are qualified to vote, I depend on that list being accurate. And what we've heard, and I don't want to put words in Ms. Adskin's mouth, but what my understanding is from voter registrars and the Secretary of State is that with all the shortcomings Eric has, it is an important part of those efforts. As we heard from Vice Chair Busey earlier in the day, with all its shortcomings, it's still the only system of its kind that exists currently. So it's striking to me that with all the talk we've had about election integrity, we're talking about a bill that, at least in the short term, would make elections less secure. So I appreciate having this public hearing. Thank you for hearing me. And I urge you to leave this bill in committee.
Members, any questions? Now tell me exactly what it is that you do.
I work in cybersecurity. This is something that I do on the side.
On the side, okay. And how exactly are you involved with elections?
I've been,
I really want to know because I'm trying to figure out
sure.
what
So-
your experience has been.
Yes, so I've been an election judge since March of last year was my first time as a presiding judge of a polling place here in Travis County. I was an election clerk before then. Before that, I've been involved in politics and various political clubs, but obviously when I step into that role as the presiding judge, my role is to conduct the election in a nonpartisan manner.
Thank you. Members, any questions? Thank you.
Thank you, Mr. Chairman.
Yes, sir. Appreciate your time. Ms. Wong. I'm going to try and get your name. Is it Shomei?
Yes, Xiao Mei, or you
Xiao
can
Mei.
call me Mei. This time I put a Mei there, so
You
that may
did.
be easier.
Shomei Wong.
Xiao Mei Wang,
And you are here on behalf of yourself and you're for the bill. Is that all correct?
that's correct.
You go right ahead.
I think I'm for this bill, and the interstate voter registration cross-check program is very necessary. But I think why people have a lot of negative comments for Eric, I think it's because it's lack of transparency. And we do not know what that program really do. And then it's hard to find any information if you search from the internet. And then also, I know people make a public information request. We're not going to have much things come out from that request. So I'm for this bill, and I wish our new cross-check program should have kind of a transparency, like, to contract with whatever the private sector company or provider, that contract should be available for public review. And also, we should have a periodical audit on the program, and the report should be also published for public to know how this program being performed, and also the cost, like how much costs the taxpayers' money. That's it. Thank you very much.
Thank you, ma'am. Members, any questions? Thank you, Ms. Wong. The chair calls Ken Moore. Not Ken Moore,
Not Susan Roebuck.
not Sears and Roebuck. You are Mr. Moore. You are here on behalf of yourself, and you are for the bill. Is that correct?
That is correct, yes, sir.
Let's go ahead.
Okay. I'd like to read to you an excerpt from a letter informing Director Hamlin, the director of ERIC, of Missouri's withdrawal from ERIC. It is from John Ashcroft, the Secretary of State of Missouri, dated March 6th this year. And the letter is to Shane Hamlin, the director of ERIC. And the excerpt reads, ERIC refuses to require member states to participate in addressing multi-state voter fraud. ERIC focuses on adding names to the voter rolls by requiring solicitation to individuals who already had an opportunity to register to vote and made the conscious decision not to be registered. ERIC allows for a hyperpartisan individual to be an ex officio member, non-voting member as a governance board. ERIC unnecessarily restricts how Missouri utilizes data reports. ERIC's benefits to Missouri are limited, as only 3 of the 8 states that border Missouri are members. Now, as was testified earlier this morning, some of these concerns have been recently addressed by ERIC. But it must be observed that the company had to be dragged kicking and screaming into making these changes. Such a company will not be amenable to future changes when they become necessary. This bill lays out a clear common sense template of what the state needs in a cross-check system. It allows for the formation of another organization to fulfill these needs. As our Secretary of State seeks to create an alternative to ERIC, this bill gives her the legislative infrastructure she will need to accomplish this.
Thanks, sir. Members, any questions? Thank you, Mr. Moore. Appreciate it. Debbie Wogamuth. Good to see you, Ms. Wogemuth.
Thank you.
You are Debbie Wogemuth. You're here on behalf of yourself and you're for the bill. Is that all correct?
Correct.
You go right ahead.
I was the coordinator of a voting roll cleanup project in McClellan County. We have 151,000 registered voters. Our project took 8 months and included 50 citizen volunteers. In our project, we were able to review 30% of our rolls, approximately 50,000 registrations. We found 10,000 errors that Eric missed. 60% of these errors were United States Postal Service change of addresses. Our voting roll cleanup project proved that Eric has dirty voting rolls, and we're wasting precious budget monies paying for Eric, a program that isn't working and isn't accurate. Texas needs to dump Eric and find a program that's accurate for maintenance of our voting rolls. Our citizens deserve better.
Thank you, ma'am. Members, any questions, Mr. Wogemuth? Appreciate you.
Thank you.
The chair calls Robert Green. Good to see you, Mr. Green. You're here on behalf of the Travis County Republican Party Election Integrity Committee for Legislation and yourself, and you're for the bill. Is that all right?
Yes, sir, it is.
Okay, go ahead.
Election integrity begins with voter confidence in a clean voter roll, and HB 2809 will be an effective tool to remove people who no longer live in the county, may be registered to vote in multiple counties or states, are, excuse me, are deceased, or are otherwise not eligible to vote. Like, for instance, they are non-citizens, or if they are a felon who are not completely off the paper. And finally, as an election judge here in Travis County for about 14 years now, I aver that anyone who testifies against or votes against this bill is not really interested in fair, transparent, or accurate election results. They just want to make it easier to manipulate the totals and illegally cast votes. We need an alternative to Eric. We may not have one right now, but I think that this bill will at least improve the ability to get accurate information from other states so that we don't permit a situation where somebody could vote in 2 states or et cetera. So if you have any questions, I'll be happy to answer them.
Thank you, sir. Members, any questions? Thank you, Mr.
Thank you, Mr.
Green.
Chairman.
I'd like the record to reflect that Chairman Capriglione's joined us. The chair calls Debbie Duke. Good to see you, Ms. Duke.
Thank you.
I understand you're here on behalf of your on behalf of the Republican Party of Texas and yourself, and you're for the bill. Is that all right?
That's right.
Okay, go right ahead.
I tried to compete with your glasses here. So we've heard what the interstate voter registration cross-check program is. This took effect in 2015, and we participated in a no-cost program. And that went up until 2020. In 2020, we joined Eric when that no-cost program was no longer available, and that was at a cost of $1.5 million in taxpayer dollars. In compliance with Eric's onerous membership agreement, Texas submits all active and inactive voter registration information and all DMV data to Eric every 60 days. This includes your full name, date of birth, address, driver's license number, last 4 of your social security number, phone number, and email address. Eric uses this information to create a list of unregistered voters. And I don't think we heard enough about the unregistered voter part today, but then the states have to contact, are required by contract to contact 95% of those individuals in an effort to register them to vote. The initial mailing was 2.5 million postcards at a cost of $858,000, followed by a subsequent mailing of $101,000. Louisiana, Alabama, Missouri, Florida, West Virginia, Ohio, Iowa have all terminated or are in the process of terminating their contract. North Carolina stopped their process of joining Eric. While each of these states outlined their reasons in press releases, there was a common concern over the security and usage of their citizens' personal data and ERIC's unwillingness to modify their membership agreement, lack of transparency, and potential violation of NVRA and HAVA. This bill would restrict the most sensitive personal information from being conveyed to non-governmental organizations assisting in voter roll accuracy and ensure Texas is focused on voter roll, the voter rolls as it is intended in the law.
Thank you, ma'am.
Thank you.
Members, any questions of Ms. Duke? Ms. Duke, could you spell your first name for us?
DEVV, as in Victor, IE.
I thought so. I just want to make sure.
Yeah.
All right. Thank you so much. The chair calls Katya Arisman. Now, Ms. Arisman, did you bring a bunch of high-level math with you this time?
Not this time, or on this bill at least, maybe
Oh,
the others.
Maybe some other ones, okay.
Yeah, sorry.
You're Katya Arisman, you're here on behalf of Common Cause Texas and yourself, and you're against the bill, is that right?
Yes, sir.
Okay, go ahead.
Awesome. Thank you so much. And thank you for the committee for hearing testimony on this bill. As some of the resource witnesses got up this morning, they testified that the interstate data records from voters that have moved from other states or been matched in other states' records are necessary for list maintenance and election integrity, which are values that we all share in terms of preserving and engaging in election administration. Unfortunately, states leaving ERIC or bills like this passing, which would preclude our existence and operation within ERIC, create their own interstate registration systems that only increases the potential for election fraud. In fact, Secretary of State Merrill of Alabama said that if bills like House Bill 2809 were to pass, it would increase the risk of election fraud exponentially, was his quote. In this committee's own organizational hearing just months ago, resource witnesses also testified that, quote, counties have the best voter registration list as they have ever been, end quote. And as House Bill 2809 would worsen Texas's and national voter registration rolls, this bill is not the solution to problems outlined in the layout if we were to need one. When Kansas tried to create their own cross-check similar to what this bill would propose, it was put out of commission and required an acknowledgement of error from the Secretary of State's office in Kansas following a lawsuit that noted that the state-led cross-check system lacked necessary security requirements. This bill as written and as it currently stands does not have the guardrails for privacy and requirements for vendors if we were to use an untested new system in place to engage in list maintenance and election administration. Additionally, Kansas's system known as cross-check was found to have a 99% false positive rate when voters with the same name are flagged as a match within their system because of the lack of data being able to be cross-checked across other states. Another example, if we're going to look at other states that did a similar model, Florida is a perfect example of this. When the day they left ERIC, a man was arrested for illegal voting using data that the county's election administrator testified as only being able to come from ERIC. This bill, if passed and endorsed by the committee, would fall into the same trap as Kansas and Florida, with voter lists being in limbo until we have a new untested software being put in place. So in the meantime, we should be looking to reform ERIC and not passing 2809.
Thank you, ma'am. Members, any questions? Representative Morales.
Ms. Conte, do you believe that ERIC in its current format is adequate, or does it need additional modifications to address some of the issues and concerns?
Yeah, I would probably defer to the resource witnesses from the Secretary of State's office that would have more purview over what the accuracy of the list and voter rolls look like. We don't have that access. What I would say is that there seems to be some impetus, as testified in just the witness before me, that there is a democratic process for them to amend rules and processes in ERIC from the participating states. So as any alternative system would be untested until that time, it would probably be better to use the medium as given to recommend, better list maintenance, better vendor privacy requirements, et cetera, if we were to continue to stay in ERIC. But yeah, I think the process is set up to allow for us to do that.
Now, maybe this is, and let me know if it's also a question I should ask better from the Secretary of State. But is it your understanding that cross-checking the names with these other states that participate in ERIC is only good and valid for those states that are participating? So if they're not participating, then we have no way if Heriberto Morales is voting in Arizona and in Texas.
That would be a question for the resource witness, probably.
Lastly, do you have information with respect to the previous witness in McClellan County, the 151 registered voters? Do you have access to that information and the 60% of the errors that they encountered?
We haven't gotten access to that information. We can look into it within our organization. I would say, if that's something that's currently happening, it seems like the system's working as intended to allow for us to have a list in place to do that cross-checking. And so using an untested or potentially unsecure system, insofar as 2809 doesn't outline any privacy requirements for vendors that would be operating within the new system, it seems probably better that we continue to go about this and use it as intended.
Do you or your organization have any proposed wording that would make Representative Jaton's 2809 bill a better bill?
We can get you some and get back to
share
your
that
office
with
with that. Yeah, absolutely.
Thank you.
Any other questions, members? Thank you, Ms. Harrison.
Thank you.
The chair calls Robert Jacoby. Afternoon, Mr.
Afternoon.
Jacoby. You are testifying on behalf of the Dallas County Republican Party Election Integrity Committee, and you're for the bill. Is that all correct?
That is correct, sir.
Go ahead.
Thank you, Committee Chair Smith and all you for this. My colleagues with the Dallas County Republican Party Election Integrity Committee looked at this, looked at all the data coming from states, and were firmly against ERIC. I spent some time talking to folks in Louisiana and Alabama. I want to sit there and mention Wes Allen, who's the new Secretary of State of Alabama, and he got out of ERIC. A couple of things. He went to Washington, D.C. on a trip with the SOSs from other states. He said, well, I'm going to go find Eric. He goes to the building. It's a virtual office. Nobody's there. Where are the computers? It's like, what kind of operation is that? I think the cost, according to my colleague, and I back up everything I second what Mr. Vera has mentioned from Harris County, the cost over 2 years has cost the state of Texas in 2021 and 2022, $1.5 million. I'm confident there are other solutions that are better. If you look at the credit bureau reports alone, which frankly I could subscribe to at a modest amount and clean the voter rolls in Dallas County, or at least in sections of Dallas County all by myself, it would be a lot less money. I think Keith Ingram actually looking at solutions is a more viable pathway for a conclusion of this matter by striking ERIC or getting prepared to end ERIC and then moving to a new system. So I'm fully in support of the bill.
Thank you, sir. Members, any questions? Thank you. Appreciate you being here. The chair calls Michael Belsick. Michael Belsick. Michael Belsick, I show him as testifying on behalf of himself. He's for HB 2809, and he is not here to testify. Who we got next? Sorry about that. The chair calls Susana Carranza. Okay, just 1 second.
Is it the League of Women Voters Texas? Okay, so we'll edit that and then you'll restate it when he calls you again.
Thank you.
Myself and.
Yes, ma'am.
Okay, you are Susana Carranza. You're here testifying on behalf of the League of Women Voters of Texas and yourself, and you're against the bill, is that correct?
Yes, that's correct.
Okay, go ahead.
Good afternoon. I oppose, me and the League of Women Voters oppose House Bill 2829. Thanks for the hearing. This bill would withdraw Texas from 34-state information sharing program that allows states to obtain accurate information on voters who have died, moved out of state, or even the voters that may try to vote twice in the same election. While it's true that Texas might be able to negotiate individual data sharing agreements with each state in the country, experts widely agree that there is no program as robust as ERIC. In the handout, there's an article that goes extensively over why
it's a good idea to stay in ERIC. The ERIC system is complex, sophisticated, and took more than a decade to build and perfect it. It was further refined by experts who focused on this problem for a long time and really appreciate the complexity of understanding everything that's on the voter databases. It would not be an easy task to quickly create a robust, accurate, alternate system. Unfortunately, this means the public would be very worried about new systems that try to reproduce that. Analysis has shown that accurately matching and connecting names to ID duplicate voters, it's really difficult. And prior to the ERIC system, some states use some poor data and matching science and cause a lot of errors. ERIC figure out how to access the existing, oh, it's not my timer. ERIC figure out a way to utilize technology to cross-reference. I'm confused about the timing, sorry.
You have 15 seconds.
All right, so point is, ERIC is able to identify things like voter trying to vote twice, which is not available in any other system right now. So please, there's more information in the written testimony. Oppose this bill. ERIC helps with election integrity. Thank you.
Thank you, Doctor. Members, any questions? Thank you. The chair would just remind everybody, we've had now several substantive witnesses talk about ERIC and the positives and the negatives and that sort of thing, including the director, and we've also had the Secretary of State's representative, Ms. Atkins, talk about the details on that. While you do have 2 minutes to testify, and we want to hear from folks, I would like to just say that if you don't have anything new to add, let's just cut it off, so because we do have 18 more bills to hear this afternoon. The chair calls Stephanie Swanson.
Not here, but if you want to keep the call, please.
Okay, Stephanie Swanson, I show her as testifying on behalf of the League of Women Voters of Texas and herself, and she's registered as against HB 2809. The chair calls Lucy Traynor. Hey, good afternoon, Ms. Traynor. I show you as testifying on behalf of yourself, and you're for the bill. Is that all correct?
Yes, for the bill, Chairman.
Okay, go ahead.
Good afternoon, Chairman, members. A bipartisan coalition of states have pending lawsuits against ERIC, including Colorado, Wisconsin, Louisiana, Alaska, and D.C. Florida, West Virginia, Missouri, Alabama, and Louisiana have terminated their contract with ERIC. Furthermore, Iowa, and Ohio have also recently announced plans to leave ERIC. North Carolina refused to join due to privacy concerns. Texas must follow the lead of these states and stop wasting money on a program that violates our privacy. Given these costs of the membership agreement and the release of personally identifiable information to third parties, the Republican Party of Texas sees no value in continuing in this contract. Texas law already makes necessary updates to these voters at no cost. County registrars must get interstate and intrastate move address changes from the USPS at least monthly, according to Texas Election Code 15.022, and interstate moves are automatically updated when driver's license data is updated according to the Texas Election Code 20.062. In addition to the disturbing release of sensitive information to third parties, we are particularly concerned with the contractual requirement for Texas to reach out to eligible but unregistered voters. This goes far beyond the original scope of the cross-check program. ERIC provides each member state with this list of people that are not registered to vote, yet there is no ERIC mandate or requirement for member states to purge their voter rolls of the ineligible or illegal voters. States are encouraged, but not required, to request ERIC's voter updates at least once a year. So our question is, why are we paying for this type of money to a nonprofit with 3 employees, giving an extensive amount of personal information to third parties, only to have it be optional to remove now eligible registrants who were just required to reach out to per the contract. Thank you.
Members, any questions? No. Thank you, Ms. Trainer. The chair calls Jim Kovarik. Afternoon.
Hello.
Could you pronounce your name for me?
You did it good, Kovarik.
Did I? Okay, excellent. Yes,
I'm a
showed that-
retired software engineer.
Yeah, I show you're here on behalf of yourself and you're for the bill.
For it,
Is that
yeah.
correct?
Yes.
You go right ahead.
I've done a lot of consulting out at IBM on security systems. And I've also built a small identical system to Eric using their own software on my $200 desktop at home on a free version of Linux. Anybody can go to sensing.com and build their own version of Eric. You can also take advantage of, Omega 4 America. They have a full-blown system that they publish. It's on Amazon AWS, and you have full user access by any state employee. You have full control of the data you uploaded, unlike Eric. You transfer a huge data file to them, and you have no control over what Eric does with it. You can't verify that they installed it in their databases. You can't verify that they're hashing data because they don't give you access to audit your own data. There is no internet access to Texas data whatsoever. All you do is beg and plead for certain reports to come at you, and they send you a huge spreadsheet file, which you now have to deal with every item and overhead of that. And the reason states are pulling out of ERIC is the mandatory process of unregistered voters. What does that have to do with cleaning voter rolls? So I suspect the millions of dollars is used by the states in the overhead of contacting every single unregistered voter to get them registered.
Thanks, sir. Members, any questions? Yes, Chairman.
Thank you, Mr. Chairman. I was curious, because there's a bunch of different issues here, but if one of the issues is related to the fact that we're sending these postcards, either in Texas or in other states, and we heard that the postcards are essentially a hard-printed link to go, I guess, learn about the process or maybe get the online data. With the data that you said you did and that you've looked at with your software, I'm on Ubuntu.
No, I use the same basic entity resolution software that Eric uses.
Sure.
To build my own.
Well,
and you can get a lot of it on open source.
Sure. I'm an Ubuntu 22.04 person, right? So I love Linux. I can see how you can do that. But my question is, can you see if that's effective? In other words, if sending a postcard to a person to make them registered or unregistered, are you able to see if that actually is somehow getting unregistered, eligible but unregistered voters to register to vote? Is that actually doing anything?
I'm an individual. My guess is it's a waste of effort. ROI is just a disaster. Just what?
Right. I mean, that's what I'm trying to get at is whether Eric or anything else is worth it or not worth it. I guess if it was that easy to just get someone to register to vote by sending them a postcard,
Is it easy? With the data you upload to Eric, you could just install it in your own spreadsheet and figure out who's not registered.
Yeah.
And send out.
All right. I guess I'm just trying to see if you ever looked at whether they do end up registering to vote after.
Oh, no, my concern is what's the definition of cleaning the voter rolls?
Okay.
And
I'm
I'm
just
looking
curious.
at, what has that got to do with cleaning voter rolls?
Okay. All right. Got it. Thank you.
Members, any other questions? Thank you, Mr. Kovarik. Chair calls Mike Brewster. Afternoon, Mr. Brewster. I show you testifying on behalf of yourself. You're for HB 2809. Is that right?
That's correct. And I'll keep this brief. Basically, it's a very expensive program. It's an opaque program. We have no idea who's handling the data, what they're doing with it, can't see what's happening there. And by all indications, it's an ineffective program. Every place we look, we're finding problems with the voter registration rolls. And in fact, when I first started working on this issue, I had a improperly registered voter at my address. That's been about 2 years ago now. So these issues need to be done. We do have to have a cross-check program. It's not rocket science. We do criminal background checks. We do driver's license checks across state lines. This is something the state should be able to handle without a non-governmental organization being involved with it, and be open and transparent to the citizens of the state.
Thanks, sir. Members, any questions? Representative Morales.
I do. I'd like to hear from you if you think that ERIC can be improved rather than completely doing away with it.
The first reason, the first issue is the excessive cost. I mean, it's just a very costly program. And I don't have the numbers right in front of me, but the cost per voter registration is pretty extensive. The second thing is we have...
Let me stop you there because I like
Okay.
to take, right? So you're saying cost. Do you have an alternate program that you can tell us about it that actually you can show us that there's cost savings?
Actually, Mr. The name escapes me, the gentleman that was head of elections at Secretary of State's office has just been assigned a new position to look into options. There is one program that is available right now. It was produced by a doctor in Georgia, a medical doctor that did data involved in the medical field that turned some of his talents to elections. I believe that program's called Eagle AI. It's being previewed by a number of people now. So that is one alternative that would be available quickly. I actually think it would be possible for the state to develop a program. I mean, we check across states when we issue a new driver's license, we make sure that there's not a driver's license someplace else. That's something that's done routinely. It's not a difficult process. It's one that the states have not stepped up and developed to date. Instead, a non-governmental organization stepped into that role and was fulfilling that. But the other issue with ERIC is because of a variety of problems, there were 35 states in it to start with, and we've got states now dropping out of it. So the number of states that are involved is going down instead of up, and that's going to impact the effectiveness of the program. So it's a very expensive program that is becoming. I can't see that it was effective in the first place. It's probably going to be less effective as time goes on. And it's opaque. We don't really know what's going on with it. So why are we paying a bunch of money for a situation that we don't understand?
So you're saying, look at Eagle AI out of Georgia and see as a...
Now, I'm sorry?
Look at Eagle AI out of Georgia as
Eagle AI is the foremost solution that I'm aware of. There are two that are out there. The other one, the information I've seen from it, it's not going to be an effective program.
Are you aware Eagle AI depends on the number of states that are participating in order for it to be more accurate?
Eagle AI is also using some commercial resources and also is using the NCOA data. And I believe that they're tapped into the Social Security Administration's death data, and that'll come up in another bill here in a bit. Social Security Administration is pretty good at figuring out somebody's dead, because my mother died, and 3 days later, her Social Security check is was pulled out of the account.
And it's your understanding that ERIC does not use that data right now?
Is it my understanding that ERIC does not use that data? I really don't know. And the fact is that we find people on the voter rolls that have been gone for a number of years that are still on the voter rolls. So, and there are other laws that are in effect with this too. It's not only just the law that empowered Eric, but there are laws involved with getting people off the rolls that need to be improved as well. But this is a first step. I mean, it's a place that you have to begin. So I really can't tell you the answer to that. I know that there's an awful lot of people on the voter rolls today that have been dead for a long time.
I hear you. I understand that Eric uses the Social Security death data already, and so I'm wondering where the
The breakdown could be in a number of areas. As I say, there are other laws that have to do with voter registration in Texas that need to be revisited and looked at as well. Somebody mentioned postcards a minute ago. There's a number of processes that, once we've identified somebody's not in an address, actually getting them off the rolls is sometimes very difficult. But today we're just talking about this bill. So, even if they're using that information, it's not doing as much good because we're not getting rid of the people and we're paying them a lot of money. And I think the state can do it cheaper. I think Eagle AI can do it cheaper.
And okay, how many, I have a number of more questions. So,
okay.
Eagle AI, how many states are currently participating to your understanding?
Eagle AI, my understanding is at about 5 right now, and that's growing regularly. There are a number of people across the country that are looking at that process. And again, he's not relying just on state data to make his determinations. NCOA data, which is required in some cases in the Texas election code. But here again, this cross-check is a beginning. There are other things that need to be taken care of with the registration system as well.
And you would be okay with the state in-housing that if necessary in order to save money for it to be? That
would actually be my, this is a function of the state's election system, and a internal state process or a process similar to what we use for criminal background checks or driver's license would be my preferred solution. Right now, it looks like the first thing that is on the plate is Eagle AI, but I personally think that this is something that the states can work together to implement. It's not a terribly difficult issue.
Thank you, sir.
Thank you, members. Any other questions? Thank you, Mr. Brewster.
Appreciate it.
Appreciate you. Chair calls Cindy Davison. Good afternoon. I show you as being Cindy Davison testifying on behalf of yourself, and you're for the bill. Is that correct?
Yes, I am.
Go right ahead.
I'm testifying on behalf of myself, but the reason that I have such a strong opinion about the voter rolls is that I'm the chair of nominations for Travis County Republican Party. There are 270 unfilled precinct chairs, so I have spent a lot of time on the GOP database. And I was so appalled at some of the testimony I was hearing this morning that we left our lunch and came down for me to testify. Some of the things that I have found out, number one, a volunteer in Travis County has 98,000 challenges to the voters, and many of those are the NCOA, the National Change of Address. About 86,000 of those are NCOA issues. There are some where there's a 90-year-old registered at a sorority house. There's another dozen people over 65 at the same sorority house. I found a couple that had 2 men born in the same year with the same first name. And so I had to straighten that one out. I've found precinct chairs that are not listed in their own precinct, even though they're the precinct chair. And I could go on and on. So anybody that tells you that our voter rolls are the top of the nation, I don't know where they're coming from, but they're obviously not looking at what I'm looking at. And the other thing is that all you would have to do is take your child's high school directory. And I started going down the list of all the kids that had graduated in '97. And many of them are listed as living at their parents' house, and I know that a lot of them have been out of state for over 20 years. So our voter rolls are a disaster. And Eric has not been helpful, so it's definitely a waste of money in addition to the security issues, and I have an email sent, it says Texas has not applied OpenPGP encryption to this first data files, but will add this layer of security to subsequent data submissions. So the first information was sent to Eric without security, and that has been corroborated that much of our own information, yours, mine, all of ours, has been compromised. So I'm very concerned about the security issue as well as the financial issue.
Thank you, ma'am. Members, any questions? Representative Morrell.
And when you're talking about concern about the security issue, what specifically have you found that they have either breached or what type of litigation has resulted from that security?
Yeah, I think you probably heard the letter from the Missouri Attorney General saying that they're concerned with security also, but there's too much of our information being shared, and that doesn't have anything to do with our voter registration. So it goes, social security numbers or whatever it is that they're sharing, and they're sharing it with third parties. So it's going to this organization called SEER, and so they should not be sharing that information. That has nothing to do with our voter registration either.
So, but rather than completely eliminate it, don't you think that maybe reforms to that and making sure that we put...
We've looked into that, and absolutely not. It's from Mr. Kavarik, who set up the lab in his own living room. It's way too easy for Texas to do our own that covers everything we need to know for a small fraction of the cost, uses our own Texas people. We don't need to be going outside our state. We should really be the leaders. And I've been told that Texas is looked to as a leader in election integrity, and we need to step up to the plate and start leading instead of following. We don't need to wait for 5 more states to get out of ERIC. We should be taking the lead and showing them. In fact, I've had Florida asking me for Mr. Kavarik's information. I said, no, I want to share it with Texas first. And so I think we should be the ones that are leading the way in election integrity, not following.
Yeah. One of my concerns, and I guess one of the counters is that from what I've read, for example, is that privacy and sharing of that privacy, of that private information was one of the concerns as raised by, let's say, Florida was one of those states. But at the same time, Florida and these other states that are claiming that data privacy was an issue, they themselves entered into an agreement with ERIC and the other states as to what that privacy and what parameters were going to be put in place in ERIC. So it's like you can't have the states agree to a set of parameters in place and then call those parameters and those checks and balances that they put for data privacy as an issue when they agreed to.
Oh, that has been, you just hit the nail on the head. That's exactly one of our concerns. Who in the world signed this contract?
It was the states.
Yeah.
And so
we have no idea from looking at the contract. Mr. Kavarik is an expert on that one. You can ask him all day long. But he has trained me from day one. It's like, who in the world would have signed this?
Yeah. And I'd like to visit with him some more.
Okay.
We can do it a lot cheaper and also make sure that we address the privacy issues and make sure that we're receiving accurate data. I'm still not sure from what I've heard whether this is an ERIC issue or whether it's our laws that we need to modify to make sure that these changes take place as our previous witness testified, or if we need to do something else. Let's say we are sending that data to the county registrars at the county level, but they're not implementing it fast enough.
Right.
Or they're just leaving it there and somebody's dead.
Well, one of the things that Jim has trained me in, all of us know what an interface is and where we go to our bank account and you log in and you put your password in, whether it's your health information or your bank account. He said that should have been the first red flag, is that it should have been real time. And that should have been obvious from the get-go. For having to send for a report and wait 30 days to get a report back from ERIC is ridiculous. So you should be able to determine when that person comes to vote, you look up on your database and determine whether or not they're registered to vote. There shouldn't be any 30-day report business going on. So that was the other portion of that. But yeah, he's much more of an expert on that aspect. I can just tell you my experience from looking at the voter rolls, and I've worked elections from the 90s, and we always knew dead people were voting, but there's still, our son was on for 20 years trying to get him off. And part of that was during ERIC. So ERIC didn't improve it any when we were still trying to get him off the roll.
And in this scenario, was your son registered in another county or another state?
Yes, Yes, actually, he's been voting in California. He graduated from high school in '97, and he moved to California to go to school at Pepperdine. It's 2023, and we only got him off, I think, 2 years ago. So, and he had sent in, you have to send in your own signature, so there's all kinds of stipulations. It takes 4 years to get off the voter roll. They have, there's lots I could tell you. But yeah, it takes you 4 years. You have to go through another election. And so he sent his own card in, signed it, made sure that that was done because we tried to get him off. That doesn't work. You have to have him sign it in. It still didn't work. So it took 20 years to get him off the voter roll.
Thank you, Miss. Appreciate it.
Thank you, ma'am. Any other questions? Is there anyone else who wishes to testify on for or against House Bill 2809? If not, yeah, we did. Yeah. The chair closes House Bill 2809. Anyone have any questions of me? That's good. If there is no objection, House Bill 2809 will be left pending. If there is no objection, House Bill 2809 is left pending. At this time, the chair lays out House Bill 1671 and recognizes Representative Jeton to explain the bill.
Thank you, Mr. Chairman. Members, I'm here to lay out House Bill 1671, which allows candidates to recover damages and penalties against an individual who engages in vote harvesting services. While significant steps were taken last session to make vote harvesting illegal and impose criminal penalties, Texas statute does not currently provide a civil remedy for vote harvesting. This bill will further discourage the practice of vote harvesting in Texas. At this time, I'm willing to answer any questions. Otherwise, reserve the right to close.
Members, any questions of Representative Jeton? Thank you. At this time, the chair calls Alan Vera. You are Alan Vera. You're here on behalf of the Harris County Republican Party Ballot Security Committee, and you're for the bill. Is that correct?
That's correct.
Go right ahead.
Unfortunately, ballot harvesting is prevalent in Harris County in every primary election and every general election of an even-numbered year. We've been investigating, gathering evidence, and pursuing criminal charges for these offenses for the last 5 years. The county DA won't pursue criminal charges for vote harvesting because she's one of the candidates who pays ballot harvesters. We provided those documents to Reps. Morales and Diala at their request. The Texas AG can't prosecute ballot harvesters because the Court of Criminal Appeals has removed that power from him. The bill finally gives candidates a viable option to deter and or punish proven ballot harvesters in civil courts. It's reasonable. It has guardrails. It's actionable. It's a good remedy for a frustrating problem. Members, the person who got us started investigating ballot harvesting in Harris County was a Democrat candidate in the 2018 primary election. He lost by a very slim margin, all attributable to harvested mail ballots. He recorded a phone call he had with the person who led the harvesting efforts for his opponent. She explained openly exactly how she harvested the ballots and how she was paid. The Democrat candidate sent us the audio of that and asked us to please find a way to fix this problem. This bill's a very big step forward to stop ballot harvesting. We urge the committee to report HB 1671 favorably to the full House. Thank you.
The chair recognizes that Vice Chair Busey is with us. Members, any questions for, yes, Representative Mann.
Who was this person who said that there was ballot harvesting and recorded this conversation?
It was a Democrat candidate for a judicial position.
And you can't state who that person's name is? They didn't...
I don't remember it anymore.
Okay, thank you.
Any other questions, members? Thank you, Mr. Vera. The chair calls Ken Moore. You are Ken Moore. You're here testifying on behalf of yourself and you're for the bill. Is that correct?
That is correct.
Go right ahead.
Okay. This bill defines the offense of ballot harvesting. It defines harm to the complainant. It provides for recovery of expenses caused by the offense of the outcome. Traditionally, many criminal courts have been very reluctant to address these things unless they can prove that the offense affected the outcome of the election. In this case, though, this bill, in its own words, a person is harmed by the vote harvesting services if the person can demonstrate that the person was a candidate for office, the liable party committed an offense under Section 276015, and another candidate seeking the same office as the person received the vote attributed to the offense. If the plaintiff can establish harm under this criteria, he is entitled to compensation paid to the harvester and his legal expenses. If he can go further and prove that the number of people that the harvester contacted was greater than the margin of victory for his opponent, but he can also recover his campaign expenses. This bill has teeth. It gives candidates opportunity. It gives an alternative to the courts, the criminal courts, to recover expenses in its campaigns. It's a good bill. I urge you to pass it.
Thanks, sir. Members, any questions? Thank you. The chair calls Robert Green. Mr. Green, I show you testifying on behalf of the Travis County Republican Party Election Integrity Committee for Legislation and yourself, and you're for the bill. Is that correct?
Yes, sir, that's correct.
Go right ahead.
Again, I'll repeat a simple statement that applies to every bill that would increase penalties for significant violations of the election code. Without significant penalties for serious violations, what benefit is any law? We must have penalties that provide a serious deterrence for those who would try to manipulate or cheat in the system. This is a pathway to do it. It's another method to deter, I hope, people who would go out and vote harvest and try to affect the vote totals. Until there are so many very, very close elections, and this happens a number of times. So if you have any questions, I'll be happy to answer them.
Thank you, sir. Members, any questions? Thank you.
Thank you.
Michael Belsick. Michael Belsick. Michael Belsick, I show him as testifying on behalf of himself and for the bill, and he's not here to testify. Ed Johnson. I knew he was here.
Yes.
It's good to see you, Mr. Johnson. You are Ed Johnson.
I was hiding in the back also.
Yeah. You're Ed Johnson, you're here on behalf of yourself and you're for the bill, is that correct?
That is correct.
Go right ahead.
Okay, you heard earlier in Alan Vera's testimony about recording of a candidate that came with vote harvesting. Let me explain how we saw this work when I was working in Harris County elections. Vote harvesters will go out and gather up ballots from different areas, communities, to the tune of about 300, 400, 500. And then during a primary is when they actually probably make their most of their money. They will go down the ballot to all the contested races and call the candidates and say, hey, I've got 500 ballots. What is it worth to you? And then they go and get each race a candidate that's paying them, and they check it off. How I know all this is after the primary is over with, the guy that didn't pay him and came in second place comes yelling and screaming to the office going, you know, they cheated. This is what they did. We had vote harvesters in here, and they called me, and they were trying to get me to pay for ballots and stuff. And we would report that to the DA. We report that to the AG, and unfortunately, as other times you've heard, it doesn't go anywhere because those are elected officials that don't want to get involved in election contest. This bill would give a candidate the ability, when they're cheated like that, to seek reparations. We had numerous recordings of phone calls from candidates where they had recorded the vote harvester asking them for monetary value for the number of ballots they were carrying.
Representative Busey.
Thank you, Mr. Chairman. Just wanted to follow up on that, just so we could get some more specifics when we're with Bill Author on it. What election cycles did that happen?
It happened about just every primary. 2018 was when it happened the most when I was there. That was the last year I was there. But at 16, 14, we had reports.
Republican and Democrat, or just one primary over the other, you're hearing this?
99% were in the Democratic primary.
In 2018?
Yes.
Do you know, can you share any of the candidates?
I don't remember, I'm sorry, I don't remember the candidates right off the bat's names.
Okay.
One of them, the one that they were talking about, the recording was for a JP race. I think it was JP 9 in Harris County.
Do y'all still have these recordings?
Huh?
Do y'all still have these recordings?
The election office has them. At least they were there when I left.
I appreciate it. Thank you.
Representative Manuel?
So you're saying that Harris County Elections Office has evidence of actual criminal activity that has not been turned over?
No, it was turned over to the DA's office, and the DA's office.
And it hasn't been turned over to the Attorney General's office?
It was turned over to the Attorney General's office. It was turned over to the FBI. It was turned over to just about any law enforcement agency that we could report it to.
And so neither of these?
No one ever pursued it.
So the FBI, the AG's office, the DA's office, local police office, all?
Local police office wouldn't have it. You'd go.
Okay, but I'm saying all forms of law enforcement that you're stating, they all
Yeah, three.
have been
There are three.
received this
FBI,
information?
AG, and the county DA.
And they haven't brought prosecution on people committing crimes, even though there are, and I'm going to use Harris County because you all love to use Harris County, even though there are actual cases that happened of election fraud in a current representative's district in Houston, Representative Harold Dutton, where there were 2-3 people prosecuted for election crimes since 2020 in the 2020 primary.
Mm-hmm.
But those crimes have not been prosecuted.
In 2018, they were not prosecuted.
Or in 2023 or 2022.
Well, I don't know about 2023 or 2022. I was not in the office at the time.
Okay. But the one that was in 2020, it took less than a year for these 3 people to be prosecuted for election fraud cases.
Okay.
No, I'm asking because, I'm saying
follow that case.
you're citing elections in Harris County, and I'm giving an example of an actual crime that the governor has talked about, that there are 3 people that have been prosecuted for election crimes. And that took less than a year, but these cases are in 2018, and it still hasn't, that you know of before you left. Those are still out there in the ether waiting for.
Yes, they were never were prosecuted.
Thank you so much.
Yes, Representative Morales.
I know you've been here, but you represent the Republican Party, right? Or just self?
Myself.
Okay. I'm wondering if 99% of it happens in Democratic primaries, why the concern of bringing up the Democratic primaries?
I'm here for myself because I don't think election fraud's right. I don't care which party it's in.
Let's say it happens.
And it happens a lot in the Democratic Party on the primary with these vote harvesters, and it's not right. Something should be done about this, and it's really not fair to the candidates that are doing this. That's why this is a good bill. It gives the candidates some avenue to pursue this.
It would seem to me the Democratic Party then is, by allowing this, allegedly allowing this, then they're putting up the wrong candidate that really doesn't have the support of the constituency, but more so of these individuals, rigging the system. And then, therefore, it would make it probably easier for the Republican candidate to get elected in the general election because you don't really have the constituency's support.
Possibly so. I mean, I don't know that the Democratic Party is involved in this. These are vote harvesters that are out to make a buck.
No. So. And let's talk now about that, because I'm looking at the election code, and it's something that hit me, and even from the last legislative session, I thought that we already had laws in place that would make it illegal for these folks to actually have those and to claim that they had X amount of number of them and that they could generate them. Is it your understanding that they're actually holding on to 500?
The three recordings from 2018 that I heard, phone recordings, yes. One had 500 ballots they were claiming to have. The other one had 300 ballots, and I don't remember what the third one was, the quantity. But yes, they said they had those ballots.
Okay. And so these were phone conversations that were recorded?
Correct.
So, and if I tried to use that recorded, unless an attorney was able to use one of the exceptions to the hearsay rule, that would be considered hearsay and would not be allowed to come into a courtroom. You understand that process,
Yes.
right? So and the reason being is that's not enough, right? We actually need the tangible evidence to support the contentions being alleged. And so I'm wondering if that information was forwarded, are you aware of an actual criminal investigation took place?
This is probably why these never take place, is just because the evidence is what you talked about, the tangible evidence here.
Yeah.
You know, that's why a DA is not going to get involved in a political battle that would possibly hurt him in his next primary race over tangible evidence. So.
Well, and that, or the person could just be lying to try to make a buck. And so it's really, I mean, they could be telling you I have 1,000, but they really don't. They just wanted to.
Very possibly. Yeah, it could be a fraud case that they're extorting money out of.
Okay, and if that's the case, that's my concern. And not really extorting. I get when I started running now for, I get approached there at my tortilla factory back home, and then when I'm trying to talk to my customers, and I'll get approached sometime like, hey man, I can help you, and I've got so many people that I know, and I'll be able to be good for at least 100 votes because these people all count on me and stuff, and it's like.
But I can tell you that's probably not the truth. This is all circumstantial evidence, but it all adds up. The particular case that Alan Vera was talking about, where he had the recording, we were able to, in the office, go back and find the applications in this particular race. And it happened to be there were about 300 applications that all had the same postage stamp and the same similar handwriting on them. And it wasn't a normal flag postage stamp. It was a gingerbread stamp from Christmas.
Yeah.
So it was very peculiar. Then, unfortunately, to get to the actual ballots to look at them took 2 years, because you had to wait the 22 months before you can unlock the box to look at them, according to law. So at that point in time, able to look at them, all these ballots were voted exactly for these applications, exactly for that candidate that supposedly bought those votes.
And so
that's pretty circumstantial evidence.
And so that information was forwarded to an investigating agency, and nothing came from it? The AG, the local DA, and the FBI, and...
I don't know if it was sent to the FBI on that one, but I'm pretty sure it was sent to the DA's office. Yes.
Wow. Okay. Thank you, sir.
Okay.
Members, any other questions? Mr. Johnson, thank you.
Thank you.
Very much. Is there anyone else who wishes to testify on, for, or against House Bill 1671? Do we have somebody? Thank you. Remind me your name?
Andrew Hendrickson with the ACLU of Texas.
Hold on just one second.
I didn't register to testify on just a couple of points I wanted to make sure raised.
Did you register to not testify?
I registered to not testify, but I am
You said your last name was?
Hendrickson.
Hendrickson.
Andrew, ACLU, Texas.
That's the one.
You are Andrew Hendrickson. You're here testifying on behalf of the ACLU of Texas, and you're against the bill. Is that all correct?
Correct.
Okay. Thank you. Go ahead.
I just wanted to flag a couple of issues that caused us to oppose this bill, namely the large burden that it would place on the civil court system and the disproportionate penalties provisions in the bill. So the way the bill is structured right now, there would be a cause of action created for every candidate who wasn't voted for on a harvested ballot, a quote-unquote harvested ballot. That would amount to I just picked a random precinct in Harris County, sort of dropped a pin, ended up being precinct 19, and looked at how many races that would impact and how many candidates that would impact. In that precinct alone, a single harvested ballot would give 96 candidates rise to have individual causes of action. Each one of them would owe a minimum of a $25,000 penalty to each one of those candidates, which amounts to $2.4 million in civil damages, which is 2,400 times more than the greatest criminal fine that we can levy under any felony provision of the criminal code. And on top of that, you would also owe attorney's fees, litigation costs. When you talk about the punitive damages section, you're talking about all of the campaign expenditures. Proving that punitive damages exception, proving that your race was actually impacted by a claim of harvesting, probably take more time. In that instance, you would have 95 candidates who would probably be able to file their cases and resolve them faster. 2.375 million is likely to bankrupt anyone involved in any of these activities, meaning that the impacted candidate would be very unlikely to collect in any case.
Vice Chair Beasley.
Thank you, Mr. Chairman. Can you expand on that? So you're saying because anyone on the ballot would have this cause as this bill is written?
That's right. So in that precinct, there were 80 races with 176 candidates. So if the ballot was fully filled out, all 96 candidates who weren't voted for on that ballot would have a cause of action under this bill that would allow them to collect the amount of any service, the fair market value or the compensation plus the $25,000 received by the person who was allegedly harvested the ballot, plus the $25,000 penalty, plus attorney's costs and filing fees, and that is for the candidates who are not showing any actual harm from the activity. Those are just for candidates who were not selected on the ballot. I would also point out that 79 other candidates who won those races, who may have had no connection to any of the harvesting activities, would not have a cause of action simply because someone who, if one of the candidates paid a quote-unquote harvester to, which again, we have our own reservations about whether any of this activity, I just want to reserve that this activity is taking place, how frequent it is, and whether the definitions in the bill that was filed, that was defined last session were problematic. But you'd have 79 other candidates who had nothing to do with this, who wouldn't have a cause of action, just because the rest of the ballot was randomly filled out.
Is there a way that you've thought through that maybe this bill could be cleaned up to make sure that that's not happening, or is there?
Given that we are in litigation regarding the definition of vote harvesting from SB1, we'd prefer not to, weigh in on any way in which we would potentially approve that section of the bill. We don't think that the definition is valid and we have some issues with it. So.
Sure. Well, no, I think it's a fair point. I would be happy to try to work with the bill author. Thank you.
Thank you.
Thanks, sir. Members, any other questions? All right.
Sorry.
Oh, I'm sorry. Representative Manuel. Yeah, y'all don't run off just yet.
So I guess I'm going to ask this question. If you don't think it's appropriate or you can, please just let me know. Does it seem to you that this is a bill that is, how can I put this, that this is something that a court would consider hearsay, that we are now looking to create legislation off of something that would not be able to be passed in a court system because there is not sufficient evidence of these quote-unquote crimes?
I think if you're putting aside our issues with that, and reserving that we have issues with the criminal penalty, but that if this, were to go forward, the allegations of vote harvesting here would be in a civil court, which does have a lower burden of proof. So even if the criminal case is not successful, you'd have a lower burden of proof. It wouldn't be beyond a reasonable doubt in the civil case, which creates a new avenue, I think, for folks to create doubt, sow doubt in the validity of election outcomes, and to do so in a court where the standard of review, the burden of proof is substantially lower than it would be in a criminal case.
Okay, and then this is a question, and I hate to be that person, but I'm just going to say this, I'm the only black person, African American on this committee. This is something that's important to me. The vast majority of claims of ballot harvesting, are they predominantly being made in areas that are high in frequency in people who are black and brown?
Without commenting specifically on vote harvesting, we have done some studies that show that election crimes, generally speaking, tend to be prosecuted at a higher level against communities of color, yes.
Okay, so prosecuted. Now, I know we've heard this before, based off of convictions, though, are those convictions, like let's say there's 300 prosecutions, how many of those turn into, let's say, convictions? Would it be 100% rate, 50% rate, 30% rate, 2% rate that you know of? If you don't, that's completely understandable.
I don't want to quote a number off the cuff. I know that, a lot of very rarely do investigations or claims that are filed by the public result in actual convictions, but I don't want to quote a statistic without having, numbers in front of me.
Perfect. So in your opinion, would you say that this would put black and brown communities and candidates specifically in situations where they would end up owing money based off of a claim that someone has made?
I think there's a possibility that a situation like that could arise in so much as if the allegation can't be proved in criminal court, there's still very, very substantial penalties. I mean, even if it's just a single candidate who is suing somebody, but the candidate themselves, of course, not being, depending on how the situation is structured, as far as I understand the bill, it's the vote harvesting service provider and not the candidate who would be liable for these the civil penalties that the civil penalties that are levied by the bill. But I do think there is some possibility of using this to call into question the results of the validity of the outcome of an election. Potentially a candidate of color, because the case can't actually be, because a conviction cannot be secured in a criminal court beyond a reasonable doubt.
Okay, thank you so much.
Of course.
Representative Dayella.
Just a quick follow-up. Just starting from a kind of a foundation, election misconduct happens. Whether it happens a lot or a very, very little bit, it happens. I think that's not disputed by most folks. And I think what's also a truism is that there are few prosecutions criminally of election violations. Fair statement?
I think those are sort of, without putting numbers to those terms, right. I don't feel necessarily comfortable weighing in sort of a non-fact-based way, without having literal statistics to look at it.
In recent past that you're aware, I'm just trying to get this understanding that when it comes to prosecution of election code violations, criminal violations, whether the violations are occurring maybe minimal, the prosecutions are the things that we can measure because they're public. But we know from prosecutions, they're not very many, at least in recent years in Texas that you're aware of. Pretty true statement, right?
Not many is, again, not a assertion I'm comfortable making when it is in fact a knowable number, and I don't have those statistics in front of me.
Okay. Well, then let me move on. I thought this was going to be a lot simpler. But true or false that the very nature of an election crime is difficult to prove based on our criminal system. It's a difficult thing to prove. Would you
Fact specific and depends on the crime. There are close to 100 different criminal violations in our election code, and all of them have different burdens of proof and different, elements that have to be proven. So
let's focus on ballot harvesting then for a moment. But the ballot
that's what I'm really not going to be comfortable commenting on, given that we have ongoing litigation regarding that provision of the law.
So I have last thing I want to do is make you uncomfortable, and so I just want to see kind of where you were. You seem to have some knowledge on it. I just wanted to get some of that information from you, so I'll stop there. Thank you, though, for your time.
Absolutely.
Members, any other questions? Thank you. All right, appreciate you. Is there anyone else who wishes to testify on, for, or against House Bill 1671? If not, the chair recognizes Representative Jatan to close on his bill.
Thank you, Chairman. Members, I know you have a long agenda today, so I'll keep it short. Appreciate the opportunity to lay out this bill. Happy to answer any questions. Otherwise, I close.
Thank you, sir. Members, any questions? Representative Jatan? Thank you.
Thank you.
If there is no objection, House Bill 1671 will be left pending. Chair hears none. House Bill 1671 is left pending. The chair lays out House Bill 453 and recognizes Representative Schofield to explain the bill. Hello, Representative.
Mr. Chairman, members, good afternoon. I missed this committee. I enjoyed being on it, and I tried to come talk to you earlier, but it's hard to get in front of you all.
It's good to see you now.
House Bill 453 is a very simple bill. As most of you are aware, particularly in this committee, Chapter 43 of the Election Code requires any public building or the owner of the public building to make it available for elections. Predominantly, they do. We have occasionally had some schools that don't want to hold elections in their school facility on the grounds that having the public come in during the day is unsafe for their students. Therefore, I filed this bill to say if they claim that, and it's illegal to say you can't have an election there, but if they're going to say we don't want to have an election in our building because it's unsafe for the students to have the public come in, then they can't have school board trustee and bond elections in the same building for the next 5 years for the same reason. So it's really very simple. If you really feel that you can't follow the law because of safety, then if it's not safe for the general public to come in to vote for state representative, it's not safe for the general public to come into the same building to vote on their bond. If there are any witnesses, I'd be happy to hear from them. In the meantime, if any of you all have any questions, I'd be delighted.
Yeah, Representative Morales.
Rep, are you saying now it's illegal for them to say no? Now?
Yes. Under, it is Section 43.031C of the Election Code. This would add a new subsection F. Subsection C, and I'll just read it to you, it's 2 sentences, or the relevant part is 2 sentences. The building selected for a polling place shall be a public building if practicable. The entity that owns or controls a public building shall make the building available for use as a polling place in any election that covers the territory in which the building is located. So it could be, it could be a general election for state and county election officers. It could be the school board election. It could be a bond election that the county puts up for flood control, anything. And that's, and again, in general, and again, it doesn't just apply to schools, it applies to any public building. The idea being if the taxpayers have paid for the building, then we should be able to hold elections in it.
So if they already cannot say no to a request that we hold early vote or election day, voting in those public buildings, why do you feel it necessary that we need to carve out an exception for them?
We have had some that said, we're not doing it anyway, sue us. We can't wait to say we're going to protect the students against the terrible voters, which is great, except we could not find a single instance in the history of Texas where a child was harmed by a voter or anybody else on election day at a school. So we just wanted to kind of make clear, rather than just, which we did, we sent a letter saying this is what the law says, and in good faith, the school did read the letter and said, okay, we're going to have the elections. But I just want to point out that y'all didn't seem to mind when the public was coming in to vote on your school bond.
Yeah.
And that's basically the point of the bill.
Do you know if the current law provides for, if a lawsuit were to have to take place in order to either have a declaratory judgment or some sort of restraining order so that voting can take place there, if it allows for legal fees and costs of court to be recovered by the, I guess, the county election?
The answer to that is we have a chapter in the Civil Practice and Remedies Code that lists those few instances in which we allow attorney's fees, and this is not one of them. We've never had to go so far as litigation. Typically what will happen, though, it does happen. There are times when the district says we're not doing it. Usually the county finds another building if they can. As you know, a voting location is, particularly for those places that don't have countywide voting, is supposed to be in the precinct. And we have had occasionally some precinct lines drawn real funky to make sure there's at least one government building in the precinct. I mean, a line will go outside the precinct to grab a building. So by and large, the county will do the best they can. And sometimes there are other reasons why you can't use a building this time. The Harris County Library Katy branch, where they always have voting, didn't have voting in the primary in 2022 because the HVAC unit went down. And they said it's going to be 6 weeks of no air conditioning in Katy, Texas, which is a bad idea. So the county found an alternate venue. But our view was just want to remind the school, if you don't think the public is good to come in there when they're voting for state rep, they're not good to come in there to vote for your bond either.
Wayne, in drafting this, that you consider also modifying to allow for the recovery of legal fees and cost of court? And if you did, why did you decide not to modify that?
I hadn't thought about that, and I will tell you, and again, the chairman knows as a practicing litigator, there are very few instances in Texas in which we allow attorney's fees. The vast predominance are in breach of contract cases because the attorney's fees that you would eat up are actually part of the damages. In other words, if you're out $100,000 and you got to spend $30,000 in legal fees, if you get $100,000, you're never getting $100,000, you're getting 70. And so we have several instances, but not very many. It is not. It is a good point, and if I'd have thought of it, I probably would have done that. But it's not something that we typically do. It's better to avoid the litigation than to figure out how to pay the lawyers. And I'm a lawyer, but I'll still tell you that.
Yeah, but and as a lawyer, I sometimes find that whenever you're ever to craft the letter and include that a particular section provides for the recovery of legal fees and costs of court, it seems to drive the point just a little bit more. So we'll have these conversations, and maybe it's something that we can discuss as a possible amendment. I like your bill, but I think if we can add even more teeth to it, and in the event that there's folks that just really want to be difficult with the elections administrators, we have that recourse.
I appreciate it. Thank you.
Representative Dayala.
Just real quick. It's my understanding there's also a timing issue. You can't get it adjudicated in a court in time for the election based on posting of polling locations.
Well, theoretically, if you file for a TRO, you could have it done pretty quickly. But yet, particularly in our county, our shared county, where you're talking about 800 polling locations,
This
having to
committee
run
isn't
down all those
familiar with
traps.
Harris County. If you could let them.
Yeah, by the way, one thing I should have mentioned to those of you who are new to this committee, welcome to Harris County. And Bob Bullock used to say when he presided over the Texas Senate, when something like that would come up, he would say, the Texas Senate will adjourn and the Houston City Council will now come to order.
Representative Busey.
Just a quick question, and I'm sorry if you addressed this in your layout. I mean, I'm leaning in support of this. We need our schools to be voting sites. Is there any, and again, I apologize, is there any like process if someone had a good cause for why they couldn't specifically be open one of these election cycles to like challenge this, review it, so they don't lose it for the next 5 years?
Typically, you're talking about under my bill or under current law?
Under your bill, like what if is there like a appeal process where they can say, well, we can't do this cycle because of X? I don't know what that would be. I'm just curious.
No, and again, currently they're not allowed to deny the ability to use it. That's a different situation from calling the county and going, again, we don't have any air, or, our water, we had a leak with the water and there's no water.
You're talking about like when an excuse is given to shut it down.
Yeah, we're talking about a denial of service, not a, and
What if there is a leak and they can show it? Is there any good cause to challenge this in the future?
The language that I have in here is fails to make the building available in accordance with subsection C. And subsection C says shall make the building available for use as an election in any election that covers a territory. We have never, to my knowledge, and again, I'm from Harris County where this kind of stuff blows up, we've never had anybody go that far where they've had to tell them, other than us having to send a letter. It was actually, I think, Senator Betancourt's office that said, you have to do this. Typically speaking, if they go, look, it's a real problem, they'll find somewhere else to go that cycle. They prefer not to, as you can imagine. If we always vote at Nottingham Elementary, the voters know where it is, they know where the election is. They prefer not to. But if Nottingham Elementary has a plumbing problem and they don't have any water during a good chunk of early voting, then the county will go, okay, well, what else can I find?
I guess that's all I'm making sure is that we don't have an unintended consequence for a legitimate issue.
But I mean, I can't imagine any of our counties going, what, you had no air conditioning, no election for you for 5 years. I mean, that's not going to upset them enough to get them to do that. But if you think some language to that effect would be useful, that would be perfectly fine with me.
Thank you, Mr. Chairman.
Any other questions? Thank you, Representative Schofield. We have a few witnesses. I think it's a fairly straightforward bill. We can keep our comments fairly short. The chair calls Alan Vera. You're Alan Vera. You're here on behalf of the Harris County Republican Party Ballot Security Committee, and you're for the bill. Is that correct?
That's correct.
Go right ahead.
We support the bill. You've heard all the reasons and circumstances that made it necessary. Only one provision we wish might be considered for the bill. If the schools decide to ignore the requirement to host elections, and then they choose to ignore the penalty of not being allowed to use that school for their own bond elections, maybe we could add that no ballots cast at those facilities can be counted in the school bond election. We support that. Even without that additional stipulation, the bill's a good step forward. We urge you to report it favorably to the full House. Thank you.
Thank you, Mr. Vera. Thank you very much. No questions for him. We go to Robert Green. Afternoon, almost evening, Mr. Green. You are Robert Green. You're here on behalf of the Travis County Republican Party Election Integrity Committee for Legislation, and yourself, and you're for the bill. That's correct?
That is all correct, sir.
Go right ahead.
Just make a short statement. School districts should not be allowed to play games with polling places by allowing elections for their board of trustees or for bond elections, but not allow them to be used as a polling location for a general election. The proposed penalty for doing so should deter districts from violating this new provision of the election code. And to address one of the statements that was made earlier, I think that the elections folks would likely decline to use that facility if something major came up, like a loss of power, loss of AC, or big-time water leak or something that I think they would just voluntarily say, hey, never mind, and we'll go on. But if you have any questions, I'll be happy to answer them.
Thank you, Mr. Green. No
Thank
questions.
you.
Appreciate it. The chair calls Ed Johnson. Ed, you're here on behalf of yourself and you're for the bill. Is that all correct?
That is correct.
You go right ahead.
Okay, start with, I think, an answer Representative Morales' question. So if you read on further down in section 42, there's actually a list of requirements that are by the state for a polling location. Accessibility problems. You have to have parking. You have to have, accessible doors that are easily opened. You have to have, water, power. You have to have all these elements. So if a school or facility for some reason didn't have those, it would not be an eligible polling location under this code. And that does exempt the school from possibly being, targeted on this. So it's actually, already, it's not spelled out directly how you said it, but due to ADA requirements, that facility would not be usable during that election. So now this was a problem in Harris County, numerous elections, particularly Representative Schofield's district in Katy. I remember an election, we had 2 elementary schools that were nice facilities, ADA compliant new schools, and they said, no, we don't want to, let you use them. Our county commissioners found a better solution. They called up the superintendent and said, well, you're building a new high school over there. Yeah, we are. He said, well, do you want a road to that school? And they said, well, we think we do. And all of a sudden those schools became available. But I don't know if you can put that in the election code or not. So, this is a problem. This would be a little teeth into it where they can't just say no. Another interesting little Google fact that you can look is Google the number of, voters have harassed students in Texas, and the answer is 0. You can Google a number of teachers that have harassed kids, and you get pages and pages. So maybe we need voters in the school to monitor the teachers.
Very good. Members, any questions? Thank you, Mr. Johnson.
Thank you.
The chair calls Dr. Susana Carranza. You are testifying on behalf of yourself and you're against the bill, is that all correct?
Yes, and I get the intent of the bill, but there is a problem that I didn't see anybody mention, is that in some places, including in Austin, the elections for school board, bonds, and everything, it's all in the general election. And there is no, like this bill would apply to, like if for some reason one school 1 year for, had a bad administrator at that year stays out of the general election, the way the bill is written, it would prevent that place to being a place for future elections. And since in the city of Austin, the bond elections, the school board elections are at the same time as the general elections, you're essentially making that place not a polling place for 5 years because somebody sometime decided not. So that's it's a different scenario than from schools that have, or districts that have their school elections in May at a separate time than the general election. So that's why I oppose this bill.
Members, any questions?
I'd just like to clear up on that issue, that the way I read this, it's the school district. So my understanding would be that it would be a board as a whole, not one individual administrator or rogue administrator making that decision.
Yeah, but it's not super relevant who makes the decision. What's relevant is that if it's in a place where the elections for school boards, like in Austin, our school board elections, our bond elections are in the same time as the November election, as the general election. So that would cause all elections to be banned for 5 years from that place, including all the next general elections. So you wouldn't be having a carrot, like a stick just against the school board elections, but it would kind of eliminate all the elections in that school for 5 years, because you can't separate them. You can't have a place that had, like in Austin, you can't have a place that votes only one thing. You can't separate them out, because our school board elections are in November. They're with the general election. Does that?
No.
Like in Austin.
I mean, I hear you.
Yeah.
I don't agree with you.
Okay.
It's the only thing, because again, it has to be, a rogue administrator is not making that decision. You have an electorate body that has to answer to their constituency that would have to make that decision of saying no, knowing that there is a consequence to that action. And then also, let's say we have a rogue board that decides on a 4-3 vote, let's say, and by the next election cycle, it changes. If we need to, I can visit with with Representative Schofield, but I know that his intentions are well from the way I understand it. And if the next year the board decides, no, come back, we can offer the place here, that does away with a 5-year ban.
No, that's the thing. That's the point. It doesn't. The 5-year ban, like if the board says 1 year, let's say a rogue board says 1 year we're not going, that place cannot be a polling place for 5 years. And that, for me, is the problem, because especially in a place that has all the elections at the same time.
And I hear you on that, and I think that we can come up with a solution to that, to clarify that.
Yeah, and that's...
If a succeeding board comes and makes a different decision and allows for their public, building to be used, that it does away with the issue.
Yeah, maybe something like if cannot allow for exclusive, like elections that are exclusive for only board. Like, so maybe some change in the language that would make it clear that if that place holds all types of elections, it wouldn't apply. I don't know. But that's the problem that I see, that specifically applies for places that hold board elections in November.
Thank you, Doctor.
Thank you.
Members, any other questions? Thank you, Dr. Carranza. The chair calls Kathy Hagler. Ms. Hagler, I show you as testifying on behalf of yourself and for the bill. Is that correct?
Yes, sir.
Go ahead.
I think almost everything I was going to say has already been said, but I do want to point out voters beg for consistency in their polling places. They do not want to vote at the church one time and vote at the library the next time and then vote at the school next time. They want to know that every time there's an election, I'm going to go vote at this one place. So either do it all the time or don't do it all the time. Just let the voters go to the same place every time. That's all I'm asking.
Members, any
I think this helps with consistency.
Any questions? Thank you, Ms. Hagler. Appreciate that. The chair calls Christina Atkins. We have our favorite resource witness here, Christina Atkins. You're here on behalf of the Texas Secretary of State, and you are on the bill. Is that correct?
Yes, sir.
Members have any questions? Representative May.
Our unnamed plated member of the committee. I have a quick question, and maybe because I just want to get clarification. Let's say, for instance, and I'm going to use that example, you have a rogue board, let's say it's 4-3, the vote, and then, there's another election. I know some are every 2 years, some are 3. If this new board comes in and they say, or even the same board come in and they say, we fixed the problems or whatever was the issue, under this bill, would they still be under a 5-year ban, or would they be able to show that, they fixed whatever the issue is, that they were allowed to start over again?
So I understand the concern that the witness had earlier, because I think there's a way to read this that implies that it's a very strict ban, that it could affect the polling locations for subsequent years. However,
because I wasn't reading it. That's why I was confused.
Sure. No, I understand what you're asking. However, I do think that there is a way to read this that would, I think, broaden that out just a little bit. And it also depends on the election that we're talking about. If we're talking about a November election where entities are required to use the polling places that the counties use, and so it's technically in that situation, they're having to designate the location that the county uses, and the county is able to designate the polling places for that election. It's not really the district that's doing the designating, it's the county that is. So I think depending on the elections, it's real clear that in some situations, it wouldn't impact it negatively. I also think the intention behind the bill is, and, as Representative Schofield stated, is to,
Consistency on where a location is.
Yes.
Since I've been voting since I was 18, I just go to the same library. I don't go anywhere else because I know exactly where it is. It's open. I know where I'm going to park. It's, I know what time to go, all that kind of stuff. Totally understand that.
And I will add, I think one thing that Representative Schofield said is very relevant. This is already the law that they have to make their building available. Already the law. That's the default. There's no mechanism for enforcing that now, or no punishment that is there for school districts that refuse to make their buildings available. This is now providing something that wasn't there before to emphasize that the law already requires that you make these buildings available.
Perfect. Thank you so much.
Sir.
Representative Morales?
Mr. Johnson talked about, the concern about the building. Let's say there's a maintenance issue or an HVAC issue. I can't find it in the election code, that section that he was referring to, but do you feel comfortable that the language is already there to address those issues and we don't have unintended consequences?
I do, because it says that if the school district fails to make the building available, I think it's different when the school district and the county, for example, come to an agreement that a building is not available for a given election. That's not the same thing as refusing the building and saying that you cannot use it for arbitrary reasons. I think when somebody has a construction issue, when they have, other community issues that might be at play, maybe there's, it's homecoming weekend or something, and there's a reason that you can't use something, related to that, and there are reasonable alternatives, and the county or the other, whoever's asking, is okay with these reasonable alternatives. I don't think that penalizes the school district. I can foresee scenarios in which it's agreed upon that they're not using it for this election, and it wouldn't preclude them from future elections.
Yes. Now that brings up, like, we use an Eagle Pass, the multipurpose, for example, and it's also where the the elementary teams or the outside teams play basketball. And so they've already set a tournament that's already in place, that we already have out-of-state folks, or out-of-city folks coming, then I can see how that would be a hardship since it's already been set up, so. Okay.
And oftentimes in those scenarios, there's usually an agreement between the school district and the entity that, typically the county that needs to use it for an election space. They do a lot of planning ahead of time, and, I think that's a scenario where there's an agreement to use an alternative location for that election. I don't think it would harm we would hold it against the school district.
Now,
when it's
really
agreed upon.
And now, really quick, walk us through who usually would enforce something like this? The local county, if they requested it, and let's say the school denied the request and didn't give a good answer, would it be upon the county to initiate legal proceedings, or is that Secretary of State referring it to the Attorney General for prosecution?
I think more often than not, it would be an item handled locally. I also think that if a school district used buildings that they were not permitted to use because they were in violation of this section, any candidate that lost their election could use that as the basis for an election contest as well. And so that's a pretty hefty risk that you take in using, locations that you were not authorized to use under the law. I don't know how successful the contest would be, but it could be grounds for a contest.
Thank you.
All right. Members, any other questions? Thank you. Ms. Atkins. Is there anyone else who wishes to testify on, for, or against House Bill 453? If not, the chair recognizes Representative Schofield to close.
A couple of quick notes. First, that bit at the end, the enforcement. Now, first of all, the whole bill is really about enforcement of the current law. The current law is you have to make these buildings available. This is really designed to just get you to do it. It's not really designed to have you not do it and then get sued. It's designed to have them go, you know what, we'd rather have this election than not have any of ours here. The November stuff that Ms. Carranza was talking about, if you have your bond on the November election and you're the school board, you're not going to deny yourself the ability to vote at the school. That will never happen. That's the whole point of this. They want that when they have a bond, they want their school people going to the school to vote on it. So that's not the issue. But the issue in terms of enforcement of this, it wouldn't be on the election in which you didn't use the facility. It would be when you try to have your subsequent election for your school bond, and the people who aren't in favor of the bond go into the judge and go, they're not allowed to have their election there because they didn't follow the law on the previous general election. So candidates who are running for state rep aren't going to be able to sue because their election isn't impacted. Their election is the one at which the building wasn't used and the county just had to find another building. It'll be the subsequent election when you try to hold your election for your $2 billion school bond and somebody who doesn't like it says, no, sir, you can't vote at Patterson Elementary because you refuse to use it. What Mr. Johnson was referring to, and I couldn't find the section because I can't get internet access for some reason, we have a section of code that is predominantly designed to make sure that we're talking about ADA compliant facilities, but we have one that says, it has to be usable. So we've had cases where the school's perfectly fine, but the entire parking lot was being redone, and so nobody could park there, so the county would just find somewhere else to go. That's not going to be denying the use of the building. It's just, we don't want you here. Well, if you don't want the voters here for one purpose, you don't want them here for another. Anyway, that's a lot longer than I intended to take up with this bill, but with that, Mr. Chairman, unless there are any questions, I would close.
Members, any questions?
He forgot how elections work.
He what?
I say he forgot how elections committee works.
Thank you, Representative Schofield. If there's no objection, House Bill 453 will be left pending. The chair hears none. House Bill 453 is left pending. The chair lays out House Bill 862 and recognizes Representative Schofield to explain the bill.
So I have two folders full of stuff here. Sorry about that. Current law has 7 instances in which a voter's registration is automatically canceled. Almost all of them involve documentation. So if we receive the abstract of your death certificate at the county, registration is automatically canceled. If we receive notice from another county that your registration is moved to that county, registration is automatically canceled. One of them in which it is not automatically canceled is another instance of documentation, which is when a person is called to jury duty, and jury duty like voting, has a legal requirement that you be a U.S. citizen in order to be able to participate. So one of the things that you can swear to when you're called to jury duty is that you're disqualified from jury duty because you're not a U.S. citizen. It happens. We use both the voter rolls, but also the driver's license rolls. And so you get people who aren't registered, who are not citizens, called to jury duty, and they say, I'm sorry, I can't serve, I'm not a citizen, which is perfectly acceptable, and they go about their business. What this bill says is if you swear to us that you're not a citizen, then we take you off the voter rolls, because the first requirement of being able to vote in our statute is you be 18 years old. The second requirement is that you be a U.S. citizen. So you're automatically not qualified to be registered if you're not a citizen. Now, we've had instances, we've had all litigation regarding the Secretary of State's program for trying to take non-citizens off. This doesn't touch that. That is trying to estimate based on lists and other things, and there's a settlement in Lulock versus Whitley, and if you read the settlement, which I have here, it doesn't touch this at all. This is about the Secretary of State trying to ascertain who are citizens and their lists and all that. I'm talking about an instance solely where the person involved has sworn to us that he's not a citizen and therefore ineligible to vote, and that rather than going through the currently cumbersome process in the election code, that we would instead just go straight to striking them because they've told us that they're not a citizen. Now, why do we need to do this? We have had, frankly, the system is broken. There's no link between telling us in a sworn document that you're not a citizen and being removed from the voter registration rolls, which require you to be a citizen. My favorite was Brazos County. In the 3-year period between January 2020 and December of 2022, they had 5,222 people who were dismissed from jury duty for not being citizens, and 2 people removed from the voter rolls. They'll tell you they don't use TEAM, which is the Secretary of State's data management. And so we've got a lot of instances where it doesn't happen. There were some counties that just flat out would not tell us how many people they were. I think it was Nueces that said, if you want that information, we're going to charge you $3,000 for it. So we couldn't even tell you what was going on there. But the issue here is very simple, and it's very clear. We're not talking about guessing at who's not a citizen, or we have good information to believe you're not a citizen. We're merely talking about people who have sworn to us in a government document, which, by the way, if they falsified it, it's a crime, that they're not a citizen. We then remove them from the rolls which required them to be a citizen. Now, in the past, when I had this, Mr. Anchia, I believe, at the time, asked the question of, well, what if they lied just to get out of jury duty? You've just taken a fundamental right away from them. Actually, you haven't. Because if they have committed a crime and lied to get out of jury duty and you strike them from the rolls, they can go register again tomorrow morning. Because at the time they go to register, they will meet all the requirements, including being a U.S. citizen. And it's not too much of a price to pay to have to go re-register if the only reason you got deregistered is you falsified a government document and lied to us to get out of jury duty and claimed not to be a citizen. So I will be happy to answer any questions. And again, I did not bring you all copies, but I have them if you want them, of the settlement agreement. You can read through this. This has nothing to do with documented cases where the person tells us they're not a citizen. This has to do with what the plaintiffs felt was a flawed system of us trying to identify on the rolls who wasn't a citizen. These people are self-identified. They're telling us they're not.
Vice Chair Busey.
Thank you, Mr. Chairman. Representative Schofield, I'm glad your internet's not working. I like it when you're not at full capacity. That's helpful. I have a few questions. I appreciate your layout. Your layout, if I heard you right, is you're not trying to repeal the settlement.
No, this does not touch the settlement top, side, or bottom.
This is where I
only touches people who have sworn they're not citizens to us in only one particular instance, and that's just jury duty.
I remember before I was in the legislature, I was here one night, maybe, were you on the elections committee in 2017? I was here before that committee testified. I'm sure you were excited to see me here. And it was dealing with the same issue.
No, I think actually I was off in 17.
Well, and I took the same stance that you quoted with Rafael and Chia. I agree it's a crime. It should be a crime. to lie. I don't agree that you should be thrown off the voting rolls because this is one of our most sacred rights, and there's a crime and a punishment over here. I don't think that's the right punishment for it. To that point, but let me jump to your bill.
If I may say before you ask, on another point, it's not a punishment. We're not punishing you. We're not sentencing you to be removed from the rolls. You've told us you're not qualified. We're taking you at your word, your sworn word.
On a document unrelated
and
to
taking you off.
your registration for voting.
Oh, no, it's related. You
Why?
have sworn that you don't meet one of the qualifications for voter registration. You've sworn
While they
to
were
us.
filling out their application to register to vote, they did that?
No,
Okay, on something else, tied to jury.
Yeah, but it's not unrelated.
related.
It is one of the, it's just like if they had to swear for some other purpose that they weren't over 18. Again, if you're not over 18, if you're not 18 or older, you're not.
But if they're 19, they should be thrown off the rules? For
No,
saying
if
that?
you're 19, you'd be qualified to vote.
No, but if they
you're-
said they were under.
If you swore that you were 17 for some reason.
Maybe they got a discount to attend something by being under 18.
Well, you wouldn't be swearing to the state about getting a discount to attend
I
something.
understand that. Let me ask you a
This
question
is a
about
very
your bill.
sacred duty of jury duty, equally
We
sacred as
strongly
voting.
disagree on that philosophy about what the right punishment is. But let's talk about your bill. Section 5, it's page 3, second to last line. If that's not what we're dealing with, we could jump through a lot of these questions by repealing this line from your bill. Section 5, Section 16.0332 of the Election Code is repealed.
Right, that's the section that has the current sort of more convoluted method that you go through that isn't working, that, as we saw in Nueces County, that more than 5,000 people didn't get taken off through that convoluted system. This would say, instead of saying, we're going to refer this list to them, and then we'll refer to them, and then maybe they'll take them off, we just go, they've sworn they're not jurors, just send it right to the voter registrar and take them off.
So House Bill 862 would repeal this section of the Election Code, which provides that before voters' registrations are canceled because of their citizenship status in specific circumstances, registrars must notify voters pending cancellation and give them 30 days to provide proof of citizenship.
Absolutely.
You want to repeal that?
Because you don't need to notify somebody who has notified you. They have sworn to the county that they are not a citizen.
So, well,
going to tell them.
You answered my next question. So
It's
here's your
nonsensical
goal.
to ask them to notify someone of what they notified you of. Hey, do you know that you swore not that you weren't a citizen to get out of jury duty? No, I'm completely unaware that I swore I was not a citizen to get out of jury duty. Yes,
Sure.
absolutely.
It is your goal to repeal that 30-day window.
Absolutely.
Okay, that's helpful. Helpful to get your answer, because that was my next question. So you are familiar with the LULAC versus Whitley settlement. We've been talking about it. The language of the section, the 16.0332, wasn't just in the settlement, though. It was added in SB 1 last session. We put this language into it. Mirroring the safeguards intended to ensure naturalized citizens are not improperly removed from the rolls, does a settlement agreement in that case establish? Is it your understanding that the terms of that settlement agreement would still be in place?
Yes.
If this legislation passed?
Yes. This does not deal with us trying to find people who aren't citizens and take them off the rolls. And by the way, you should clean off the rolls. Dead people, we should find them and remove them from the rolls. People that have moved out of the county, we should find them and remove them from the rolls. People who aren't citizens, we should find them and remove them from the rolls. This isn't about finding anybody. This is about people who have sworn to us in the same courthouse in most counties where you register to vote that they aren't a citizen and therefore do not meet the eligibility requirements to be on the voter rolls.
So I just want to wrap this up to be clear. One, it is your intent to repeal the 30-day, the notice and the 30-day response.
Absolutely. Once they've already given you notice that they're not a citizen, you don't need to go give them notice, they've given you notice.
And it's your intent to change the language that we put in SB 1, where we codified.
This section existed long before SB 1. It may have been amended in SB 1.
It was amended to match that LULAC-Whitley settlement.
Yeah, and again, this has nothing to do with the LULAC versus Whitley.
Okay, no, that's
We're not
good.
trying to find voters.
Last question here.
They're finding us.
Just to be clear, it is not your intent to invalidate the terms of the settlement agreement in LULAC versus Whitley with this bill.
That's correct.
Thank you, Mr. Chairman.
Members, any other questions?
I do, and I forgot now. They got so heated.
Well, I'll be back.
That's my friend. It's not heated.
I'll be back later.
If I remember, I'm sorry.
That's all right. All right.
Now, I know we've been informed by the parliamentarians that we no longer are supposed to say that we reserve our right to close, but I would like to reserve my request to close.
Absolutely. All right, you've got it. It's reserved. The request. The chair calls Ed Johnson. Mr. Johnson, you're here on behalf of the Harris County Republican Party Ballot Security Committee, and you're for the bill. Is that all correct?
Well, that's not correct. I used to be on the ballot security committee, but maybe you were supposed to be calling
Oh,
Alan.
I'm sorry, I've got the wrong line here. Hold on.
But I will represent them if you want me to.
I was trying to rank you Mr. Vera. I meant, yes. So
Would you like Mr. Vera to come up?
No, he'll come up here next, but you are Ed Johnson. You're on behalf of yourself, and you're for the bill.
That is correct.
And that's correct. Now, so go ahead.
Worked in voter registration for 10 years. We would get notices from deceased family, family members of deceased on, written letters. We would get it on poll books, sworn statements they would send in, and we'd immediately be able to remove them from the voter roll. Voter would come in and fill out, change a confirmation card, statement of residence, saying that they no longer lived in the county, and you were able to immediately remove them from the voter roll on their testament. You go to jury duty, and you sign a sworn statement saying, I'm not a U.S. citizen, and the county had to write you a letter saying, are you sure you're not a U.S. citizen? It's a huge waste of money to the county and lots of work that we had to can't take this person for their sworn word like we do on every other document that we receive, but we have to write them a letter to do this. This makes the whole system work so much more efficiently and quits the counties from having to waste this money writing letters to people that just filled out a sworn statement saying, I'm not a citizen.
All right. Members, any questions?
Thank you.
Thank you. Now the chair calls Alan Vera.
Are you going to say?
And just to remind everybody again, this is Mr. Vera's birthday.
Jesus.
Anybody forget? You're here on behalf of the Harris County Republican Party Ballot Security Committee, and you're for the bill, is that correct?
That's correct.
Go right ahead.
Just some quick perspective for the committee relevant to Section 1, Paragraph 8 of the bill. In 2019, Public Interest Legal Foundation sued Harris County in federal court in Virginia to obtain the documents in which citizens claimed they were not citizens to get out of jury duty. And PILF successfully sued Harris County to get that information and successfully sued to have 3,000 plus voters taken off the rolls. So this has been done in federal court. The bill does nothing more than to make that a codification of that practice. Thank you.
Absolutely, thank you. Members, any questions? Thank you, Mr. Vera. The chair calls Bill Sargent. Good afternoon or evening, Mr. Sargent. I understand that you're here on behalf of yourself and that you're for the bill. Is that all correct?
That's affirmative. I'm sorry the author just left, but.
He'll be back.
He'll be, okay.
Yes, sir. Go ahead.
In Galveston County, we had a non-citizen who voted 5 times and successfully did so until he went to jury duty, and he told the judge he was not a U.S. citizen, so he was taken off the list. He couldn't vote. So it does happen. He apparently was not aware of the fact he had to be a citizen in order to vote. We need to stop the way we do registrations. We need to require documentation of citizenship and have it be presented in order to, instead of simply checking a box that says you're a U.S. citizen. There are instances where rogue deputy voter registrars have registered people, and they didn't know that they had to be a U.S. citizen. They just went ahead and registered them, and they went and voted. And then they come back in wanting to become a U.S. citizen legally, and they have to have a Department of Homeland Security form filled out that says you never voted illegally. And in Bexar County, this happens at least maybe 3 times a month, that they come in, they want to become a U.S. citizen, and they're precluded from doing so because somebody didn't tell them they had to be a U.S. citizen. They did not know it. They didn't want to violate the law, but they did. And that's just dead wrong, folks. So I would suggest to the author and to this committee that in order to strengthen this bill, you might want to add provisions that would require documentation for a person who is registering to vote, similar to what you get when you go to DPS. That would strengthen the bill. It would make it a lot better. I support the bill as it is, but I would encourage you to consider doing that.
Thank you. Members, any questions? Yes, Representative Manuel.
The person who was voting in Galveston, was that person prosecuted for voting illegally?
That person was referred to the local district attorney. The local district attorney happened to be a person who knew that family, and so he chose not to prosecute it, but instead to refer it to the Attorney General's office for prosecution. And as far as I know, nothing has happened since then.
And do you know, when was that?
Because he probably had a conflict of interest, so.
Anyone voting that should not be voting should be prosecuted. That's illegal. But I'm just was wondering. So that, okay, thank you so much. It was referred to the Attorney General's office.
Right, because the local DA felt he had a conflict of interest if he was to prosecute it.
Thank you so much.
Any other questions, members? Thank you,
Thank
Mr.
you.
Sargent. The chair calls Emily Ebby French. Good evening, Ms. French. You're here on behalf of the Texas Civil Rights Project, and you're against HB 862, is that right?
That's correct.
Go right ahead.
All right. I'm here to testify against HB 862 and its attempt to remove the safeguards around identifying non-citizens on the voter rolls. We've gone over the LULAC settlement, and I won't belabor it again, but except to say that I remember hearing that one day the Secretary of State's office had called McLennan County and said there are 366 non-citizens on your rolls, and then 2 days later they had quietly called McLennan County again and been like, take 366 of those names off the list. And we're like, well, that math doesn't quite math up, but it was an incredibly flawed voter purge and not something we want to go back to. My reading does not match up with the reading of the bill author. The settlement agreement was codified and approved by the Secretary of State in 2019, codified into law in section 16.0332 of the Election Code. And that section does include the jury service provisions, but it also includes the folks who are marked as non-citizens from the DPS list maintenance. So to repeal that whole section would also take out the protections enshrined by the settlement for folks on the DPS list maintenance. So it's not strictly people who've told us they're not citizens because of jury duty. It would also apply to that part as well. I think a colleague from the ACLU will talk a little bit more about that in a minute. Citizenship status is really complex. Government agencies are notorious for having out-of-date, mismatched information. I agree that these things need to be accurate. They need to be efficient. We want to make sure we don't throw the baby out with the bathwater. We'd urge you to reject this proposed legislation, not open the door to potential errors, which could lead to eligible voters being wrongly removed from the voter rolls, in addition to the folks who should not be on there.
Thank you, ma'am. Members, any questions? Representative Morales.
You're telling us that the lawsuit was codified into section 16.0332?
Correct. And there are other things that weren't specifically the Whitley v. LULAC settlement in that section. This bill would repeal the whole section, but that section is part of it.
Including the settlement, which we're trying to preserve, and which even the author has said, I'm not trying to touch the settlement.
Correct. That's my reading, and I've talked to other folks who that's their reading as well.
Okay. And I need to, your office, you're already familiar with my office. So
Absolutely.
To discuss possible changes to that, because I do think, though, that as an attorney and the expenses as a litigator, which is different from just regular attorneys that are out there, may not ever see a courtroom. There's so much work involved in preparing for trial on these cases.
Right.
And even though 90% of them end up settling, those few cases that do go to court result in thousands of dollars and time spent from both party litigants, and they deserve their right to be up there. And then we have issues almost every trial, and I'm one of the the attorneys in my area, in my region, that has tried the most cases down there because we're usually civil defense, doing civil defense work.
Right.
And the consequences that I have seen is that we end up with judges having to order deputies to send out and go get people because they will not respond to their jury summons and be there on time. They stop their proceedings for hours because we have to now wait, and we can't keep going and announcing our board hour or performing our board hour because we have to have the entire jury panel there.
Yeah.
And then when these instances happen, this is kind of new to me, I had not seen this in my area at least, but 5,222 people being dismissed, and that, now I remembered what the question was to the author. I wanted to see if those were all related to being dismissed because they were claiming that they were not U.S. citizens, if that was the case on those 5,222, because I also noticed that many, at least in South Central Texas, many of the folks don't have, they may be U.S. citizens, but there's no way that they could sit there through a complex litigation case. And they'll be the first ones to admit, like, my English is not at the level to be able to listen to experts and to be able to discern their testimony and be able to process it correctly to make an informed decision in this case. And rightfully so, right? They call themselves out and they tell the judge and the parties, like, I don't think that I should be sitting in this case. And I want to make sure that we protect those individuals that are dismissed, but not because they're not U.S. citizens, just they are not going to be able to handle, or they don't have a good grasp of the English language.
Right.
And so, do you know if these 5,222 people that the author was discussing were all dismissed because they were not U.S. citizens?
I personally have never heard that number before. That's one of the things we'll get back to your office about. I'll look into that and see where that number might come from. I'd love to hear more about that. My concern that you mentioned, the folks who maybe don't have the best English, maybe can't understand complex litigation, things like that, those type of people sound to me like the exact kind of people who might accidentally check a box on a form that says they're non-citizens and then be mistakenly purged from the rolls. And as one of those very lucky attorneys who doesn't have to prepare complex litigation, I agree with you entirely that we want to make sure we protect
And usually, I mean, once the judge has them there, I know that they've never just taken somebody's voter, information that they filled out and just taken it as so. They usually have almost always follow-up questions just to verify and make sure that what they're saying is accurate. And they usually call them up and it's on the record. But I also am pragmatic, and being in government, I dislike heavily bureaucracy, and if I can streamline that process, and that's where I'm trying to go with the author in terms of why is it necessary if somebody is telling us in a sworn statement that they're not U.S. citizens, why don't we take them for their word, obviously with the judge also verifying that information before they're let go from the courtroom, but if in fact that is verified, we should be able to rely on that sworn statement. And I want to know why you or your organization would not be supportive of that measure, or why you're in opposition to that. Because I'm really open to understanding why you would not take that sworn statement as the literal truth and then be able to say, we don't need to send another piece of paper and wait 30 days.
Yeah.
I mean, this person came and said they're not U.S. citizens.
Right. And I think if the bill were just that, that we would be having a different conversation. My organization may or may not have taken a different position on that, but by repealing the entire section that's in the repealer, I think that it's being over-inclusive and it's targeting voters who aren't in that fact pattern, right?
Love it.
And
Thank
so
you
I
for
think
your response. Let's work on that wording to make sure that we protect that settlement, but at the same time that we are the folks up here that will fix these issues, and we can respond to our Texans and to our constituents and say, we're done also with bureaucracy. We're going to streamline the process wherever possible, and we're being responsive to our constituency. Thank you for all your help. And you and your staff and everyone down there are invaluable in what you all do for us and keeping us informed. So thank you.
Thanks so much.
Any other questions, members? Thank you, Ms. French.
Thanks.
Chair calls Robert Green. Mr. Green, you're here on behalf of the Travis County Republican Party Election Integrity Committee for Legislation and yourself, and you're for the bill. Is that
Yes,
correct?
sir, I am.
All right, go ahead.
Again, this is another important methodology to remove people from the voter rolls who are not eligible to cast a ballot in the election being conducted. It provides for communication between state agencies, et cetera, to more efficiently achieve the goal of removing those people from the voter rolls if they have been excused from jury service because they are not a citizen. They have sworn that they are not a citizen to get off of the jury. I'd like to step into something else. I think it has to do with informed consent. I had testified in favor of SB 2 over in the Senate and had made a recommendation that was amenable to the bill's author, Senator Hughes, essentially to put a notice in every polling location that says you are eligible to vote at this location if, and go through all of the things that are currently in the election code. And I think that it'd be like informed consent. It's like seeing a sign on a building that says, you know, regardless of whether the law says about personal carry, you can't carry in this building. But essentially, that way to give the people who are standing in line notice right up there to say, you can vote if, or you can't vote if you're a non-citizen, et cetera, a felon who's not off paper, so on and so forth. But to set those down very specifically so that they see them when they walk into the polling place.
Appreciate your point, Mr. Green. Members, any questions? All right, thank you, Mr. Green.
Thank you.
You bet. The chair calls Sophia De Loreto Chudy. Sophia De Loreto Chudy. Sophia De Loreto Chudy. I show her as against HB 862 and testifying on behalf of herself. She's not here. The chair calls Andrew Hendrickson. Mr. Hendrickson, I show you as testifying on behalf of the ACLU of Texas and against the bill. Is that all correct?
That is correct.
Go right ahead.
All right, so I had a bunch of points, but I am just going to jump right in because we have missed something massive about the LULAC settlement in both the author's layout and the discussion that's happened so far. The issue was not about how DPS had records where the person did not indicate that they were a citizen. DPS absolutely had those records in which the voter themselves did not indicate. The reason for the 30 days, Representative Morales, the reason that voter purge, which identified 95,000 people who were recently naturalized citizens, was the issue. Now, DPS has records that date back years and years in which you indicated that you were not a citizen potentially. Those were being compared to the current voter registration lists. The problem there was 130,000 new Texans were naturalized as U.S. citizens last year in Texas. That's 365 new citizens in Texas every single day on average. And what was happening was you were having to, and this language is the language that's codified, so you were having this situation where someone would either say, and this dealt with DPS, but the same could definitely be true of jury duty, but in the LULAC settlement, the issue was you were using a record from prior to naturalization. Now, at the end of a naturalization ceremony, someone receives a voter registration form. It is part of the naturalization ceremony. They would fill that form out. Prior to that, when they had been a legal permanent resident, been here on a work visa, they may have interacted with DPS, and in getting a driver's license, they may have indicated to DPS that they were not a citizen for the purposes of that indication. But what the settlement said is that there has to be the right timeline. The settlement is all about the timeline here. It says that you can only use the DPS data from the database to scrub somebody from the voter rolls if they indicated after their registration became effective to DPS. So after they have registered to vote, they indicate that they're not a citizen. That's why the 30 days is in there. That's why the extra layer of protection is in there. That's the same for why it was in there for jury duty. When this section was enacted, originally not related to the LULAC settlement, it was actually shortly after the NVRA was enacted. And many, many folks, the bill passed unanimously. It was 1997. Many, many folks, especially in South Texas, who were in that situation were being given a voter registration form for the first time when they went to renew a driver's license if they were a legal permanent resident or they had a work visa. And so you had a lot of process that had to happen. But what people wanted to make sure of with the 30-day requirement is that we're not capturing citizens who naturalized after they made a sworn statement that they were not a citizen and therefore registered after. So this is all about the timeline.
Okay. All right. Well, thank you, sir. Members, any questions? Yes. Representative Manuel.
Okay, so this is, in your opinion, would you think that then in that case, maybe it should be a question that the person has to check or whatever it may be, where it asks, are you, like if they say I'm not a citizen, why, are you going through the process of citizenship to maybe there's a box that the person could check? Because I'm just going to say it and be very honest. It does seem for me, it's a little hard to say if a person says they're not a citizen, that we're still going to allow them to have the right to be able to vote and use whatever the excuse, because it does make people feel that the elections could be unsafe. And I'm saying, looking at it from that point of view, what do you think it would be if it was a point for a person to have to check? Are they going through the process of immigration? Are they 30 days away from whatever the situation
They may have not been going through that process.
Mr. Hendrickson, hold on.
Sorry, excuse me.
Rather than just not doing anything and making people feel...
Representative Manuel.
Yeah.
I don't want this to turn into a big, broad discussion about someone's ability to waive their right to vote. The bill is about what happens if you go in and tell someone that you're not a citizen whenever you show up for jury duty.
It
Well, I
does
think we've gone
include any
far-
other,
excuse me.
sorry.
I think we've gone far afield. So do we have a specific question about that particular situation, or are we going to have a...
No, that was what I was saying is, what is his thoughts on like when they're saying during jury duty, if they say I'm not a citizen, they would have to mark why they're not a citizen rather than not doing anything at all. That was just my question.
Okay.
Yeah.
All right. Yes, Representative Houston.
Hey, Mr. Chairman, specific to the bill, and this may not be the intent, so let's hash this out and then we'll talk to the bill author. Page 2, Section 8, I'm looking specifically at line 13 and 14. Do you have the bill in front of you? Of course. It just says, this Section 8, a list under Section 18.068 of this code or Section 62.113 Government Code of persons excused or disqualified from jury service because of citizenship status that includes the voter or other notice from any governmental agency that the voter has acknowledged that the voter is not a citizen of the United States. That to me says this is beyond just jury duty, a jury duty notice. Is that how you're reading it? Is that what we're talking about, just to get us back on?
That's correct. And if you look at the section that's being repealed, I believe what that language is trying to capture is what it says in the portion of the repealer is a person excused or disqualified from jury duty to citizen status indicated lack of citizenship, or a person who indicated lack of citizenship status in connection with a motor vehicle or Department of Safety, public safety record as provided in Section 8, the registrar shall deliver. So it's a notice under that portion of the repealer, of the repealed section, that would be captured by any governmental agency portion. So I didn't mean to make it go in too far afield, but I would also point to one other section in that repealer, which is A1 of Section 16.0332 is exclusively about the agreement between the Secretary of State and the Department of Public Safety and Department of Public Safety records. And so when you're talking about that, and this is, I think, to get to the answer to your question, Representative Manuel, the protection in that, I believe, is the appropriate protection, which is, it reads, in comparing information under this subsection, the Secretary of State shall consider only a voter's information in the database of the Department of Public Safety that was derived from documents presented by the voter to the department after the person's current registration became active, right? And so it is, again, that's the protection there. The timeline is the protection that you're only looking at statements that were made by someone that they were not a citizen that were after their registration became effective.
And my last question, Mr. Chairman, on this is to this point right here. If we repeal, which again is where I started my questions with Bill Author, Section 5, repealing this whole section, what was so important, and I was serving here when we were dealing with this issue in 19 on this committee, it was people were removed who may have said this before they registered to vote. So we got to make sure we don't lose this timeline. And if we repeal this section, and if that case is or no longer there, then we could lose that timeline. Is that your understanding?
That is correct.
And so that's another thing we need to be very cautious about because, for example, someone may not be a citizen. They say they're not a citizen. Later, 2 years later, they register to vote. Without that timeline, you could pull a date, a government document before they registered to vote when they may have not been a citizen and take them off the rolls. All right. Thank you,
That's a good point.
Mr. Chairman.
Thank you, Mr. Henderson. Members, any other questions? All good discussions. Thank you.
Thank you.
The chair calls Samantha Serna Uribe? And I'm just probably butchered a beautiful name there. Did I? Okay.
Got it.
Are you Samantha Serna Uribe?
Yes, Chairman.
You're here on behalf of the Mexican American Legal Defense and Educational Fund, and you're against the bill, is that correct?
Yes, Chairman.
You go right ahead.
Chairman Smith, Vice Chair Busey, and members of the committee. My name is Samantha Serna Uribe, and I am a staff attorney with MALDEF. Founded in 1968, MALDEF is the nation's leading organization that litigates civil rights on behalf of Latinos in the United States. MALDEF was also a party to the Whitley litigation and was part of negotiating the settlement with the Secretary of State. As has been testified to, Section 5 of the bill, House Bill 862, which MALDEF opposes in its entirety, does repeal the Section 16.0332 of the Texas Election Code, which codifies the Whitley settlement, and that is subsection A1 of the bill. The process outlined in that subsection requires a notice to be sent to the notice to registered voter for proof of citizenship. And that provides a mechanism and a process to flag a list of individuals who either were excluded or disqualified from jury service based on lack of U.S. citizenship or with the record with the DPS. And the process provides the 30 days that was negotiated by the parties in the Whitley litigation to provide registration status. I want to turn to some of the questions, or one specifically about an individual who states in order to not have to testify or to serve in jury service, that they are not a citizen. And you can imagine, to provide a scenario, because MALDEF is aware of several individuals whose citizenship status was incorrectly flagged by their voters registrar, and they utilize this 30-day grace period to cure and to maintain their voter registration. So imagine a home in which there's a junior and senior with the exact same name, but the jury summons doesn't include or explain that it's the junior or the senior. It leaves that off. And so dad, who perhaps is not a U.S. citizen, goes to jury service, says, I'm not a U.S. citizen, I can't serve. That list of the individual's name without the junior or senior gets sent to a county registrar, says that that individual with that name didn't testify because of citizenship. And junior, who is a U.S. citizen, is automatically removed from the voter rolls. And so the 30-day grace period is very important to allow individuals who are U.S. citizens or naturalized citizens to be able to cure any flag to their citizenship or voter registration. I also have my testimony. We asked that the committee reject House Bill 862, and I also have a copy of the notice that is prescribed by the Secretary of State that is sent to individuals who are flagged by their county registrars for the county.
Thank you, ma'am. Members, any questions? Yep. Representative Morales.
You were here when the line of question with the Texas Civil Rights Project and with Emily. If we were to make sure that we take into account the LULAC settlement and incorporate the correct language so that we don't completely do away with 16.0332, would you feel comfortable in supporting it, knowing that that sworn statement from them should suffice to take them off the voter rolls?
Well, Representative Morales, the language of the bill doesn't contain the phrase "a sworn statement." It says that an individual, the cancellation is immediate upon the county registrar receiving a list of persons excused or disqualified from jury service because of citizenship status, but it doesn't include any language about a sworn statement from the individual. And in the example I just provided, you could have a scenario in which a household with the same name of both a father and a son, and one shows up to jury service, is not qualified for jury service, but then the son's voter registration is removed from the roll automatically, and there's no mechanism to challenge that and to cure that challenge. And so what the bill seeks to do is remove a safeguard for individuals who are lawfully registered to vote and are citizens, and it has a disproportionate effect on naturalized citizens. And so as this previous testimony indicated, the section that this bill seeks to repeal lists out a process that safeguards the correct timeline and as it was negotiated by the parties. And so the 30-day notice is important to allow scenarios in which mixed status immigration families have the opportunity to safeguard their voter registration, and it allows the county registrars to do a thorough investigation rather than forcing an immediate cancellation for the voter.
All right, tell me how, if there is a 30-day, I'm all about the timeline. I think it's important the way Mr. Busey explained it. It made perfect sense to me. But tell me how in that timeline the senior goes out there and he's not a U.S. citizen. I'm junior, I am. The notice was actually to me, but my dad got it. He appeared and he tells the judge, I'm not a U.S. citizen. When that notice right now under its current format, the elections administration would send a letter. How would I know and my dad know that that was for me? If we have the same name and we have the same issues, just the same way that my dad went thinking he was being summoned to jury duty, and that notice letter goes out, it's going to go in the same name. How do you make that distinction that this applied to me and not to my dad?
I would refer you to the actual form. It is listed out there. The individual, your voter registration has been marked or flagged, and I don't have the exact language in front of me, but it states in the notice that your voter registration has been flagged based off of an alleged lack of citizenship. And so Junior would know that he is a registered voter. And so it's much clearer in that instance as opposed to just the name on the jury summons.
Can I see that form? Does she and so would it include the date of birth and other specific identifying information?
No, the form as prescribed right now by the Secretary of State just lists the name to the individual. And that's why the process is important, because it's a name match. That's essentially what's...
Name match, but we're talking about the scenario you gave is two Heriberto Moraleses, which is happening in we have three right now.
Yeah.
My dad, me, and my son.
Yes, but the question there is having the notice sent to the household provides the voter in the home a chance to cure. And under the bill, it would remove that process entirely. And so the individual would have, it provides not until 30 days after the cancellation would they be able to have notice that they have been removed from the rolls. And so the issue is the automatic cancellation, that it doesn't allow a lawfully registered voter the chance to cure the claim, the alleged lack of U.S. citizenship. That's the issue. And that's what the Whitley litigation and the settlement agreement was all about, was providing a process by which individuals who are lawful registered voters to cure challenges to their registration.
You mean before Whitley, there was no 30-day notice to cure?
I wouldn't know that, unfortunately, Representative. I do know that what was happening to cause the litigation was that the Secretary of State sent out an advisory to counties that scooped up all the past records of individuals who had interacted with DPS, who had indicated at one point in time they weren't U.S. citizens.
I
and then
understood that process
after fact.
from Representative Busey. Okay, I'm looking at the jury questionnaire that I'm very familiar with, right? Because we have access to it after they fill it out. It provides for an age, it provides for a date of birth at the very top, it provides for race, and also on the far right, are you a U.S. citizen? Check a box, yes or no. And then there's even, and I've forgotten about this, in parentheses, please see note below. At the end of that first page, it says note. If you state that you are not a U.S. citizen, you will no longer be eligible to vote if you fail to provide proof of U.S. citizenship to your county voter registrar. That is all. I think that there's already enough notice there to the individual of its effect if you were to check that box no. In addition, you have to put your age, which means then more than likely, like my experience in the 20 plus years of litigation is with those judges, they don't just let those folks go. They ascertain that that is Heriberto Morales, and my data shows you're supposed to be 43. Sir, you don't look 43. Like if my dad happens to be the one that responds. It's like, are you correct? And that's how they're able to, the judge is able to make that determination. And then like figure out like, oh no, we got the wrong Heriberto Morales.
I understand your point, Representative Morales, but the problem is the notice doesn't go to the right Representative Morales, right? Like, yes, there could be a judge who engages in that process, but that's not what's outlined in this bill. It requires the automatic cancellation without the means to cure. And so the scenario is contingent on the right person giving the statement that they are not a citizen. Okay. And it's a name match that happens that can be weak.
This. Do you know the way the bill, and I don't, I need to go back and maybe this is a question for the author. If they were to, under this bill, if they were to then make a determination that Heriberto Morales has sworn in this jury questionnaire that he's not a U.S. citizen, therefore he's going to be automatically taken off the voter register. Do you know if the bill provides for Heriberto Morales to receive a notice?
A notice after the fact.
Yes.
They have been canceled. But that's in controversy of is against the settlement agreement that is both outlined in the election code, but also that the state of Texas signed. And so there's still a process that the state has to abide by, whether the bill repeals it or not. There's still a settlement agreement that is legally binding on the state of Texas.
I think it was the way the Representative Busey was saying, it's all about the timeline of previous to that. But now you're actually in a sworn document saying you're not a U.S. citizen. And I think the notice would take care of, if I receive the letter, it's like, why am I being taken off the docket? Then I go and correct it.
But it doesn't provide, the bill doesn't provide an opportunity to correct it before you're removed. It's automatically canceled. And so that's the issue that would be against or would be in violation of the settlement agreement.
I'll tell you what, I think this is all great exchange here. Do you mind having conversations with both these guys about, in the event that is the situation? We'll hear from the author in a minute, but we can get that fixed up. And I appreciate the discussion.
Thank you, Chairman.
But thank you. Members, if there's no other questions, then I'll call Laura Rogers. You are Laura Rogers. You're here on behalf of the County and District Clerks Association of Texas, and you're neutral on the bill, is that right?
We are neutral on this bill.
Yes,
and I am the county and district clerk for Sherman County. Therefore, I also do elections, county clerk, and district clerk duties for the citizens of Sherman County. Our concern, or where we want clarification on this bill, would be the fact that as a combo clerk, I do maintain multiple documents outside of the jury summonses that indicate that the person is a non-citizen of the United States or of the state of Texas. And so we would just like a little bit of clarification about any other governmental records and what it would require as a clerk for me to provide to our voter registrar, who is in a different building, different office, that is not under my roof, what the requirement would be for me whenever we receive like a magistrate's warning where the person has marked a non-citizen, and if that person is not a resident of Sherman County, would I be required to send that to the county that person resides in?
Members, any questions? Thank you, ma'am.
Thank you.
The chair calls Christina Atkins. You are here on behalf of the Texas Secretary of State's office and neutral on the bill. Is that right, Ms. Atkins?
Yes, sir.
Members, any questions, Ms. Atkins? Do you have any?
I thought y'all were gonna have a ton of questions.
No, you go right ahead. You have some.
Sorry. Christina, you heard all our back and forth. I have concerns with the current wording, and I think that we need to take care of the LULAC and versus Whitley settlement. Would you agree with me, or do you think that the wording is accurate enough to move forward?
So what I see here is in that number 8, when it says, or other notice from any governmental agency, that would include the notices that we received from DPS related to the litigation, what people keep referring to with that settlement agreement. The settlement agreement specifically has language says that if there's any state or federal law that's applicable supersedes the terms of the settlement agreement. So if this law goes into effect as is, that settlement agreement has no effect. We have to follow the law, which means that any information we get from DPS, where we have currently been sending that out to the counties and the counties send out notices, now if we get that information, if this law were in effect, it would result in an automatic cancellation for that voter.
Got it. Now, under the scenarios that I've given as far as, you know, my father and myself and the wrong person going to the jury questionnaire, to the jury summons, the fact alone that, and then after my dad claims not to be a U.S. citizen in that jury questionnaire, and then a notice letter will go out to that home address, do you find that to be sufficient for purpose and to be in compliance with the LULAC settlement if we were to incorporate that language from the LULAC settlement?
The LULAC settlement, there's really the primary key piece to that settlement agreement is the timing issue, that these individuals have provided information to DPS indicating that they're not a U.S. citizen, but were already registered to vote. So there's that. It's the timing of when those steps occur, and then it happens within that 30-day process. And so we know that they were already registered before that information, before the registration had to come first, is essentially what the settlement agreement says. And so I think if you were wanting to do something that was consistent with the settlement agreement and consistent with that process, you would have to take into account that timing issue. And also, if you wanted to do something that was in line with that settlement agreement, you would have to provide a notice and response opportunity. I mean, that's what 160332 does, is it requires that an individual be notified, receive a notice, that individual has the opportunity to then provide proof of citizenship. If they don't respond to the notice, or if they don't provide proof of citizenship, they are canceled. They're not put on suspense. They don't go into any other bucket. They are canceled. It just delays the cancellation because it gives the voter the opportunity to respond if appropriate.
And that's on the timing issue if somebody were to have claimed prior to that they were actually U.S. citizens and registered.
Correct.
Right, under LULAC.
Correct.
So we can have that and protect the LULAC settlement. And at the same time, do you feel comfortable that we can have this particular section that also, can we have both?
Well, I think you would have to change the language in number 8 to remove the language that says, or other notice from any governmental agency. Because what this is doing is this is putting the non-citizen jury excuse and any other notice from any other governmental agency, and it's putting it into the provision that requires automatic cancellation, no investigation. So if you wanted to preserve the settlement agreement and that DPS process that's in place, you would have to change number 8, I think, to remove that reference to any other notice from a governmental agency. And I believe it would probably be better to leave in 160332 and maybe just modify 160332, because that provision now makes reference to the government code provision related to jury service. So
Could your office send us some proposed wording? As you just,
I can send you, yes, I can describe to you, I can send you something in writing that describes those steps, if that's the course of action that the bill author wants to take on this.
I like to have it so that I can see if it makes sense to me, and then I can discuss.
Yes, I can give it to you, I can give it to you regardless, sir, yes.
Thank you.
Yes.
Members, any other questions? Thank you, Ms. Atkins. Is there anyone else that wishes to testify on, for, or against House Bill 862? Chair hears none. He recognizes Representative Schofield to close on his bill.
All right, now, it is not above me to sneak in a repealer that is designed to be more than the entire bill, but that actually wasn't the purpose of this, and I'll be frank with you. This bill was drafted before the settlement. This is a refile, and so at the time, 16.0, I'm going to get the numbers wrong, 332 was the alternative to what I'm doing in the bill. So when you did what I did in the bill, what you did was repeal that. I knew in SB 1 that we'd put in language to enact the settlement agreement. I didn't realize we'd put it in 16.0332. So I'm more than happy to undo the repealer. This wasn't the purpose of, hey, let's just do a little language here so we can repeal this. That was not fixing it when I refiled it. It was a mistake on my part. Now, in terms of the timeline, these are all contemporaneous. The problem in the settlement was they just went back and grabbed all the records they had from however long ago it was. This is something that happens on the third business day of every month. So when you go to court and you say, no, I'm not a citizen, you check it, the third day of the next month, so May 3rd if you did it today, and you can actually see it's the part of the law that it's referencing is actually in this bill. It's Section 4 of the bill on page 3. If you look at B, on the third day of each month, the clerk is to forward all of the information about different things, one of which would now be this. And if you see also the fact that we now have some election administrators, we used to just have county clerks, that's the purpose for the language here. It says a county official responsible for administering elections. It may be your county clerk, but it could be your EA. And so that's the only reason that whole section is in the bill. So yes, we'd be more than happy to undo the repealer of 16.0332 and say something to the effect of notwithstanding that in this instance, if you swear on a government document, which is what you do, by the way, that's how you get out of jury duty. You're checking on the document. We don't bring a notary in, but it is a government document, and you have sworn to it. In terms of the timing, this is the right timeline. This is not, again, going back and finding prior language. This has nothing to do with naturalized citizens. You're not naturalized yet if you're telling the court you're not a citizen yet. If you get naturalized, next month and you go register to vote, this doesn't affect that. And in fact, I could certainly see a lot of circumstances where people aren't a citizen yet. What you'd probably do, by the way, if you weren't a citizen and you wanted, folks who are getting naturalized want to vote, they want to participate on juries. You know what they're going to do if you actually send them the notices? They're going to kick it because certainly all the big counties will let you postpone your jury service till the next time. They give you at least one bite at the apple of postponing. And if you're about to become a citizen, you're going to postpone so you can serve on the jury. But that's neither here nor there. So to me, this is the right timeline. This is a current statement that you're not a citizen. If you become one, you're certainly eligible to register to vote at that time, but you won't have done it yet. This won't be after you registered to vote because you haven't been naturalized yet.
Well, I know you, as smart a lawyer as you are, I know you'll work with Christina and everybody involved in trying to get something that works here.
That should be a fairly easy drafting fix.
I would think. Yes, Representative Dayala. Members, any other questions?
You're not supposed to haze me. It works the other way around.
Thank you, Representative Schofield. We appreciate that.
Thank you, and I close, Mr. Chairman.
Is there anyone else who wishes to, well, no one else is testifying here. I'm just going to say no one else is going to testify on this. If there's no objection, House Bill 862 will be left pending. The chair hears none. House Bill 862 is left pending. But wait, folks, there's more. The chair lays out House Bill 1140 and recognizes Representative Schofield to explain the bill.
I only have 25 questions.
This one should be a heck of a lot shorter than that one. As you all recall, last session in the same bill, Senate Bill 1, we put in a form of voter ID for mail ballot voters to protect their ballot from somebody else casting it. And it included putting in either the last four of your social or your driver's license, or if you didn't have a driver's license, your DPS issued card or your voter registration certificate, which is something that we passed into law when we did photo ID, that if you don't have a driver's license and you don't want to pay for a DPS ID card, you could get one of these cards, and it's only good for voting. You can't use it for any other purpose. You can't use it as ID, but there it is. Now, really, almost nobody has these. But because it exists, we put in the law that it's one of the things you could put on your mail ballot. Well, in the first election, which was the primary, after we passed this law, thousands of people took the VUID number that the county sends them in the mail on the postcard, assumed that was this, wrote it on their ballot, and their mail ballot didn't count. Now, both the counties and the Secretary of State did a great job between then and the general of getting the word out. Counties spent a lot of money educating people so that they would know that's not the number to use. The Secretary of State put the highlighted language that you have in front of you that says not your voter registration VUID on there. The only reason for this bill is that probably the most crowded real estate in Texas is not in downtown Houston. It is on your mail ballot envelope. There's a lot of stuff we think that people ought to know, and we cram all of it onto that envelope. Of all of it, the only language on the entire envelope that isn't dictated in statute is this language that you see here. Everything else, Secretary of State sort of felt they needed to put this. Everything else comes word for word from a statute. And so the point of this bill is just to give them the statutory authority to do what we're all pretty darn glad they did, which is to explain to these folks that it's not your VUID. The actual language I use here isn't what we're going to end up with. We're going to try to find a way to say exactly this language in a way that gives the Secretary of State the authority to do what, again, we're all very happy that they did. They saved thousands of votes because the problem that we had in the primary did not remanifest itself in the general as a result of a lot of good efforts. You can't expect the counties to go out and do this voter education for seniors predominantly every single election from now to the end of time. So we want to make sure that we're able to kind of give cover and sort of validate the action the Secretary of State did in putting this language on the mail ballot envelope. And Mr. Chairman, if there are any questions, I'd be happy to take them. Otherwise, I would reserve my request to close.
Thank you. It's reserved. Members, any questions? Don't go too far. I think we got one witness, to tell you the truth, unless Mr. Belsick is here. Michael Belsick?
Chair.
Michael Belsick? Michael Belsick? I show him as representing himself. He's for HB 1140 and not here to testify. We do have a resource witness, Christina Adkins. Christina Adkins. I show you as testifying on behalf of the Texas Secretary of State's office, and you're neutral on the bill, is that right?
Yes, sir.
Okay, ma'am, do you have any comments about this particular piece of legislation?
No, sir.
Okay, members have any questions? Thank you. Is there anyone else who wishes to testify on, for, or against House Bill 1140? Hearing none, we invite Representative Schofield to close on his bill.
Thank you, Mr. Chairman, and members of the committee. Thank you for your good discussion on all my bills. Yes. But in particular, we really want to preserve our seniors and other folks who qualify to vote by mail, make sure that their vote is counted and that it is received. And so thank you to the Secretary of State's office for the work they did. Thank you to the committee. And with that, I close on the bill.
Yes, sir. If there's no objection, House Bill 1140 will be left pending. I hear none. House Bill 1140 is left pending. Thank you, Representative Schofield. Appreciate, as usual, I always appreciate your advice, too. Thank you. The chair lays out House Bill 3732 and recognizes Chairman Guerra to explain the bill. Representative Morales offers a committee substitute. Good to see you this evening.
Good seeing you, Mr. Chairman. And members, good seeing all of y'all. And again, thank you, Chairman and members, for allowing me to lay out House Bill 3732. I'd like to give some background and context to this legislation. I don't want to cause any hullabaloo with this bill. That's not my intent. It is a simple bill that, as substituted, would permit a voter to receive a paper receipt that proves they checked in to vote at an election. That's all it is. The idea for this bill was brought to me by a constituent. The constituent stated that although she had not missed an election in more than 15 years, neither her county clerk nor the Secretary of State had a record of her voting in 2 important elections. There was just no record. Because there's no other way to verify a voter's participation in an election besides these records, the constituent was left with no further avenue to investigate the discrepancy and was left believing her votes did not count. I learned an important fact while working on this bill. The data that the county clerk and Secretary of State have is not a record of your ballot submission. What most of us think about as our vote, the data they have is a record that you checked in to the polling place and received the ballot. This is by design. Our democracy relies on complete privacy and secret ballots. We do not want anyone besides the voters to know who they actually voted for. If you have any questions about the intricacies of running an election and the entire quality, assurances, and processes, please ask the expert witness. I've already told you more than I know, but understanding it's about election workers that have to deal with check-in and errors and with flyers. People who check in to vote and get a ballot but never submit the actual ballot. I filed my bill, and I feel that this bill is important to accomplish. There is no voting system that prints a receipt associated with the ballot submission. After learning the difference between proof of check-in and proof of ballot cast, I pivoted in the committee substitute to require a paper receipt to prove the voter checked in to vote. The Secretary of State certifies electronic devices to accept voters. The check-in equipment, as substituted for my bill, directs the Secretary of State to only certify electronic devices capable of providing a paper receipt to voters, and only the voter. The paper receipt would be a lot like, you see those stickers that say, I voted, right? When you walk out of a voting booth. Except it actually proves that you were there. Not just, hey, here's a sticker, you put this on, say you voted. Where a sticker is just for bragging rights, it would give the voter more confidence that their check-in was properly recorded and save voters in the future from experiencing the doubt my constituent is facing. I work closely with the Secretary of State and other stakeholders on this committee sub, and I hope you will join me in this very small fix that will have a big impact on the confidence that voters have and that they will have once they have actually voted. Members, I'm happy to answer any questions, and Chairman, I respectfully request a right to close.
Thank you, Chairman Garrett. Members, any questions? Yes, sir.
Representative, really quickly, I looked at your fiscal note and it says that there's no significant fiscal implications, although I have received some calls from my counties out there thinking that they're going to have to get new voting machines.
I'm sure you have.
And so how does your bill take that into account, let's say, because when they have limited resources, they can't just go out there and get new voting machines.
Are you suggesting that the county send them out a letter? Because if nobody's asking, what difference does it make?
If nobody's asking.
Well,
No, nobody's asking what, I don't follow you.
well, the question you're asking me, I don't understand your question.
Sorry. So I'm getting calls from county election administrators thinking, does this mean, there's a number of bills that they have raised concerns. And so does this mean that there's going to be new voting machines that they have to acquire that do print out those receipts?
Oh,
Or
no.
could it just be something similar to that?
Here,
that sticker where, hey, you
so-and-so,
voted.
Eddie Morales voted today, or you voted. Doesn't say who you voted for, doesn't say what you voted for. It's just a verification that you can have that shows that you indeed voted, because some of these folks had nothing.
I hear you.
That's it.
So you're helping me here, because then I can turn around and tell my elections administrators in the 11 counties that I represent that they don't have to buy new machines.
No.
That all that is required is something similar to a small sticker that would just conform with, you voted on this particular day, and that's it, not who you voted for, and not an actual receipt from the machine that they voted in.
Well, let me just say that my chief just handed me a note that says, in answer to your question, no, the current equipment should be adaptable.
Okay, maybe it's I'll ask the resources.
Yeah.
Thank you. Thank you.
Probably a good idea.
Members, any other questions of the chairman? You're
Chairman, with that,
request to reserve your right to close. You just
Yeah.
hold on, and we're going to call Christina Atkins,
Oh, okay.
our resource witness.
Great.
The chair calls Christina Atkins. She is here on behalf of the Texas Secretary of State's office and neutral on the bill, correct?
Yes, sir.
And so I'm reading this committee substitute. It says that the Secretary of State may not certify a device described by this section unless the device produces a paper receipt that provides a voter the information necessary to verify the voter's participation, et cetera.
Yes, sir.
Can you give us some indication as to whether or not that's currently possible?
Sure. So in the filed bill, it was referring to your electronic voting system, the one that the devices that you actually vote on, where you get your ballot, you cast your ballot. In talking to Representative Guetta's office, what we worked on was shifting that to a different part of the election code. So we're not talking about the voting equipment that people vote on. What we're talking about are the electronic poll books, the check-in devices. When you first go to a polling place to vote, if most counties use electronic poll books to check you in, those are not connected to the electronic voting system. So it's the check-in device, it's the check-in record. It's in the past, it would be like the form that you sign when you come into a polling location. So this is shifting that requirement to print a receipt to that device, not your voting system equipment, which has much stricter federal and state certification guidelines, which with the filed bill would have required new equipment, and that's probably why, Representative Morales, you were getting those calls on this. With this bill, it still would require a modification to the software for the different vendors that are used for the electronic poll books, and in some cases may require that they purchase printers, like smaller printers to print receipts from. Far less of a cost than if you were modifying the electronic voting system itself.
I have a number of counties that don't actually use anything electronic. When we go up there, I give my voter ID card, and they have still those forms where everyone's in the register, and they look you up, and they just put a little check mark. What's the process in those situations?
So this would not provide a process by which those counties that don't use an electronic poll book have to provide a receipt. But the difference is, when you're using the hard copy paper check-in process, you as a voter are signing it next to your name. Your name is going to be printed on there, you're signing on there. So there is a hard record that they can go back to if there's a dispute as to whether or not you voted. That paper record already exists. With the electronic poll book process, for many counties where it's all maintained electronically, if they check in the wrong voter or if they make a mistake in the processing, it may not retain that information. If it doesn't retain it, there's no hard copy record to go back to. That's why, my understanding is the intention is that you would have a receipt that you could walk away with.
And this bill would not obligate, for example, those counties that don't have electronic voter records to have to update to an electronic.
I don't believe that this bill creates an obligation for them to procure electronic poll books if they're not already using them.
Or procure or disseminate a receipt.
No, I don't believe that. No, this bill does not make that requirement that in those situations, when you're not using an electronic setup, that you have to provide a receipt. Since there's already, My understanding is the intention is that there's already a paper record there that they can go back and refer to.
Got it. Giving me the ammunition to go back to. Thank you.
Yes, sir.
Do the electronic poll books that we have now have the printable option? Did you say that?
We have 8 vendors in Texas that provide electronic poll books that are certified and provide electronic poll books to counties. They can procure, whichever one they would like. There are some of the vendors that actually have printers, and so they already have some kind of configuration where this is possible. The other vendors would have to make some changes to their system, but e-poll book changes, software changes are much easier to make. And so provided we're giving them enough time, those are things that can be modified and we can
You don't think we require a hardware update, though? So maybe a printer?
With the exception of maybe purchasing a printer.
Okay. Thank you.
Members, any other questions? Thank you, Ms. Akins.
Yes, sir.
Okay. Now, we have 8 more witnesses in connection with what is a very straightforward bill. And we've had some very good testimony from the Secretary of State's office. All right, so before we all get up here and pontificate about that, I'm hoping everybody will keep that in mind. And with that, I will call Bill Sargent.
I was opposed to the bill. I would like to change it to being on the bill, having heard.
Thank you, Mr. Sargent. Hold
Sure.
on just one second. I show you as Bill Sargent here on behalf of yourself and on the bill, is that correct?
Correct.
Go right ahead.
I'm assuming that most of you have never worked an election before. I don't have that experience. I'm familiar with the Hart Intercivic system, not ENS&S, but there's a real simple way of doing it. The way the process works is you sign in, if you're using an electronic poll book, you sign in and you get a slip of paper that says, what your ballot style is, your name and all of that, and has a barcode on it. You go over to the controller and they scan it. And when they scan it, it gives you an access code. That access code you take over to the voting machine and you vote on that voting machine. And then that prints out a paper ballot, you take it to the scanner and it scans it. That paper access code shows that you voted. So you don't have to do anything. You have that piece of paper. If you're using a Hart Intercivic system, you don't need anything further. No changes are required because it shows the precinct you voted in and it shows you your access code number. That's all you need. That proves that you actually voted.
All right, thank you, Mr. Sargent.
But one other issue, however, is this, and that is that if there is a problem between the actual sign-in getting recorded at headquarters and the number of ballots cast, and they don't match because for some reason it didn't get transmitted, then you got a problem.
Well, that's a different issue.
Which
Members, any other
relates to
questions? Mr. Sargent? Thank you.
Sure.
Appreciate you. The chair calls Alan Vera. You are Alan Vera here on behalf of the Harris County Republican Party Ballot Security Committee, and you're on the bill, is that correct?
That's correct.
Go ahead, Mr. Vera.
I want to quickly reinforce the concerns that Chair Guerra has raised are real. In 2021, election integrity groups all across Texas did door-to-door canvasses of voters and asked, did you vote? The voters said yes, and they went to look them up in the voter rosters in the county and the Secretary of State, and the voters' names weren't there. That started all of this. There's a real concern among voters that my vote never counted. I can reassure you that at least in the Hart system, the access code does give the voter the receipt they need because it includes an access code and the ballot style number they were awarded. The only reason we are not for the bill is we're not sure what the impact would be on the other systems in the county. Thank you.
Thank you. Members, any questions? Thank you. Well, Mr. Vera, we still have some important questions that we need to ask of you. Would you mind coming back up here for just a second? I'm just saying, there's something really important we need to ask you about this.
Law enforcement.
That's right, that's right. Hey, listen here, folks. Happy birthday, Mr. Vera, yay.
Thank you.
Yes, that's right, that's right.
Fire alarms.
Happy birthday to you, happy birthday to you. birthday, dear Alan. Happy birthday to you.
Thank you for dinner.
Well, it's just all part of the show here in elections, folks. It's worth the price of admission, isn't it? Yeah. Yeah. Hold on. The chair calls Chris Davis. Yes, absolutely. That's a tough act to follow.
Very much, sir.
Is it your birthday today by chance?
It's not,
Okay,
unfortunately.
I should ask everyone. You're Chris Davis. You're here on behalf of the Texas Association of Elections Administrators, and you're neutral on the bill. Is that correct?
Yes, sir, that's correct.
Go right ahead.
It feels like my birthday because the committee sub is like a gift compared to the voting system Armageddon that we were facing with the original bill. So all we can say collectively for TAA is, whew, thank goodness. It was late breaking, the committee sub. We will make sure that your counties in our listserv and our communications know that this affects, has a lot smaller impact in terms of just the poll book. What the Chairman Guetta laid out in his layout cannot be repeated enough because we get a lot of calls from voters thinking, how can I prove that the results that I made, and can I see them included in our official results? And of course, there's that anonymity and secrecy of the ballot that must be protected. And they also think, or data requesters think, that if a name is on our voter rosters that we currently upload regularly, daily, nightly to the Secretary of State, that always precisely means that those are voters that have always cast their ballot. And of course, the chairman mentioned fleeing voters. So the clarification that he mentioned in his layout is very, very important. We will continue to express that to our voters, and we appreciate the committee sub.
Thanks, sir. Members, any questions?
Thank you, sir.
Appreciate you. The chair calls Sophia De Loretta Chudy. I don't believe she's here today, but I'll call it Sophia De Loretta Chudy. Sophia De Loretta Chudy. She is testifying on behalf of herself and showing her against the bill and not here. Susana Carranza. Dr. Carranza, I show you as testifying on behalf of yourself and against the bill.
Yes, and the sub is definitely much better. I don't oppose the idea of having a receipt to give the voter, but it's even with the sub, I think like having effective date in September, knowing that we have an election in November, it's problematic. I'm an election judge and that early voting deputy in Travis County, and our system, it's sort of set up that there is a printer, but there's still software changes that have to be verified and be done to fix that. And then having that for November, I think it's asking a little bit much.
Members, any questions? Thank you, ma'am. That's a good point. The chair calls Kathy Hagler. You are Kathy Hagler. You're here testifying on behalf of yourself, and you're against the bill. Is that right?
That's correct, sir.
All right. Go right ahead.
Okay, first I would say that ES&S does not issue an access code like the Hart InterCivic machines do, so you would have to find a way to make that work for them. I'm also concerned that a paper receipt could be used to pay people for voting. Bring in your voter receipt and get a free ice cream cone. The union wants to know if you have your paper voting receipt once they know that these things are out there. I would not like there to be something that proved that you voted, but here's the question that I would have. If you give me a paper receipt, does that change my voting record? Is somebody going to go back and say that I voted at the last city council election because I have a receipt? And how does that affect the reconciliation? At the end of the night, we said this many people voted and this is how many votes there were, and everything came out even at the end. And if you come back a couple months later and say, oh, and add Kathy in, now your records are off by one. So this is going to mess up your election reconciliation if you're going to actually go change my voter record. That's my concern.
Members, any questions? All right. Thank you, ma'am. Chair calls Mike Brewster. Mr. Brewster, I show you're testifying on behalf of yourself and you're on the bill or neutral? Is that right?
Yeah, I am kind of neutral on this bill, but it needs a lot of work. I'm afraid I'm going to rain on the parade. This is not a straightforward issue. When we talk about amending section 122.001, we're talking about the voting machines, the equipment that records your vote. A voting system may not be used in an election unless the system preserves the secrecy of the ballot, is suitable for the purpose which it intended, operates safely, efficiently, and accurately, and complies with the voting system standards, is safe from fraudulent and unauthorized manipulation, permits voting on all offices. We're not talking about poll books here. We're talking about the electronic voting systems. And when I read this last night, I read it initially. There are two issues here. One of them was described earlier. We have situations where voters know that they voted, and when we canvass later, they're not on the voter rolls. So that's the situation that these gentlemen and people talked about earlier. There's another situation where people out there want a receipt, a ballot stub that can trace their ballot. And there's some language in here that is concerning there, because it says the voter's participation in the election is recorded accurately. Okay, we are talking about the voting system that records your vote. The voting system recorded your participation accurately. So now we're talking about, did we record your vote accurately?
Right.
There are people that want a voting stub that can trace their ballot through the system to be able to see that their ballot was counted correctly. And actually, the way this reads is more in line, that's more in line with what I'm seeing in this statement than the indication that, yes, I checked in on the poll book, I was here, and I've got a receipt that says that I did participate in the election. Yeah, this is way more complicated than.
All right. Thank you for your points, Mr. Sturgeon. Members, any questions? Thank you. Very good points.
That it?
That's it. Thank you. The chair calls Ed Johnson. Democrata's not here.
Sorry, it's talking to you.
No, it's all right. Yeah. That last one was. You're Ed Johnson. You're here on behalf of yourself, and you are against the bill. Is that correct, Mr.
That is
Johnson?
correct.
Go right ahead.
I think it'd be great if this bill was rewritten into a hybrid system. The HART voting machines already have what they call an access code that has the date you voted, the precinct you voted in, your ballot style. So it's already giving every voter a receipt, as you heard earlier. The ES&S systems do not give this receipt. And the easiest change to be made would be at the electronic poll book if they are using them. To make a change to an electronic voting system is a minimum of 2 years. You got to go through a 2-year certification program to make changes to the voting system. So that's i.e. this bill would take effect September 1. There is not time in here to make a change to any electronic voting systems, which I know a sub is correcting. But even the same, I actually helped develop the electronic poll books that Harris County used, and that was over a year process, and there are great complications there too using electronic poll book, because 90% of the poll books used are an iPad. And if you look at your iPad, you don't have a printer port cable on it. So you got to use a wireless printer on it. And we tried that in Harris County and had great complications with it accidentally linking to other printers in the building or getting them linked to other systems. So there are a lot of complications here. I would think that you want to do this as a pilot program first to work the bugs out, and then maybe make it a hybrid, because HART already does it. It's just ES&S that needs to, equipment that needs this, and the electronic poll book is definitely the easier one to change than the election system.
Thank you, sir. Members, any questions?
Thank you.
Thank you, Mr. Johnson. Chair calls Laura Presley. You've been sitting there very patiently tonight, Ms. Presley.
Yes.
You're here through Texas elections, and you're neutral on the bill, is that correct?
Yes, thank you.
Go right ahead.
Let's kind of walk through this logistically. For example, ES&S, which is about 100 counties around the state, has their e-poll books connected to the internet, and that e-poll book is connected to, and I'm going to disagree with Ms. Atkins as her statement may not be entirely accurate. The ES&S poll book, the poll book, is connected to the voting system component, the express vote printer, the express vote card printer, that is a certified voting piece of equipment. You can look on the Secretary of State's website and you will see it's a certified piece of equipment that is either wired connected to the poll book, that is internet accessed, or it is Bluetoothed to that poll book. So that's not entirely accurate, and I raised that to the Secretary of State last week. Now you would have to have the ES&S poll book connected to a separate printer at every check-in computer so that it's not connected to that original express vote printer. The hard intercivic problem is your access code that's printed should nowhere be connected to your name. And if we're proposing to connect the name to the access code in the HART system, now you have potentially violated the secrecy of the ballot. So for HART, you would have to have, again, a separate printer or a separate printed piece of paper that's not connected to or associated with that access code. I think this is not as simple as it seems, and we may need to reconsider the secrecy concerns with the HART, and then the ES&S will need a completely separate printer.
All right. Thank you, ma'am. Members,
Okay.
any questions?
Any questions?
Thank you.
Thank you.
I appreciate it. Is there anyone else?
Anyone else? Yeah, it's just not refreshed.
Is there anyone else who wishes to testify on, for, or against House Bill 3732? If not, the chair recognizes Chairman Guerra to close on House Bill 3732.
Chairman, and the members, forgive me. I've been experiencing a bum leg lately, so
It's all right.
anyways,
Can I
go
ask
to
you a
San
question?
Antonio tomorrow and check it out.
Can I ask you a question real quick?
Yes.
On your committee substitute, it says here that there's a receipt that provides a voter the information necessary to verify the voter's participation in the election is recorded accurately, and the voter information database is maintained by the county and the Secretary of State. Did you mean to say that the fact that you voted on, and on what date you voted and when you voted was recorded accurately? Or did you mean to say that you wanted some receipt that says how you voted?
No. The intent of this, and forgive me if it's being misinterpreted like that. I didn't want this bill to be that complicated. Just I had a very, very frustrated constituent and was very concerned, and I've heard from some others. I voted, but I got no way to prove I voted.
Right.
That's it.
Right. Okay, that's what I thought that's what you were looking for. I'll tell you what, would you do me a favor?
Yes, sir.
Would you work with the Secretary of State's office on how we might work on that to make sure that we
Indeed.
pull it off? And here's the other part of this, and I don't mean to interrupt your closing statement, but I was just going to say, if you want to talk to her about the possibility of maybe, and I think Mr. Johnson's point's well taken about a possible pilot program or something to that effect, so that we can kind of make sure that we can look all around the corners and don't have an unintended consequence. I think that'd be a good idea.
Indeed, and I,
Would you talk to her about that in kind of a?
Indeed,
quickly? Okay.
indeed.
If y'all will do that, did you have a statement that you wanted to make?
well, the only statement I wanted to make before I laid the rest of this bill out, or 3732, is Representative Morales, I personally have not encountered, I've always, since I was a child, we always had electronic voting machines. I was not aware of situations like yours, and I didn't mean to make light of it, but it's, I've had numerous people complain about that. And personally, after I vote, I'm done, okay? But it's a concern to some of my constituents. So that's all I wanted to say. And Chairman and members, with your permission, if I could lay out.
In just 1 second.
Yes, sir.
I think Representative Morales has a question for you.
Not a question so much as I understand where you're going. I like your bill. I just think that we need to tweak the language, and I'm available if you want to work with it, just to make sure that we effectuate what your constituent was requesting.
Yeah, we're willing to work with anybody. The intent was just to take care of some of the constituents' concerns.
Yep.
That's all I wanted to do. We don't want to turn this into an expensive proposition at all. Just trying to make ourselves available for the voters and constituents.
Thank you, Chairman. Is there any other questions? If not, the committee substitute is withdrawn. If there's no objection, House Bill 3732 will be left pending. I hear none. The chair will, yes, he did.
You said I close.
I'm sorry.
Do you close?
Okay, yes, indeed, I close.
All right. Well, then we're going to leave it pending. I hear no objection to that. House Bill 3732 is left pending. The chair lays out House Bill 3736 and recognizes Chairman Guerra to explain that bill.
Thank you, Chairman and members. Again, it's been a long day, I think, for all of us. Thank you for allowing me to lay out House Bill 3736. I'd like to give some background in the context of this legislation. This is a simple study bill to evaluate the accuracy of and efficiency of transferring data into the Secretary of State's election participation database. It's based on the same experience my constituent had that I previously described in HB 3732 layout. One theory about why the record of the vote is not in the voter database is because counties, many counties, and the Secretary of State maintain different databases. I was surprised to learn that. One theory, quite frankly, I think probably what the biggest problem is, there's a technical glitch preventing an accurate data transfer. And again, as I see it, it's got to be a technical glitch. I don't think this is on purpose by anybody for any purpose or any reason other than it's a technical glitch, and we all know what those are. While working on this bill, I learned that each county decides if it wants to maintain its own voter participation database and synchronize their database with the Secretary of State's database, or if they want to port directly into the Secretary of State's database. The purpose of my bill is to evaluate the transfer, storage, and accuracy of voting records through a study of the statewide voter information database conducted by the Secretary of State. This is simply a quality assurance, quality control bill about some of the most important data we maintain, election data. Members, I'm happy to answer any questions. Again, we're just trying to help the public out there and the constituents, and also make sure everybody feels very comfortable knowing that they did indeed vote, and try to fix any of these glitches. And I respectfully request the right to close.
You bet. Members, any questions? I think we just got 2 or 3 witnesses. The chair is going to call Christina Atkins. Ms. Atkins, you're here on behalf of the Texas Secretary of State's office, and you're neutral on the bill, correct?
Yes, sir.
Have you had a chance to review this?
I have.
Do you have any issues with conducting a study on this accuracy, or are there any issues with this bill?
No, sir. You know, we're happy to do whatever we need to do to get the legislature accurate information on this.
Members, any questions? Ms. Atkins? Oh, go right ahead.
I noticed the fiscal note, and there's no fiscal implication, so it could be absorbed under the existing.
Yes. As with most studies, yes.
All right, thank you. Appreciate that. If there's no other questions, the chair calls Alan Vera. Mr. Vera, you're here on behalf of the Harris County Republican Party Ballot Security Committee, and you were for the bill, is that correct?
That's correct.
Go right ahead.
We think that Chairman Guerra and we have been talking to the same voters because we've got the same reports to us. There are discrepancies between how the voter's name appears in the county database versus the Secretary of State database, or whether the voter appears in both, and depends on what time of year it is. Frankly, it just shouldn't be happening. It may be a technical glitch. We hope that's all it is. But it is time to take a look to see why our voters keep seeing discrepancies between two different data sets that should be matched. Recommend the committee report this bill, HB 3736, favorably to the full House. Thank you.
Members, any questions? Thank you, Mr. Vera. The chair calls Bill Sargent.
I will not need to testify. We'll take your time.
Are you sure?
Yeah, because Alan's answered all the questions.
Okay, thank you, sir. All right, so we're going to mark you down as neutral on the bill and not testifying.
That's correct.
Okay. Is there anyone else who wishes to testify on, for, or against House Bill 3736? If not, the chair recognizes Chairman Guerra to close.
Chairman, I have to thank you for your professionalism and taking it, especially how all of this is meant, that what my proposed bills are. And again, we're here to work with all of you or any of you at your discretion. And I hope you just appreciate the fact that this is a nonpartisan issue to me. All I just want to do is help out the constituents. That's it. Thank you very much. And with that, I close.
Members, any questions of the chairman? Thank you.
Thank you.
And I appreciate you, sir. If there's no objection, House Bill 3736 will be left pending. The chair hears none, and House Bill 3736 is left pending. We want to go to Phillips. Let's see, how many does Phillips have? Two bills? The chair lays out House Bill 223 and recognizes Representative Cortez to explain the bill.
Thank you, Chairman. Appreciate the opportunity to lay out this bill. House Bill 223 would require precinct chairs to include an email address, phone number, or both on their applications. In the 2020 to 2022 cycle, the Bexar County Democratic Party received 444 filed applications for precinct chairs, and nearly 20% had no contact information aside from a mailing address. With this change, voters will be able to reach their precinct chairs and be represented adequately. We look forward to working with the committee members to see this legislation through, and I respectfully ask for your consideration, and I reserve my right to close.
Thank you, sir. Members, any questions? The chair calls Christina Adkins. You are Christina Atkins here on behalf of the Texas Secretary of State's office, and you're neutral on the bill, that's correct?
Yes, sir.
Now, I'm looking here at HB 223, an application for a place on the ballot as a candidate for precinct chair must in addition email address, telephone number. Okay. First of all, is this something that's workable from your perspective?
Yes, sir. We'd have to modify the application form just to make it clear that those boxes, they have to provide either email, phone number, or both, but that shouldn't be hard to do.
Is there anything about providing that kind of information which violates any federal or state law that you're aware of?
No, sir. I mean, certain confidential information is protected under the Public Information Act, but, things like email address, in certain circumstances, it could be protected, but I don't think that I'm not aware of anything that would specifically impact this.
Okay. Members, any questions? Thank you, ma'am. Yeah. The chair calls Rose Marie de Hoyos. Rose Marie de Hoyos. Oh, there she is. Sorry. Ma'am, would you pronounce your name for me?
Rosemary De Hoyos, yeah, you're correct.
Ms. De Hoyos, thank you for being here this evening. I understand you're here on behalf of the primary manager. You are the primary manager and precinct chair for Bexar County Democratic Party, who you're here to testify
In favor of the House Bill 223.
And you're also here for yourself?
Yes.
And you're,
Okay, as I am here to testify for House Bill 223, and I'm a little bit nervous, I don't know why. But anyway, we find it very, very necessary that the applications, when you file, that they should have some contact information there to help the constituents as well as our office to be able to contact them for any updates, any problems, or any information, and especially for the constituents, because as for precinct chairs, if they don't know how to get in touch with their precinct chairs, why are they precinct chairs? And all we want is to take off optional on there, because it has optional on the phone number. And if you could make that correction, that would help us tremendously, as well as the Secretary of State when they're trying to get a hold of people as well. And it also applies to the applications for the candidates, because sometimes we get one or two candidates that refuse to give us information, and then we can't call them back and if we have any corrections or anything on their applications. So we find it very, very necessary to do that. Okay?
thank you, ma'am.
Thank
Members, any
you.
questions? The chair calls Gloria Gutierrez. Good evening, Ms. Gutierrez. I show that you're here on behalf of the Bexar County Democratic Party and yourself, and that you're for the bill. Is that all correct?
That is correct.
Go ahead. Thank you.
Yes, well, I have worked with the primary election in the past, and I am so glad to have this bill here. It's time to make changes on the current precinct chair application. We need more information from the candidates in order to better serve them. We need to require a public email address and a phone number. This is the application. And right here, under public email address, it says if available. And then under telephone contact information, it says optional. And we have candidates who actually refuse to answer on both of them. And so we're left in a quandary, as to how to contact them, because it really creates a problem. There are times when we really have to get in touch with the candidates, especially when they send in their applications that are handwritten. Sometimes we can't read the handwriting, so we need to call them for clarification. There have been times that the spelling is in question and we have to call for clarification. We want to double check that the name that they want on the ballot is absolutely correct. And so there's many ways or many instances where we really need to contact them. And without a way to communicate with them in a timely manner can create a real problem for us, especially in meeting deadlines. So we need your help in changing this. In this day and age, with everything moving so fast, we absolutely need email addresses and phone contact information. So I'm asking you all to please help us do a better job of serving our precinct chair candidates. Make providing email addresses and telephone contact information mandatory on the application. Thank you.
Chairman Capriglione.
Thank you, Mr. Chairman. I just have a dumb question. What if their phone number changes?
Well, then, of course, we would have to contact them. They would have to contact us. Believe me, there were times when we had to go to their houses to go and to track them down.
Well, I guess I'm wondering, are they still qualified precinct chairs if they change their phone number?
Oh, yes. It doesn't invalidate their application. We just need to make sure we have some way to contact them.
And do you check, you're going to check to see if that's the right number? In other words, if they put down any number, is that okay?
Well, of course not. Of course not. But, when we do need to get a hold of them, we will find out if it's a valid number or not.
Okay.
Yeah.
All right.
So we're working on it. But we need your help. Thank you.
Any other questions, members? Thank you, Ms. Gutierrez. The chair calls Ed Johnson. Mr. Johnson, I show you're testifying on behalf of yourself and that you're against the bill. Is that correct?
That is correct.
Go ahead.
Okay, so this bill requires more information to apply for a volunteer office that's a party office than you guys had to apply for a regular office. You're not required to give your cell phone or email address when you put on an application. This is an open record application too that anybody could get access to. My wife was precinct chairman, and in 2020, they managed to get a copy of, she's also a election judge, get a copy of the phone numbers from the county through open record request. She had to change her cell phone number that year because she got harassing calls all day and all night long. This is not information for a volunteer. For a lot of these are older citizens that don't want to be harassed all the time by having to give their personal information. And no other office is required to do this. Why are we going to require these volunteers to give this kind of information? This is a party issue. If the Democrat Party can't find their volunteers, that is their problem. We shouldn't make this a state issue and make it a higher bar to jump over to become a precinct chairman than what y'all did to have to run for office. That's
Thank you, sir. Members, any questions? All right, thank you, Mr. Johnson. The chair calls Mary Ann Ramos. Good evening, Ms. Ramos.
Good evening, Mr. Chairman.
Now, you're
members.
also here on behalf of the Bexar County Democratic Party and yourself, is that
Yes,
correct?
yes, sir.
And you're for the bill?
I am for the
Are
bill.
y'all having a hard time getting in touch with people down in Bexar County?
Apparently. I'm also a deputy chair for the Bexar County Democratic Party as County Commissioner Precinct 1. And one of my duties is I have so many precinct chairs under our precinct that we have to contact them in order to, give them information that needs to be pertinent to candidates and to also to, for them for meetings and also for, propositions that are going on in elections, during elections, to give them, information on candidates and also, to get information to them so they can pass it on to their constituents. We are precinct, I'm also a precinct chair. We're our precinct chairs, and our duty is to keep our constituents up to date on everything that's going on, the information that they need to be able to vote, know the candidates. We give them information about the candidates and give them as much information as we can, and, for them to pass it on to their constituents. One of the duties for our precinct chairs is to inform all the constituents and to block walk, all of their precinct to make sure that they're getting all the information that they need in order to make, a ballot decision on voting. Our thing is to vote. So I feel that if you are an elected, and they are elected officials also, because they run to be a precinct chair, besides putting the information on their ballots. So I feel that we need to be able to get in contact with them, to give them information. And a lot of our precinct chairs appreciate us calling them and reminding them of different things, of meetings and things that are going on. But some of them, they don't put any information whatsoever on there. And then their people are calling us in those particular precincts, they want to find out, what's going on, what information they can get from the Bexar County Democratic Party. In this instance, we have no way of contacting them.
Okay.
So either we have to do it by mail carrier or, or go to their homes, like Rosemary mentioned.
Sure. Members, any questions? Thank you.
Thank you.
Ms. Ramos. Is there anyone, ma'am, Ms. Ramos? Ms. Ramos?
Yes, sir.
Can I make sure, we're trying to make sure we're staying on top of things. Just don't want to confirm, you're here on behalf of the Bexar County Democratic Party and yourself, is that correct?
Yes, correct.
Okay, thank you.
Thank you.
And you're for the bill?
Yes, I'm for the
She's
bill.
making sure I'm straight about that.
Got to get that straight.
All right. Is there anyone else who wishes to testify on for or against House Bill 223? If not, the chair recognizes Representative Cortez to close on that bill.
Thank you, Mr. Chairman, for the opportunity to lay out this bill. I would like all of y'all's cell phone numbers and email addresses too, while I'm up here, just to make sure we have your contact information. I appreciate the opportunity, Mr. Chairman, to lay out the bill. I look forward to working with y'all, and I do close.
Thank you. Members, any questions? All right, thank you. If there's no objection, House Bill 223 will be left pending. I don't hear anyone objecting, so House Bill 223 is left pending. The chair lays out House Bill 315 and recognizes Representative Cortez to explain the bill.
Mr. Chairman, Vice Chair, and members of the committee, thank you for the opportunity to lay out House Bill 315. The current application for ballot by mail lacks clarity in the optional section for an applicant's email address and phone number. Although providing this information isn't legally mandated, the contact information is essential to assist the county election office when reaching out to applicants if there are issues or questions regarding their mail ballot application. Application errors impair Texans' ability to engage in the voting process. House Bill 315 would require the Secretary of State to draft a statement to be displayed in the application for ballot by mail, describing the benefits of providing their contact information, explaining how this information can help the county elections office. The statement will provide clear incentive for the applicants to fill this section out. House Bill 315 will also ensure that this contact information remain private and unavailable to the public. Not only will this alleviate the burden on the county elections office, but also ensure more applicants can cast a successful ballot. Look forward to working with you, Mr. Chairman, and members of the committee on this bill, and I reserve my right to question.
Members, any questions? The chair calls Christina Atkins. Ms. Atkins, you're here on behalf of, very dutifully, on behalf of the Texas Secretary of State's office, and you're neutral on the bill, that's all correct?
Yes, sir.
Now, I'm sorry, I'm missing this. What information is it that he's wanting on the statement?
So it's a statement informing the applicant that, I think it's specifically referring to phone number, that by providing that phone number, it's an optional category on the application for ballot by mail form, but providing that number could be helpful because it can give the early voting clerk the ability to contact them with questions or even notify them if they need to correct anything.
Now, is this the fabled information that we've discussed before that goes on the outside of the envelope?
No, sir, we're talking about the application form.
The actual application
yes,
form?
equally crowded,
Okay.
yes.
Right,
But we can, I'm sure we can make it work.
you can.
Yes, sir. I think we're going to actually engage with there's an organization out there, Center for Civic Design. We're actually going to try to work with them to see if there's ways we can maximize our use of space on our application forms and envelopes.
Okay. All right. Members, any questions? Thank you. Chair calls Rosemarie De Hoyos.
I no longer wish to speak on the matter, thank you.
Have we scared you? You were nervous before. I don't want you to be. All right. Well, I'll tell you what we're going to do. Are you still for the bill, Ms. De Hoyos?
Yes.
And you are here on behalf of the Bexar County Democratic Party and yourself, is that correct?
Right.
You're for the bill, but you're not testifying. Is that correct? Okay, thank you.
Thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 315?
Ed Johnson.
All right, Mr. Johnson. I'm so sorry, I missed him.
I just hit the button fast enough. I'm sorry.
No, it's all right. You're, Ed Johnson, you're here on behalf of yourself and you're for the bill, is that correct?
That is correct. This
Go
would be, working ballot by mails, this would be a very helpful tool to have the phone numbers on there. When voters a lot of times have moved, i.e. they were a house, they moved to a nursing home, they've changed their address, they end up being put on suspense, they get a statement of residence that's required to vote, they didn't return that with their ballot. Having the phone number allows you to call the voter and say, hey, we need you to fill that out and send it back. Without that statement of residence, the ballot does not get counted. So they lose their vote. So this helps, and when you have a very tight window, to be able to help very quickly correct a mistake so that you can count the mail ballot. The phone number under election law, in this case, is protected from Open Record Act, so it's safe.
Members, any questions? Thank you, Mr. Johnson. Is there anyone else who wishes to testify on, for, or against House Bill 315? If not, the chair recognizes Representative Cortez to close.
Anyone else? All right. I'm good, Chairman.
Are you wanting my phone number again on this, or?
Your email address,
Yeah.
your Twitter handle,
That's right.
anything on the socials.
TikTok.
All the socials.
Right.
Thank you, Mr. Chairman. I do close.
Members, any questions? Thank you. If there's no objection, House Bill 315 will be left pending. Chair hears none. House Bill 315 is left pending. I think Mr. Toth is here. The chair lays out House Bill 5259 and recognizes Representative Toth to explain the bill.
Chairman, members, I've got a 10 a.m. version, I've got a 5 p.m. version, and I'm going to give you all the 11 p.m. version.
Oh, thank you.
In November of 2022, 17,672,143 individuals were registered to vote in Texas. The use of vital records ensures accuracy by the Texas elections. In December 2022 alone, 17,000 deceased individuals were removed. The interaction between the Department of State Health Services and other governmental agencies in ensuring accuracy of voter registration with respect to vital records is critical. Current regulations require the Bureau of Vital Statistics to provide the Secretary of State a list of deceased individuals. The Bureau of Vital Statistics does not supply the Secretary of State with unique identifiers necessary to accurately match death records and voter registration lists. That's what this bill corrects. This can lead to confusion and election in the elections administration. Consequently, dead individuals may be left in the rolls, or officials might unintentionally remove voters who did not die. So we want to get this right. The bill also amends the Health Safety Code to require death certificates to include, and this is what's critically important, the county where the deceased individuals died and the county of the last residence. As proposed, SB 5259 amends current law relating to death records maintained and provided by the Vital Statistics Unit of the Department of State Health Services. With that, I respectfully ask for the opportunity to close.
Thank you, sir. You have it. Members, are there any questions? Thank you. The chair calls Christina Atkins. Ma'am, you are Christina Atkins. You're here on behalf of the Texas Secretary of State's office, and you're neutral on the bill. Is that all correct?
Yes, sir.
Okay, now I'm seeing here that this bill asks the Department of State Health Services to implement a method to provide this death information to you, to your office, to assist in maintaining the statewide computerized voter registration list under Section 18 of the Election Code.
Yes, sir.
Okay. Can you give us a little backdrop on that? Would that be helpful? Is that something that y'all already do? Is it something you don't do? Is it, kind of give us some information on this?
Yes, sir. We currently have a process in place, and so we are already getting this information, but this definitely codifies the process and makes it very clear what data points we need to receive.
Okay, and you get this information from the Department of State Health Services?
From Vital Statistics, yes. Mm-hmm.
Okay. And so what this would do is just codify and make sure that there's some type of efficient and effective method
Absolutely.
to be able to do that. Is there anything else about this bill that causes you concern or that you like, or are there any comments that you want to make about it?
No, sir. I think it's pretty straightforward.
Members, any questions of our resource witness? Thank you. The chair calls Mike Brewster. Mr. Brewster, you are here on behalf of yourself and you're for this bill, is that correct?
That's correct. And I'll keep this brief. We've got several bills tonight that deal with voter registration issues. I typically work on the periphery of that, but that's one of the most important issues that is up in the state right now. There needs to be a lot of correction in this. This helps guide and direct. I think we're doing some good things tonight, and I'd encourage that this go forward.
Yes, sir. Thank you. Members, any questions? Thank you, Mr. Brewster. The chair calls Robert Green. Mr. Green, I see you're here on behalf of the Travis County Republican Party Election Integrity Committee for Legislation and yourself, and that you're for the bills.
Yes, sir, that is correct.
Go right ahead.
I mean, I want to say, why is this not intuitively obvious method to avoid someone being able to vote for a deceased voter? Cooperative communication is absolutely necessary to keep the voter rolls clean, or cleaner, by removing those who cannot cast a ballot due to being dead. Did have one comment about this. They were talking about the county where they died notifying someone about their death. I had a situation, my father lived in Aransas County, but died in San Patricio County in a hospital. If they had just notified San Patricio, there wouldn't have been any record of his voting there because he didn't. There needs to be some way to notify the county where the individual's residence was and where they had been voting for some time.
Points well taken, Mr. Green. Anybody have any questions of Mr. Green?
Really quick comment.
Chairman Capriglio.
Thank you, Mr. Chairman.
Yes, sir.
So I don't know if you heard the part where we are already doing this. So it is intuitively obvious, which is why we're doing it.
Okay.
Okay, thank you.
Thank you.
Thanks, sir. If there's no other questions to that witness, the chairman's going to call Alan Vera. You are Alan Vera. You're here on behalf of the Harris County Republican Party Ballot Security Committee, and you're for the bill. That's all correct?
That's all correct.
Have you anything additional to add to the discussion on this?
Just a little bit. Using the Aristotle database, which gathers and reports deaths from Social Security Administration records, on November 8th, 2022 in Harris County, there were 64,539 dead people still on the rolls. Of that group, 2,311 were still active and voted. The Aristotle database is very expensive, or we would have tried to gather data from other Texas counties, and we certainly welcome any of the members to donate to our cause to be able to buy more data. Members, there's no excuse for this kind of discrepancy in our voter rolls. You can't prosecute dead people for voting illegally, either via felony or misdemeanor. And with cameras outlawed in our polling places, it's impossible to identify who's voting in person in the name of deceased people. The bill addresses a very real and significant problem with our voter rolls. We urge the committee to report House Bill 5259 favorably to the full House. Thank you.
Thank you, Mr. Vera. Any questions? Mr. Vera, thank you.
Thank you.
It's still his birthday, folks. And he's with us. The chair calls Andrew Hendrickson. Andrew Hendrickson. I think Mr. Hendrickson's not, I don't see him. Andrew Hendrickson, I show him as testifying on behalf of the ACLU of Texas and against HB 5259 and not here to testify. The chair calls Ed Johnson, who is here. Yes, sir. You are Ed Johnson testifying on behalf of yourself, and you are for HB 5259, is that correct?
That is correct.
Go ahead, sir.
Okay, so I used to be director of voter registration in Harris County, and when we were doing this, let me explain the process, because you are correct that the state's been currently doing this. The state gets the list from the Vital Statistics Service. They match it up against the voter roll. If they find a hard match, name, birth date, Social Security number, they automatically delete them. Unfortunately, the data in the voter registration database is not very accurate. There are a lot of typos and things like that. So when it's a weak match, they don't get an exact match. They actually send this list to the county, and the county is supposed to mail that voter or that possible deceased person a letter. So when I was running voter registration in Harris County, we had 5 employees working on this to look these records up, mail the letters, process them when they come back. That was about $300,000 a year in salaries just for those. Then we were mailing, by the current estimates that you heard from Mr. Vera, there's about 26,000 deceased right now on the roll. So, that would cost $2 a letter because you had that outgoing and the incoming postage in there. If you do all the math, it came up, basically, it comes up to, if you do that and extract it to the whole state, that's about 135,000 deceased. It's about $2 million that's being spent on this, of people processing this and doing the mailing, when it could be simplified by just getting the data more accurate from the vital statistics area. If vital statistics, when the person is deceased and has the family members, they're processing that death certificate or helping getting the information on the death certificate, would indicate that they're a registered voter and their voter number, it'd be an exact match every time. And we wouldn't have to spend this $2 million on trying to determine if the person's dead. And I will tell you, mailing a letter to a deceased person is not a great way to get information. The replies you get are very strange. So that is not the best way to do this. It would be a lot more efficient, accurate, save $2 million to the county's cost by just getting the information correct on the front end.
Thank you, Mr. Johnson. Members, any questions?
Thank you.
Is there anyone else who wishes to testify on for or against House Bill 5259? If not, the chair recognizes Representative Toth to close on his bill.
Thank you, Chairman, members. This is not a partisan issue. And frankly, I'm surprised that the ACLU's attempt to make sure that dead people remain on our voter rolls, that they have rights for some reason. And given the numbers and the statistics that Alan Vera shared earlier, I've heard those statistics for years. And I'm shocked at the lack of urgency on the part of our Secretary of State here in Texas, that we not fix this. But this is your opportunity to help us take the next step. And I appreciate you guys. Long night. Appreciate your commitment to the state of Texas and getting this right.
Okay.
I close.
Thank you, Representative. Members, any questions? If not, House Bill 5259 is going to be left pending unless there's an objection. The chair hears none. House Bill, actually, did you switch it? Did I got it wrong?
No, you're good.
No,
Right here.
5259. There's no objection to House Bill 5259 being left pending. It will be left pending. At this point, the chair lays out House Bill 1299 and recognizes Representative Noble. Candace Noble to explain the bill.
Thank you, Mr. Chairman. I thought Human Services had the coldest room, but I think it may be this one. Pretty sure.
And warm hearts.
It is really cold in here. Thank you for giving me the opportunity to lay out House Bill 1299. The intent of this bill is to provide clarity that a ballot by mail carrier envelope is required to have an ink on paper signature. Additionally, we clearly state that a photocopy or electronic signature is not allowed, and if it's used, it is a criminal offense. We want to make every effort to ensure our elections reflect the will of the voters. By clarifying that an ink on paper signature is required, we take one more step toward ensuring the voter is truly the person casting the ballot. Requiring this measure will also assist the early voting ballot board or signature verification committee in completing their task of comparing signatures of a voter requesting the ballot by mail with the carrier envelope returned by the voter. This provision, of course, does not apply to someone who under current law uses an assistant to cast their vote. And I'm happy to answer any questions and reserve the right to close.
Vice Chair Beasley.
Just one quick clarifying question. Some people use like an ink stamp signature, some individuals
Yeah,
with disabilities.
that would not be allowed under this bill. I mean, that would still be around after your death, and so that's not something that would be acceptable.
Okay. I just, maybe we'll have someone from disability community talk about it.
Again, if this doesn't apply to someone who under current law uses someone to assist them to vote.
Okay. Thank you.
Members, any other questions? You're going to request to reserve your right
Yes,
to
I
close.
reserve the right.
Absolutely, and you've got it. Your request has been accepted, and the chair is going to call Christina Atkins. I have a method to my madness tonight.
Yes, sir.
You are Christina Atkins. You're here on behalf of the Texas Secretary of State's office, and you're neutral on this bill.
Yes, sir.
Now, I think we're back talking about this envelope.
Mm-hmm.
Okay.
Yes, sir. Yes.
All excited about it, and I know that we talked about the signature before. Do you have any opinion as to the viability of requiring it using ink on paper?
I mean, this is generally what the requirement is now. We've always said that it requires an original wet signature. If somebody's not able to provide that signature, then they can have somebody serve as a witness for them, which means they can make a mark. In some situations, that might mean they use a stamp, a signature stamp, but they would have to have somebody that witnesses that. So they are witnessing that that person makes a mark or is unable to sign. And I don't think this would change that process. In SB 1, I believe language like this was added with respect to the application for ballot by mail, but it wasn't added on the carrier envelope. And so if I remember correctly, this is just taking that same concept and applying it to the carrier envelope as well.
Members, any questions? Thank you
Yes, sir.
very much. Chair calls Michael Belsick, who I don't believe is here. Michael Belsick. I show him as testifying on behalf of himself and for the bill, and not here to testify. Sophia De Loretta Chudy. I show her as here on behalf of herself and against HB 1299 and not here to testify. The chair calls Robert L. Green.
Pass, Mr. Chairman.
All right, Mr. Green is here, but he is back here telling me that he's here on behalf of the Travis County Republican Party Election Integrity Committee for Legislation and himself and for the bill, but not wanting to testify.
Correct, sir.
Okay. Is there anyone else who wishes to testify on, for, or against House Bill 1299? If not, Chair recognizes Representative Noble to close.
Thank you, Mr. Chairman. I respectfully request passage.
Thank you. Members, any questions? If there's no objection, House Bill 1299 will be left pending. The chair hears none. House Bill 1299 is left pending. The chair lays out House Bill 3449 and recognizes Representative Noble to explain the bill.
Thank you, Chairman, and committee for giving me the opportunity to lay out this bill. In the Texas Election Code, every county has an early voting ballot board and may opt to also have a signature verification committee for the purpose of processing mail-in ballots. The code, however, does not give equal access to the same materials for determining if the signatures on the application and courier envelope are those of the voter, and does not require the signature verification committee to examine any known signature on file with the county election officers to determine if the signatures are those of the voter. Since voters' signatures may change over time, especially among the elderly and the event of a disability, it's important that all available signatures be examined to provide the voter every opportunity to show that it is indeed their signature. This is a best practice bill that clarifies and codifies uniform practices and procedures concerning processing early voting results by the Early Voting Ballot Board and Signature Verification Committee. This bill requires county election officers to maintain at least 6 years of signature images on file, and that can be the actual signatures, the originals, or in an electronic version, to assist the board and committee in determining if the signatures are those of the voter. For counties who do not currently store signatures electronically, this will go into effect for them, the storage electronically, for them only when they do their next software update to include that information. Happy to answer any questions and reserve the right to close.
Thank you, ma'am. Any questions? We will reserve your right to close, and the chair will call Christina Adkins. You are Christina Atkins here on behalf of the Texas Secretary of State's office in neutral on this bill. Is that
Yes,
correct?
sir.
Okay. Do you have any particular comments that you want to make in connection with this legislation?
No, sir, I'm happy to answer any questions that you all might have.
Okay. Members, any questions of Ms. Atkins? So on page 1 there, it talks about the general election custodian of election records. Are we talking about in each county? What, do you know what?
Yes, sir, we're talking about, it's typically going to be the county election officer in each county, so either the elections administrator or the county clerk, county or district clerk.
Okay. And so the idea is that they'll maintain these documents for 6 years, including copies of the applications for ballots?
Yes, sir. What I'm seeing here is that typically the retention period for election records is 22 months. What we're doing here is changing the retention period related to copies or images of the voter's signature. That's going to be extended to a 6-year period. So that's the first item. Beyond that, what I'm seeing is that all of those signatures that are retained on file have to be provided to the Signature Verification Committee or Ballot Board. And then at that point, when they're doing signature comparison, instead of just looking at the mail ballot application form and the carrier envelope, they're now also having to look at all of the other signatures that are on file.
Okay. All right. And make that comparison.
To make the comparison correct.
Okay. Members, any questions? Thank you, Ms. Atkins.
Yes, sir.
The chair calls Sophia De Loretta Chudy, and she's here. And am I pronouncing your name correctly?
No, but it's okay. No one does.
Would you pronounce your name?
Yeah, I will. Yeah, sorry, I was eating dinner in the other room when you called my name. I
all right.
sprinted. Yes, my name is Sophia Di Loretto Chetty, and I am against this bill, HB 1299. But my testimony is very brief.
Are you for or against the bill?
Against.
You're against the bill?
Against.
Okay, go ahead.
It's very brief. The requirement of ink signatures on the carrier envelope for the requirement for mail ballots would contribute, in my opinion, to discriminatory access to voters with disabilities, people who have a difficulty signing their name, holding pen to paper. Additionally, voters in jail or on pretrial detention who don't have access to ink, pens, or stamps. And then just as a young person,
And you are against HB 3449, right?
this was for 1299.
That bill's been closed and left pending.
Okay,
Oh.
let's start over again. That's all right, just to make sure we're correct.
We're on 3449.
Yeah, we're on 344.
Well, I'm against that one too, so.
All right. Well, hold on just one second before you get to it. So you're Ms. Chuddy, and you're here on behalf of yourself. You're against HB 3449.
Yes.
All right, now go ahead with your testimony on that bill, please.
Okay. Also, very brief. The preservation of voted ballots by mail enables more opportunities for untrained signature verification committees. A 6-year look back is dangerous, especially for voters that become eligible by disability or students out of their country who are likely to have changes and inconsistencies in their signatures. Again, as a young person, my signature changes literally every time I write it. And a lot of students specifically are ones who are voting for the first time. They're voting out of state. They're going to need to have that signature match. And I'm just concerned about those things. That's it. Yeah.
Thank you, ma'am. Members, any questions? All right. No, thanks. The chair calls Chris Davis. Mr. Davis, you're here on behalf of the Texas Association of Election Administrators, and you're neutral on this bill, is that correct?
Yes, sir, that's correct.
Go ahead.
Thank you, Mr. Chairman. TAEA is neutral on this bill, but has some concerns, primarily with the phrase, any known signature. That's quite a powerful and broad phrase that has extensive consequences. We can envision voters using this phrase in this bill that would necessitate 30, 50 signatures to be brought up, according to this bill, all at once on a screen. It would necessitate the scanning of paper combo forms that so many of our mid to small counties still use, not the digital ink that's already digitized, but actual combo forms that have wet ink signatures, and that labor within that 22-month retention period, because we shall produce any known signature, can be problematic and be a bit of a fiscal burden for small counties where they're required to produce so many signatures. The fact that this bill requires signatures to also have to display all these known signatures all at once, to my knowledge, we don't know of any software that does that right now. That's all I have to say, sir.
Members, any questions? Vice Chair Busey.
So what, I think you just hit my first question. Is there software available to handle this need? And
Not to my knowledge. We, in our county, have one, and it provides the signatures on the carrier envelope and the application currently, and then we can go one by one with past signatures, however many we have on file. But unless I'm mistakenly reading that bill requiring all displayed simultaneously, it could be 3, it could be 30, it could be 50 for one voter.
Now, having to find new software aside, would this have any impact financially on y'all to house this data?
It'll have impact on us to purchase software that can handle 30 simultaneous signatures. It'll certainly have an impact on smaller counties that don't do digital signature comparison currently. And software is mandated, as I read it, for every county.
Okay.
So yes, sir.
Thank you.
You have the bill in front of you?
No, sir, I don't.
That's okay. All right. Well, thank you. Members,
I'm
any
sorry.
other questions? Thank you.
Thank you, sir.
The chair calls Michael Belsick. Michael Belsick. Michael Belsick, I show him as testifying on behalf of himself and for HB 3449 and not here to testify. The chair calls Katya Arisman. Ms. Arisman, I see you're here on behalf of Common Cause Texas and yourself, and that you're against the bill. Is that correct?
Yes, sir.
Go ahead.
Awesome. Thank you so much. Well, thank you all for having this committee hearing. I know we're going late. I will try not to reiterate anything. One thing, as was just mentioned, is that this bill largely relies on counties that still use the antiquated form of a signature verification committee, which has been ruled by lower courts as being a plain violation of voters' constitutional rights when there's an absence of standards for signature review in the existing election code, and when conducted by local election officials who seldom have training in signature verification. What we've seen also is the perceived mismatching of signatures has had constitutional claims as well as ordered by the state to either abandon the practice or come up with a new mechanism, including the digital matching that lets voters get their ballots counted. The process has not been abandoned, and this bill continues to leave that process vulnerable to allowing for folks that don't have that necessary training on signature matching to now use up to 6 years of signatures available to match these signatures. To be certified for the actual courts in Texas as a certified document examiner actually requires a minimum of 2 years of training and a bunch of other tests in order to pass. To be qualified in court as an expert witness on signature verification, of which most of the folks at counties employed by this process don't do. Extending the years of preservation without that institutional training or expectations outlined for these volunteer roles increases disparity of the review process. Some volunteers might look at the earlier signatures to match, while others might look at the most recent. But what we're most concerned about is Section 3I of the bill, which exacerbates this more, with the provision that the committee shall compare the signatures with any known signature on the voter file with the county clerk or the voter registrar to determine whether the signatures are those of the voter. As I think was mentioned by the last witness, clerks have many pages of signatures attached, whether it be an addendum for someone that closes on a house, permitting documents, et cetera, which is a problem in and of itself, but would mean that there are many different types of signatures that are being matched, whether a finicky touchpad at the DMV when an 18-year-old is getting their license, or these many signatures that are being signed quickly as a couple is, signing on a house. So we're worried about this bill, and we urge the committee to oppose.
Members, any questions? Thank you, Ms. Harris. Yeah, Representative Manuel.
How many, and if you don't know it, how many counties would you think would be negatively affected by it? So I know you were saying that there's smaller counties. Is it just, would it be, if you knew the number? If you don't, that's completely understandable.
Yeah, I don't think we have a public number of how many counties are still using this type of signature verification committee, but we have seen that the statute is still outlining that the counties that are using it haven't had any updated standards as to what the process of matching goes through. And so we can try to figure out what that number is of counties that still utilize it, but the point being it's still allowed that they can.
Okay, thank you.
Yeah.
Any other questions, members? Thank you, Ms. Harris.
Thank you.
The chair calls Robert Green. Mr. Green, I just want to make sure we're not messing up the record here. Can you come on up here? Yes, sir. Yeah, I'm probably going to need to make sure you're on the record here. You are Robert Green. You're here on behalf of the Travis County Republican Party Election Integrity Committee for Legislation and yourself. You're for HB 3449, and you're registered to testify. Is that all correct?
Yes, it is. And I'm choosing at this point not to testify.
Okay.
I think Mr. Barrow will probably say everything that I need to say.
All right, thank you, Mr.
Is that it?
We have you not testifying. The chair calls Ed Johnson. You're Ed Johnson. You're here on behalf of yourself. You are for HB 3449. Is that correct?
That is correct.
Go ahead.
Yes, so answer a couple of questions here. My understanding of this bill, all the things that it's talking about here are already pretty well in code. You have to display, or you have to have present right now for the ballot board or signature verification, the last 6 years of signatures on file. And so that's nothing new, that's nothing in law. What we're adding here is that the poll books that you signed, they get destroyed within 22 months if it's a paper one, get saved. So they can add to that 6-year list of signatures on file. And this really helps the ballot board. It actually helps them probably approve a lot more ballots than it's disqualifying, because as you get older, people's signatures sometimes get sloppier and change, and you can look back and see, oh, we filed that application at the beginning of the year, and it matches last year's signature, but, he was having a hard day this day, and it's kind of squiggly here. That's what they use it for. And there's a corporation called Votech that I think most of the major counties use. It's a voter software that's connected to the state. They have a ballot imaging module with it that images this carrier envelope that has the signature and all the text and the applications, and it displays it, and also displays on the right-hand side all the signatures from the last 6 years automatically. I will tell you, I think Harris, Dallas, Tarrant, all of them are already using this and having it in practice. So very few counties would be affected by this, because it was my understanding if they're still on paper and not imaging, it's not until they get to that point that it would be implemented.
Members, any questions of Mr. Johnson?
Thank you.
Thank you, Ed. The chair calls Laura Rogers. Thank you for hanging in here with us, Ms. Rogers. You're here on behalf of the County and District Clerks Association, and you're neutral on the bill, is that correct?
We are neutral on the bill. We would like some clarification. Our first concern with this bill is the obvious cost to the smaller counties. I have 1,200 registered voters in my county, and I mail out approximately 75 ballots per election. I've had a yearly election budget currently of $20,000, which is pretty much double what I've already had in what I had in 2020. This cost of new technology would be a huge burden to my county. Our second concern is the wording of any known signature in the possession of the county clerk. County clerks could have possession of over 20 signatures due to keeping land records, vital statistic, court records, etc. This bill could be narrowed down to election records or maybe a shorter time frame. The 6 years, I understand, would be for the applications and the envelopes, but clerk records go back for years. Our records actually start about 1895, so that would be an entire lifetime of signatures. Our last concern would be how much a signature can change in 6 years. My own father was diagnosed with Parkinson's several years ago, and his signature changes pretty much every year, if not more often. This would cause confusion for my signature board, because if they have multiple signatures, which one are they going to go off of? How are they going to know which one is the signature that should be matched to? This would also treat first-time ballot by mail voters with only one signature on file differently than those who have 6 years' worth of signatures on file, and that's another concern that we have. Thank you so much for listening to our concerns, and do you have any questions?
Members, any questions? So, ma'am, I see here on page 3 that, apparently this has been the law that the committee, it said the committee may, is what the law was, or currently is, also compare the signatures with any known signature of the voter on file with the county clerk or voter registrar to determine whether the signatures are those of the voter. So that's currently the law.
Right.
Right. What I think Ms. Noble's bill says is that shall.
Right. It's the change from may to shall that is kind of a little sticking point, especially me as a combo clerk, because then I also have district court records that could be possibly brought in, divorces, adoptions, name changes, then drop down to my county court where I have misdemeanors, juveniles. I have multiple, all the land records, vital statistics. Then I drop over to probate court where I have people being appointed as executors of estates. And so I have so many signatures in my office. There is no reasonable way to compile all of those at once to compare a signature on one document.
Members, any questions? Thank you.
Thank you.
Yes, ma'am. Chair calls Alan Vera. Mr. Vera, you're here on behalf of the Harris County Republican Party Ballot Security Committee, and you're for HB 3449, is that correct?
That's correct.
Go ahead.
We were stunned to learn that there are still counties in Texas where the Signature Verification Committee only compares the signature on the carrier envelope with the signature on the application. It should just say open house ballot harvesters. As long as you sign the application and the envelope, you're in. We think that is a key point that this bill is changing. we would recommend or suggest that the language of the bill be changed to include all signatures in possession of the county elections authority and voter registrar. That would narrow the number of signatures required and make it more manageable. In essence, this bill simply creates uniformity for the voter registration information available to all signature verification committees in all 254 counties. It ensures that mail ballots across Texas are processed uniformly and that Texans who vote by mail have uniform protection against harvesters attempting to sneak illegal ballots past the SVCs. We urge the committee to report this bill favorably to the full House. Thank you.
Members, any questions? Thank you, Mr. Vera. Chair calls Shomei Wong? Sorry.
Yes.
I had it going and then I lost it.
Yeah, my name is Xiaomei Wang.
Yes, ma'am.
I'm
You're here on
here.
behalf of yourself and your 4HB 3449, is that correct?
That's correct.
Go right ahead.
Yes, I'm for this bill. I understand that the signature verification committee always, have to deal with non-comparable signatures, since I work at the Tarrant County Ballot Board and the Signature Verification Committee. We have the process on that one, and I'm not going to talking about that. But I think right now, this bill want to keep the 6 year of history of the signature image. This is very good for collecting the documents, election documents and evidence for the future investigation and audit, because this will help for identifying suspicious phenomena. And these, we all know, mail-in ballot is really a warm bed of ballot harvesting and election fraud. So this one is going to help us to protect our election integrity and security. Thank you.
Members, any questions? Thank you, Ms. Wong. Is there anyone else who wishes to testify on, for, or against House Bill 3449? If not, the chair recognizes Representative Noble to close on her bill.
Thank you, Mr. Chairman. You so wisely pointed out that most of this is already in code. We're just asking that these signatures all be available at the same time, at the same place. And more counties are going to the electronic storing of this information. So it would be to their advantage to have it available to the voter. I contend that more ballot by mail applications would be approved. Well, we have this situation in our county where our U.S. Congressman's wife had a degenerative disease, and the ballot board was going to reject her signature because it was so different from what it had been in the past. And so, but if they had been able to see the progression of her disease, they would have known it was hers. And I think that this is the advantage that we have with this bill. So.
Members, any questions? Yes, Representative Manuel.
To my favorite zebra, just a really quick question.
Yeah.
It's a human service joke. Is there going to be a governmental body that's going to be training, that would be training people on the ballot, making the signatures, or the board? Would it be
The Texas Election Code already tells us how the early voting ballot board, who makes that up, and the signature verification. That's not in this bill. That's a separate.
So just following that law.
We just have to follow that law.
Okay, thank you so much.
Mr. Chairman,
Chairman.
is there a fiscal note?
There would not be, because this is already being used in many counties, and this just says that when they upgrade their software, that they would include this.
No, I've thought about
Thank you
this
for
a bit.
making me say that, though.
Where is that portion, when they upgrade?
Yes, that is in,
I'm sorry, I don't want to put you on the spot, but I've just,
it's on page 4. The software must be made available for the first, following the update of the software. Following the update of the software.
first election following an update of the
Yes.
software, the early voting clerk uses.
That's when it would start being used. So until they, and again, some counties may never use this kind of software or to store signatures. So I assume that they would never need it. If you are in Lovington County, I assume you can go actually pull those signatures for their board.
So, you know, in my early practice, I was involved in a case where I ended up in the deed records forever looking at signatures and stuff, just by chance. How do you feel about, what I don't want to do is I don't want to get in a situation where we have people say, well, you know, these ballots are not valid because there was a signature from 1970 whatever that they didn't look at, right?
Yes.
So how do you feel about keeping it at May on reviewing the signatures?
The problem with that is that some of the counties have taken that to mean that they don't have to provide it to the ballot board.
Okay.
Even though the ballot board may want them.
Okay.
So that's the problem with the May.
I see. All right. You see my point?
Yeah, I see your point
Get into a
completely.
big contest on these mail-in ballots. Am I the only one that's worried about this? Yes, Representative?
I was thinking about that also, and I think if you're looking to compare signatures, and you have 5 prior signatures, and maybe 2 of them compare and 3 don't, you have 2 that compare, and they're prior, and that does it. The other 3, you know, may have been late at night after a scotch. I don't know, but the point is.
Just say it.
Did I say that out loud?
Yeah.
The point is it gives you more opportunity to have comparable signatures, is the way I look at it. Is that the intent of the bill?
Absolutely.
Okay.
Absolutely.
Okay. Thank you. Members,
And that's why we narrowed it to 6 years as well. I don't think that we need to keep something from 1975 in there.
Yeah, I was just looking at this, though, this portion about all signatures.
Yeah, that was already that's language that was already in code. We didn't change that part, so.
But it's permissive, see, it's the committee may.
And I wouldn't mind narrowing it if it's not going to get the bill, you know, popped, to narrow it to signatures available to the elections administrator or the election office. I would be okay with that. I think that that there's probably not, we don't want them to have to go check with the clerk and others to see if they've filed suit or they've changed their, you know, name or had some dealings with the clerk's office. I don't think that was never the intention, I don't think, of whoever wrote this code originally.
Okay. Members, any other questions? Yes, Representative.
I would like to say that Representative Noble is very thoughtful in not having a fiscal note if she can do anything about that.
Yes, that's right. She also has great candy at her desk, everybody, so. Yeah. Is there anyone, do you have anything else? Okay.
I respectfully request passage.
Thank you, ma'am. If there's no objection, House Bill 3449 will be left pending. Chair hears none, and House Bill 3449 is left pending. Chair lays out House Bill 3749 and recognizes Representative Flores to explain the bill.
Hi, good evening. You all should have some scotch in here. Thank you, Chairman Smith and committee members, for the opportunity to lay out HB 3749 relating to the provision of the reason for rejecting a voter registration application. Let me start off by asking you, have you ever had an official document rejected or returned because of missed checkbox, an omitted signature or initial, mistakenly entering the correct date as your birth date, or even worse, by having no clue why it was rejected? It's probably happened at one point or another in each of our lives, right? Well, thousands of Texans have experienced this same feeling of confusion and frustration when being notified that their voter registration application has been rejected by their local voter registrar. HB 3749 is a simple bill that will help these Texans know precisely why their application was rejected. Under Election Code 13.073, currently, county voter registrars are required to provide notice of the reason for rejection of a voter registration application as follows. If the applicant is present upon the registrar's review of the application, then the rejection notification must be given orally immediately. Or if the applicant is not present, a rejection notification must be sent to the applicant in writing within 2 days. But current law does not establish that a specific reason for the rejection be included in the rejection notification. This has resulted in many applicants being provided vague, nonspecific information by some voter registrars that have made it difficult for them to know precisely where on the application the error, omission, or disqualifying information occurred. If applicants are told of the precise reason for the rejection, they are much more likely to then submit a correctly filled out application on their next attempt. HB 3749 requires that the applicant be notified of which specific section or sections on the application that was either incomplete, improperly filled out, or contained information indicating the applicant is ineligible to vote. You can look at the handout that has just been distributed. Currently, the Secretary of State provides these templates for both their notice of incomplete information and the notice of rejection. Between these two forms used in the corresponding instances of an insufficient application, every foreseeable instance of a reason for rejection is covered. However, these are only templates. County registrars are not required to send out notices with this amount of detail, leading to a patchwork of different forms across the state. Counties can instead send notices that are much more vague and leave room for interpretation and confusion of the rejection reason. Throughout Texas, county registrars should provide voter registration applicants with the specific section and deficiency that was the cause of the rejection so that the applicant can successfully reapply without making the same mistake repeatedly. The Secretary of State's office has previously indicated that this change would be very easy to implement. All they would have to do is update their current template forms to include or even categorize by voter registration application section numbers. Then counties can integrate these into their existing rejection notice form letters. There are no significant implications to the state or county since voter registrars are already required by law to send notice of rejection to applicants. This bill simply requires an update to that rejection form letter to be uniformly more specific and helpful to the applicant. Passage and implementation of this bill will result in reduced delays and frustration for both potential voters and county voter registrars' offices by increasing success rates for second attempts at registering, eliminating the need to send multiple rejection letters, and ensuring county registrars remain in compliance with the law. The simple bill was reported favorably out of this committee and passed the full House during the 84th session before dying in the Senate State Affairs. With your favorable consideration, Mr. Chair and members, I hope to carry it across the finish line finally and onto the governor's desk in this session. So with that, I'm available for questions, and I reserve my right to close.
Members, any questions? Ms. Flores, when was it?
84th session?
The 84th.
Step 2017, I believe the date
Do you
of
know
that.
who carried it at that time?
I believe it was,
If you don't.
well, I know Sylvia Garcia in the Senate, perhaps?
Okay, all right. Members, any questions? You're requesting to reserve your right to close?
I did.
And that is reserved for you, and we'll have some witnesses, I believe, testify. The chair is going to call Christina Atkins.
Thank you.
Yes, ma'am. Ms. Atkins, you're here on behalf of the Texas Secretary of State's office, and you are neutral on the bill, that's correct?
Yes, sir.
Now, for the first time, I read this provision under Section 13 of the Election Code. I've not ever had any experience with that before. Can you kind of give us some backdrop on what that provision is supposed to do and how this will enhance or detract from that?
Yes, sir. When a voter registration application goes to the voter registrar of a county, they review it, and there's kind of 3 different paths it can go on. First, they can just accept the application if it's complete and everything on the face of that application indicates there aren't any eligibility issues. So that's probably the most common path that we see. The other 2 paths are if it's incomplete, they can issue what's called a notice of incomplete. So maybe the person forgot some boxes, didn't put all the required information. So then they're sent a notice telling them that that information was incomplete, gives them the opportunity to complete the application. And the reason why that's important, why that step is different than just an outright rejection, is because if you have a voter registration application that comes in right on that deadline, a notice of incomplete preserves the deadline. So that gives somebody the chance, if they left off one of the eligibility boxes on there, they forgot to mark the citizenship box, for example, it would hold their registration date, give them the chance to fix it so it doesn't negatively impact their registration. The other thing that can happen is an application can subsequently be rejected or challenged on eligibility grounds. So if the application itself, indicates that somebody's not eligible for registration, they would be rejected, or if there's information that voter registrar has that somebody's not eligible, they would go through what we call a challenge process. So we have prescribed templates for all of these different scenarios. Yes. It sounds complicated, but it's really, I think for voter registrars, it's not as complicated as it sounds. We have templates to help them with this process. What I hear is that not everybody uses our templates. And so I think this bill, with requiring that specificity, would require more than likely that they use our templates. Now, what I would do is review what we have to make sure that we're covering everything here so that it's easy for implementation for the county voter registrars.
Okay. So y'all are doing this, or y'all have templates that?
We do. We have templates that the counties can use.
Okay. But what this would do is just make it a must?
It doesn't require that they use our templates, but what the bill author said is, in her experience, she's finding that not everybody's using our templates. And so they're not giving the specificity when they're telling individuals with the problems in their application process.
I see.
I think putting more specificity in 13073 as to what you have to tell the voter would probably force people to use our templates.
Okay.
We're going to make it easy for them. We'll do the work there, and then they can use our forms.
I see. Okay. Members, any questions? Thank you, Ms.
You're
Ashton.
welcome.
The chair calls Ed Johnson. Mr. Johnson, you're here on behalf of yourself and you're against the bill, is that correct?
That is correct.
Go ahead.
So in my reading of the bill, what this is referring to is a rejection. And there are really basically 3 things you can reject an application for: is if the name's not correct, if it's not the correct birth date, or the correct driver's license or social number. It's not a very complicated form. And I question if they don't know their name, birth date, and can't look up the driver's license number, is it really that voter? If they can't figure those 3 out, because they've written them down incorrectly for a rejection. It wasn't that they were blank, it's they were rejected because it wasn't correct. So I think you're helping by pointing out what it was that was incorrect specifically, as helping people that are trying to fraud the system and register someone illegally. Because a voter should know this information. It's not complicated. It's your name and your birth date. So I believe in the letters for leaving it blank, but I don't think we should be specific on if you didn't get the information correct, because it's probably not the voter if the information wasn't correct.
Members, any questions? Thank you, Mr. Johnson.
Thank you.
Chair calls Michael Belsick. Michael Belsick, we show him testifying on behalf of himself and for HB 3749 and not here to testify. The chair calls Susana Carranza. Good to see you, Doctor. I understand you're here on behalf of yourself and you're for HB 3749, is that correct?
Yes, I am. And the Secretary of State resource witness kind of said half of what I had to say, but I'm going to repeat because there are points that people don't realize. So I'm a volunteer deputy registrar, so I help register voters. And one of the things that we do when we register voters is, when we're helping in person, is we check that they filled all the forms. Well, unlike the previous testimony mentioned, like, it's pretty easy to mess up a form because the form is kind of hasn't been updated in a long time. There are boxes here and there that you have to move your eyes around. So it's very easy. We see a lot of voters that miss a thing, but because we're there helping them in person, we point them out and they fix. But a lot of people use a mail form, so they never have somebody helping them. So it's very, very common for people to miss a box. I mean, I'm horrible filling forms. I skip a box like all the time just because, I hate paper forms, which is why I want online voter registration, but I digress. But one thing that I want to emphasize, having the actual information is really helpful, because if you just have a generic, or you miss some information, I've had voters that kind of re-register because they showed to me, like, I received this letter and I have no idea what I'm missing. And then we went and refilled stuff because there was no detail. So that actually happened when I was registering voters. But what is really critical is because when, as the Secretary of State mentioned, that there are 10 days to fix a problem when you receive a notification because your registration was incomplete. And if they do that and register close to the deadline, they're still going to be able to vote in that election. If that's completely rejected, they don't see the notice and they cannot fix it in time, even though they register in time, just because they missed a box, they will miss that election. So because of that, clarity is very important.
Thank you, ma'am. Members, any questions? Thank you, Doctor.
Thank you.
The chair calls Avital Cuevas. Sure I'm mispronouncing that. Avital Cuevas, C-U-E-V-A-S. Avital Cuevas. She's here, or someone's here on behalf of themselves and for HB 3749, but not here to testify. The chair calls Emily French. She is here. She's here on behalf of the Texas Civil Rights Project and for HB 3749, is that correct?
3 for 3.
All right. We found a bill you're for, Ms. French. Makes me a little nervous, to tell you the truth, but that's all right. No. Go ahead. Go ahead.
Love to hear it. Keep everybody on their toes. I'm here to testify in favor of HB 3749. Election laws in Texas are notoriously complex, and we support any effort to help voters navigate that complexity. Reasons for rejection of a voter registration application are usually fairly obvious to election workers, but can often be inscrutable to voters. Many aspects of election are like this. This session has seen its fair share of bills that would penalize voters for what they don't know. Instead of penalizing them, 3749 makes the effort to close that knowledge gap between election pros, like present company, and casual election participants. This committee has already passed several bills out that would close that gap for voters with disabilities. We hope to see similar efforts passed out for Texas voters, including those who vote by mail. We ask you to report it favorably. Thanks.
Yeah, thank you, Ms. French. Now, did you hear Mr. Johnson's testimony?
I did.
Johnson's testimony is concerned about, said there's only limited things that you can reject this thing for, and all you're going to be doing is giving somebody, a heads up on how to defraud the system. Do you have any kind of a rebuttal to that?
I think it would be really ineffective to try to defraud the election system with mass voter applications, especially if you keep coming back to the office and getting them rejected. I don't think it happens. I think it doesn't happen because, I don't think the market would reward such a scheme.
Members, any questions? Yes, Mr. Chairman.
Mr. Chairman, I kind of see your point, right? So let's say, for instance, you get back the rejection. Maybe it is because you put your name in the wrong place, and so then you can focus on that part. But if it says, well, it's because, I don't know, your name is wrong, you might think, well, maybe I need to go call the registrar's office and make sure if they have my maiden name or if they have something else right. So I guess I don't see why we wouldn't want the voter to know. Obviously, their name is their name. their birthday is the birth date and their address is the address. But by providing them at least some information about something as important about making sure they can go vote, doesn't necessarily mean that they're trying to be fraudulent. We're just trying to help them direct their efforts to finding the most accurate information and filling out the form correctly.
I agree, and my name, when I go to vote, my name still has to be substantially similar to the name on my ID. I think that's, I agree.
You'd be shocked how many times mine's spelled wrong, so.
I think I would. There's a reason I changed my last name when I got married. I was like, I'm sorry.
Any other questions, members? Thank you, Ms. Fresh.
Thanks.
Is there anyone else who wishes to testify on, for, or against House Bill 3749? If not, the chair recognizes Representative Flores to close.
Thank you, Mr. Chairman and members, and I appreciate the witnesses in favor of this bill, and as I mentioned, the aforementioned scotch, if you go home and you're drinking a scotch and you're filling out your application and you somehow forgot your date of birth or got the year wrong, or you spaced out somehow or missed a box, those things can happen, and it would be helpful to know when you receive a notice of incomplete, or to have them point out what it was that you got wrong and do that. So I appreciate that. And you did ask a question about, it was actually then Representative, now Senator Miles, who carried this bill, and it passed this committee 4-2 and passed the House 103-37 back in the 84th session. So anyway, just for a little data there for your information. Anyway, as you can see, this is a simple bill. It's a little bill, but with a big impact. I think it would be very helpful to the voters so that they can, to potential voters, so that they can make sure that they actually get the opportunity to fill out their applications correctly and have an opportunity to vote in an election. So with that, I close, and I thank you very much.
Thank you, ma'am. Members, any questions?
Any more?
Thank you.
Thank you.
If there's no objection, House Bill 3749 will be left pending. The chair hears none. House Bill 3749 is left pending. The chair lays out House Bill 2954 and recognizes Representative Baumgartner to explain the bill.
Mr. Chairman, members of the committee, members of the elite and prestigious Brew Caucus.
That's right.
Thanks for having me this evening. I'm here to lay out House Bill 2954, which seeks to rectify a misunderstanding in the election code regarding office hours of election authorities. Currently, local election authorities are unclear what the definition of a regular business day is due to lack of clarity in current statute. A county clerk, city secretary, or secretary of a governing body of a political subdivision must keep that officer's office open for election duties for at least 3 hours each day during regular office hours. However, the definition of regular business day is only applied to school districts. It leaves counties and local municipalities without certainty of what days they are required to remain open. This was brought to me before by my city secretary in Flower Mound, and I served there locally, and they were required to stay open on Good Friday for 3 hours. And basically, this would allow local municipalities to be under the same definition for business day as school districts, so they can close and have the same 3-day weekend as school districts would. And it would save money, it would save time, and allow people to enjoy the holiday. And if there aren't any questions, I reserve my right to close.
Members, any questions? Hold on just one second. I'm going to call Christina Atkins. Ma'am, you're here on behalf of the Texas Secretary of State's office, and you're neutral on this bill? Is that
Yes, sir.
correct? And you're here as a resource witness?
Yes, sir.
Members, any questions of Ms. Atkins? Ms. Atkins, have you had a chance to review this bill?
I have.
Any unintended consequences here? Looking around all the corners?
We actually nicknamed this bill the Good Friday bill in my office because it may actually save the state money, because we get about 6,000 phone calls the week of Good Friday every year asking about whether or not they have to be open on Good Friday. So, well, right now the answer is yes, and unless you're a school district. So this will definitely add some clarity in that area.
Excellent.
Yes.
Members, any questions? Thank you. Is there anyone else who wishes to testify on, for, or against House Bill 2954? If not, the chair recognizes Representative Baumgartner to close on House Bill 2954.
With that, I close. Thank you, guys.
Thank you. Now, I want people to know that Representative Baumgartner, Representative Busey, and myself all went to Austin College.
That's right.
Yeah, that's right.
Rear caucus.
A school of,
We're taking over.
a school of 1,400 students.
Kangaroo ears.
At any time. Yes, very small. That's right. If there's no objection, House Bill 2954 will be left pending. The chair hears none. House Bill 2954 is left pending. The chair lays out House Bill 4399 and recognizes Representative Hayes to explain the bill. Representative De Ayala offers a committee substitute.
Thank you so much. Mr. Chairman and committee members, the election code sets forth requirements related to a plan for this counting station operation, often referred to as central count. Originally written in 1985, it simply required the manager to establish and implement a written plan for the orderly operation of the central counting station. Since that time, the law has been amended only twice, once to require the process for comparing the number of voters who signed the combination form to the total number of votes cast for the entire election, and then once to require the plan to be made available upon public request, not later than 5 p.m. the 5th day before the day of the election. House Bill 4399 will provide more structured set of requirements, providing more consistency and transparency. Originally, what I would tell you, when the law was originally written, we didn't have the technology that we have today. And there is much interest in open, honest, fair, and transparent elections, and that has increased significantly over the last few years. Additionally, county election officials in Texas are as varied in their experience as the Texas landscape. Updating the requirements in this section can boost confidence in our elections and help provide a more robust framework for a central count plan. And thank you, Mr. Chairman and members. And there may be some witnesses, so I'll reserve the right to close.
Members, any questions? Your right to close is reserved.
Thank you.
Mr. Hayes, thank you. The chair calls Kathy Hagler. Ms. Hagler, I understand you're here on behalf of yourself and that you're for HB 4399, is that correct?
Yes, sir, that's correct.
Go ahead.
Chairman Smith, Vice Chair Busey, and members, thank you for considering this very good bill. I didn't think I could tell you all of the things I wanted to tell you in a short time, so I'm giving you a handout, hoping you'll be able to look through it. But in very quick summary, the last 2 pages of that handout are the most current resource that the Secretary of State has online for Central Counting Station training. Those pages show the first slide on the bottom of page 6 says that there must be a plan. The second slide on the top of page 7 says what must be in the plan. The third page has many suggested elements of the plan. But as you can well imagine, with all the things happening in a busy elections office, all the rules and opinions they're required to follow, most election offices will take a hard pass on suggested elements of a plan. So SOS actually has some very good items on that suggested elements list. And basically, House Bill 4399 appears to move some of those things from suggested status into the must-be status. So the bill that was originally filed had a little bit more aggressive and detailed things in it. And I understand there's a committee substitute that will kind of soften the edges a little bit. The original bill said all LNA tests, but now the committee said, I understand, will probably say only the second and third LNA tests would be available. Originally, I believe it said we needed to see a list of who will work in the central count. Now we're just trying to find out how many people will work there. We don't need to know their names. We just want to know how many so that candidates and poll watchers can plan in advance. And the biggest change, the original bill had a deadline of 15 days before Election Day. That was met with a lot of opposition, so I think we've negotiated to go back to the 5th day of the election, 5th day before the election. But the most important part of it is now, rather than an individual having to go and request it, them stop, drop, and roll in the elections office to give me a copy. We're just asking them to post it online, and it's available to the public, and it'll save a lot of grief for everyone concerned. So it will save a lot of issues on election night by having a good plan that's well thought out in advance. I'm happy to answer any questions.
Members, any questions? Chairman Caprigliano.
Thank you. So I have a question as I go through this. So why do you think it's important that the number of licensed peace officers that are at the central county station, and in which room those peace officers will be stationed is important?
So originally, that was the language, but now we just, I think, changed it to how many peace officers there will be. The main reason for that is they're required to have peace officers there. We want them to say in the plan how many there's going to be so that we know that they are actually planning to do that. If they're going to have 2 or 3 different peace officers, that tells us also with poll watchers, we may not need as many poll watchers to watch things if they have more peace officers there.
Okay, so you don't have that part in it anymore, or you do?
I'm sorry?
So that's not in the substitute? Maybe I missed the substitute.
There is a substitute.
I'm sorry?
There is a
There is a
substitute.
substitute, okay.
Yes, sir, there is a substitute that I'm not looking at it. I don't know what it says exactly, but I believe we were trying to make that simpler. Yes, sir.
Members, any other questions? Thank you, Ms. Hagler.
Thank you.
The chair calls Chris Davis. Mr. Davis, I see you're here on behalf of the Texas Association of Elections Administrators. You're neutral on this bill, is that correct?
That's correct, sir.
Go ahead.
TAA appreciates the effort that the author's office showed in trying to compromise on between the original bill and this committee substitute. TAEA, the Texas Association of Election Administrators, wants to know which counties are not currently publishing or making publicly available their central count station plans, because we want to reach out to them and make sure that they do. We realize that there's a spectrum between really, really bad central county station plans and really, really good ones. I think the vice chair's county has a really, really, really good one. There's a saying that the best laid plans of mice and men often go awry. And what I think that means is that the more details you put into a plan, the better the chance that it's not going to be as accurate to what actually happens. And when we go through the bill, what stands out to us is some of the information that may be broad or vague. Section 2, it mentions about asking who will provide information and what information provided by each person, the presiding judge. We'd love clarity on what kind of information they're talking about, because information can be anything when it comes to the central count station plan. We're glad, well, we're hopeful that Section 4 is removed in the committee sub or possibly by amended, because right now we apply that to an unsuccessful logic and accuracy test to possibly applying to the first LNA test, which has occurred 30 to 45 days before the central count station plan. We don't necessarily see the relevance of such an old test and the results. In number 6, the number of people appointed, we appreciate the edits that they've made. That number, back to the best laid plans, is still fluid. We have so many people that could work a central count station. We consider the runners, those high school kids that wear the reflective vests that are bringing the materials in from all those cars in our polling places, to be part of our central count plan. And we don't know how many we're going to have at any point in time. The minimum number of licensed peace officers, I'm not sure that they're asking for how many we're going to have. They're asking for the minimum number of licensed peace officers. Well, we all know what the minimum number is. It was passed a session ago in SB 1. That minimum number is 1. Every county must have at least 1 at central count station plan. We appreciate that they've adjusted it from having it available 15 days out back to its current statutory 5 days before Election Day, and we agree that counties must be putting this online. And I'm here for any questions.
Just, can you get us and the bill author a copy of those concerns? And maybe you've already done it with the bill author, but.
We've conversed with that office more than any other bill tonight. We appreciate that. Okay. Yes, we have.
And if we can have it too, we'd keep working on it together. Thank you.
Thank you.
Members, any other questions?
Thank you, sir.
The chair calls Christina Atkins. so kind to be here on behalf of the Texas Secretary of State's office and neutral on this bill.
Yes, sir.
And here's a resource for us. Anybody have any questions of her? Ms. Atkins, do you have anything that you want to add about this particular bill?
No, sir, I do think providing additional detail in this area could be beneficial, and so it's good to see, I've been apprised of the progress with the committee substitute in some of those discussions, and it's moving in a good direction.
Okay. Members, any other questions? Thank you, ma'am.
Yes, sir.
The chair calls Alan Vera. Mr. Vera, I show you as being still here on behalf of the Harris County Republican Party Ballot Security Committee and for HB 4399, is that correct?
That's correct.
Go right ahead.
The code already has a requirement for a central count written plan. This bill adds what we believe is needed specificity to the contents. We think it's a solid bill. It addresses 3 current points of contentions quite well. Since the establishment of the election reconciliation form in the 87th session in Senate Bill 1, most of the county problems with the report have traced to confusion about which official is responsible for reporting data to the central count presiding judge to fill out the reconciliation form correctly. That's what that's about. Second, we read complaints from across the state on lax chain of custody procedures with the ballots and equipments turned in by Election Day presiding judges at the central counting station rally points. This bill addresses that problem. And there are still last-minute surprises about where poll watchers can and cannot observe central counting activity. That leads to big election night fights, disagreements, phone calls to the SOS, etc. This bill requires early posting of that data, allowing enough time to address disagreements before Election Day. We urge the committee to report HB 4399 favorably to the full House. Thank you.
Members, any questions? Thank you, Mr. Vera. The chair calls Shomei Wong.
Yes.
Here on behalf of yourself and for HB 4399, is that correct?
That's correct.
Go right ahead.
Yeah, I'm here to support for this bill, and this is a great bill and address the whatever is options from now. And then I think Mr. Alan Veras, he already said all I want to say, and I just want to add one thing is things happened in the central county station almost every election. It's going to be like not like going smoothly. For example, last election we have the V drive basically is contain one scanner's ballot data is not readable by the central counting machine. So if these things happen, and then the whole bag of a ballot from that location will get rescanned from another machine. But something happened like this, I think is the central counting station judge or whoever responsible for that need to make some report to disclosure these kind of incidents. So incidents happen, but need to be reported and let people know. So that's why I was thinking, I just want to add this. I think this is a great bill, and I'm respectfully asking you to support that. Thank you.
Thank you, Ms. Wong. Members, any questions? Thank you. The chair calls Laura Presley. Ms. Presley, I show you're here on behalf of True Texas Elections and for HB 4399. Is that correct?
Yes, sir. Thank you.
Go right ahead.
This is a really good bill, and it's very much needed because there's inconsistencies in the details of how the central counting station plans are written and carried out across the state. I have trained 600 election watchers in the last 7 years for the central counting stations. I'd like to I appreciate that the committee sub is going to add in Section 5 that the plan should contain information about before Election Day. Central Count operates before Election Day. That Friday night, when early vote ballots are delivered to the building of Central Count, they're delivered, they're checked in, they're transported down hallways, they're stored, and that's when the ballots are most vulnerable. 60% of the vote comes in on that Friday night. So I'd like to go to Section 8 and 10. I'd like to consider, you guys to consider adding on Section 8 about the chain of custody procedures. There should be chain of custody procedures defined when the ballots are dropped off, because there's a debate. Does central count mean the room of central count, or does it mean the building where central count comes in? In my county, the vice chair's county, it's not considered central count until it's into a room. Well, you've gone down hallways, you've checked it in, there's no surveillance, and watchers can't look at it. We filed criminal complaints in Williamson County because watchers were not permitted to monitor and follow the ballots into the storage location. I would like to see some changes added to that to say exactly what central count is. It's where it's dropped off. Even Chris Davis just said just now the runners are part of central count. I agree they are. There needs to be surveillance. The watchers should be able to watch from that point all the way to when the ballots go into the building, and we'd like to see some changes of that. And I'm here if there's any questions.
Members, any questions? Thank you, Ms. Presley.
Thank you. Could we work on continuing this? Okay. Thank you.
Good, thank you. Is there anyone else who wishes to testify on, for, or against House Bill 4399? If not, the chair recognizes Representative Hayes to close on his bill.
Thank you, Mr. Chairman. In an earlier life, I served as county chairman for 6 years, and I worked at Central Count on many elections. And over the years, we've seen there have been issues. And so what this bill really seeks to do is to give more definition of what's going on. And when you do that, you lower everybody's blood pressure. And I think there's just a lot of positive here. We've had a lot of input from a lot of different stakeholders. I think we got it pretty close here. There might be tweak. We'll keep talking, but not very long, because we need y'all to report it out so it can, get to the floor.
I understand, absolutely, yes.
I close.
No, thank you. Members, any questions? The committee substitute is withdrawn. If there's no objection, House Bill 4399 will be left pending. The chair hears none. House Bill 4399 is left pending. Let's see. We did pieces now. The chair lays out House Bill 374 and recognizes the esteemed Vice Chairman Busey to explain the bill. Also a graduate of Austin College. Right.
Fighting kangaroos. Thank you, Mr. Chairman. Members, thank you for allowing me the privilege to lay out House Bill 374. Under current law, a person submitting an application for a ballot by mail must also request to receive a ballots by mail for any runoff resulting from that election. This process made sense when the only reason allowed for requesting a ballot by mail was temporary absent from one's county, given that such voters may be back in their counties for runoff elections and would not need runoff mail-in ballots. However, most ballot by mail are requested today by persons over the age of 65 or persons with disabilities, and these people would still be eligible to vote by mail in a runoff, adding an additional step which is unnecessary. House Bill 374 would change the application process to automatically send a runoff ballot in the mail unless a voter specifically requests not to receive one. This is for the runoff elections. Rather than requiring eligible voters to opt in to receiving a runoff ballot by mail, this bill would require eligible voters to opt out from receiving one. I believe I have Ed Johnson here to testify in support of this bill, and if that's true, then I think we might have some real support.
Oh, my. Okay.
I would like to request the option to close.
Yes, absolutely. Members, any questions?
Thank you, Mr. Chairman.
All right, thank you. The chair indeed does call Ed Johnson. And Mr. Johnson, you're here on behalf of yourself and you're for HB 374?
That is correct. Probably one of the things we received the most phone calls, and I was working in elections, is frustrated voters getting ballot by mails. They got a ballot for the general election, and then the runoff came around, and they would call and yell and scream at us, "Why didn't you mail me a ballot for my runoff?" It's all the friggin' same election. So, I don't know why we couldn't, but the code says they had to apply again. We've tried to fix this by adding in for over 65s and handicapped people that they can check a box on the application saying they want to receive a ballot for a year. That helped a whole lot. But there are still some voters that in those categories, the 65 and handicapped, that way back and forth. Well, I may want to vote by mail this time, but not the next election. So I think this would guarantee that they would get a ballot for that election, even including the runoff. The one that does concern me, which the bill has an option for, but I hope it doesn't get to be confusing for voters, is the voter that's temporary out of the county. 3 reasons you can get a ballot by mail. You're over 65, you're handicapped, or you're temporary out of the county. If you check or say you're temporary out of the county, the ballot has to be mailed to an address outside of the county. So, i.e., I live in Houston, I'm working in Dallas, I'm not going to be home on election day. I can have the ballot mailed to, the Dallas address where I am staying. What I've seen happen, though, is that job assignment will be complete and the voter comes back to Houston, and so he's in Houston when the runoff election starts to go, and his ballot gets mailed to Dallas. And that makes a problem for that voter because now their ballot's in Dallas and they're trying to vote here in Houston. There is a remedy that they can vote provisionally, and as long as no one voted the vote by mail ballot, they get to vote. But or they can check the box saying, I don't want a ballot, for the runoff. But we need to make that clear so they can determine between the I don't want a ballot and give me a ballot for the year. If we put those boxes next to each other, I think they'll be confused.
Thank you, sir. Members, any questions?
Thank you.
Mr. Gus. The chair calls Christina Atkins, resource witness. Ma'am, I'm showing you as here on behalf of the Texas Secretary of State's office and neutral on the bill. Members have any questions, Ms. Atkins? Do you have any comments about this bill at all?
No, sir.
Thank you. No questions, Ms. Atkins? Thank you. Is there anyone else who wishes to testify on for or against House Bill 374? If not, the chair recognizes Vice Chair Busey to close.
Mr. Chairman, this is a common sense bill. It's not every day that Ed Johnson and I, after 5 years, are on the same team. And if y'all agree with us, I would love your consideration and consideration for local and consent calendar.
Okay.
If your buddy Ed.
That's right.
Thank you, Mr. Chairman. I close.
Any questions? If there's no objection, House Bill 374 will be left pending. The chair hears none. The House bill is left pending. The chair lays out House Bill 2860 and recognizes Representative De Ayala lay out Ms. Swanson's bill. Their Representative Capriglione offers a committee substitute.
I'm going to try to pinch hit a little bit, Chairman. Members, thank you for this opportunity. House Bill 2860. During an election, one of the more straightforward methods we can do to ensure that those who cannot vote do not is through a distributed voter registration list ahead of the election contest. This list may be quite common to some of you as an entire voter registration list within a particular precinct or county can be obtained for a small fee, and many of the campaign systems and software you may be familiar with are based around this technology. The point is that an accurate, updated voter registration list plays a critical role in all aspects of our election. However, the system used to facilitate its distribution in Texas are behind other states. Unfortunately, there are many issues with the current system of voter registration laws in Texas that leave them prone to abuse and can cause confusion among municipalities. The generic term for these defects is called database latency, and it's basically that time between a change is inputted into the system and the time that it is made public. And that time can be up to 30 days in the National Change of Address System, NCOA. So if there were bad actors that wanted to do some things, for example, they could change addresses, zip codes, make ballots not get to voters, and then change them back before anyone would even know there was even a change. This bill addresses that. It speeds up the time that has to be made available, and it also preserves that data whenever changes were made to be kept. So all those things can be verified. Florida has taken steps over recent years to do this. They do it quite well. This basically mirrors what Florida already does. House Bill 2860 creates an automated common sense solution to cut down on the database latency present in our local election systems and streamlines the process for voter registration information at the county and state levels. The legislation creates a voter registration audit log, an online database that is nearly identical to an existing Secretary of State process in Florida. House Bill 2860 also mandates that the signature on a mail-in ballot be compared with the voter's signature. I think we had testimony in another bill that talked about comparing the ballot of the application with the envelope is not a real comparison. They're not two different signatures. They can be manipulated by the same person on the same envelope. And this change is critical as well, and I think we've heard on another bill earlier today exactly why that change in our election laws is needed. By making the may to shall, and let me go back a little bit. The jobs of the Signature Verification Committee is to ensure that the signature on the carrier envelope is that of the voter. The only way to do that is to compare the signature to other signatures of that specific voter on file with the county. If the county only compares the signature to that application to the carrier envelope, you've just made it easier. And I think Mr. Vera said it was open day for harvesters, I think is the language that he used. So by changing it to may to shall, these committees can add an additional layer of security and integrity to mail-in ballot processes. With that, I'm happy to answer any questions.
Members, any questions? Thank you for laying this out for her.
Thank you all. Reserve right to close.
Absolutely. The chair calls. We got here.
It's not reloading.
Thank you, Kia. The chair calls Mike Brewster. You're Mike Brewster. You're here on behalf of yourself and your 4 HB 2860. Is that right?
That's correct.
Go right ahead.
And while all of the voter registration bills that have been presented for consideration today are pretty good ones, this one is the reason I'm putting in an 18-hour day today. There's a number of features that in this that are going to be important to all 31 million Texans out there, whether they know it or not. It helps bring us into the 21st century. It helps put things on the web where they can be seen, where they can be tracked. I don't know that there's anything in the bill to complain about. So that is one that I would definitely recommend putting forward. And in fact, I would say it'd probably be one of the 4 most important election bills that'll be considered
Thank you, Mr. Brewster.
Legislation.
Members, any questions? Thank you very much. The chair calls Sophia De Loretta Chetty. Sophia De Loretta Chetty. Sophia De Loretta Chetty, I show her as testifying on behalf of herself and against HB 2860 and not here to testify. Chair calls Emily Ebby French. Ms. French, you're here on behalf of Texas Civil Rights Project and against HB 2860, is that correct?
That's correct.
Go right ahead.
All right. I'm here to testify against HB 2860. As this committee knows, it's hard to run a Texas election under the best of circumstances. The election code is full of regulations and the Secretary of State's guidance is full of best practices. Local groups, political parties, election judges, and voters all have strong and, as we all know, often conflicting ideas about how things should be done within those laws. It's disheartening to see another bill that threatens criminal penalties against election officials trying to balance all of that. HB 2860 would impose state jail felonies upon voter registrars, presiding judges of early voting ballot boards, presiding judges of signature verification committees, and early voting clerks for failing to store names and data that the law has not required them to store until now. It is not difficult to imagine a lot of election officials facing the potential jail time during the first election if this bill becomes law. It is not difficult to imagine that a wave of prosecutions against election officials and key volunteers would make it difficult to replace those election officials and key volunteers. The TCRP obviously does not oppose storing more information about elections for later reference. We use a lot of that data ourselves. We just asked this committee not to impose life-altering penalties on those who would fail to store that information. Thanks.
Members, any questions? Thank you, Ms. Bridge. Appreciate that. The chair calls Ed Johnson. Mr. Johnson, you're here on behalf of yourself. You're for HB 2860, is that correct?
That is correct. This bill does a lot of good things, but I'm going to talk about just the first part where voter registration's involved. Here in Texas, we don't incentivize cleaning the voter roll. We actually incentivize not cleaning the voter roll. There's a thing called Chapter 19 fund. Chapter 19 fund, you get paid 40 cents to delete a voter from the roll if you process it. If you just leave the voter on the roll, you get paid 40 cents. You get paid 40 cents every year that the voter's on the roll. So I can get paid 40 cents once for taking them off, or I can just do nothing and get paid 40 cents until someone makes me do it. So we're incentivizing not cleaning the voter roll, because counties actually get paid more money by having more voters on their roll. When Senator Betancourt was tax collector, Assessor Betancourt, and took over after Carl Smith had been running the office for 30 years, Democrat CPA, he believed in trying to make the most he could, and we came in and took about 100,000 people off the voter roll right off the bat that shouldn't have been on there. 80,000 of them were dead. And he just, never cleaned it because he got paid 40 cents every time, it rolled around just for leaving them on. Why am I going to spend the effort paying somebody to take them off? So this bill kind of fixes that problem. It holds Chapter 19 payments if they're, not doing the voter registrars not doing their work and cleaning the roll. And if they're warned and intentionally keep them on there, then it could actually be a criminal penalty because they're intentionally breaking the law then.
Members, any questions?
Thank
you, Mr. Johnson. The chair calls Luis Figueroa. Luis Figueroa. Luis Figueroa, it's my understanding he left. I show him as registered testifying on behalf of every Texan and against HB 2860 and not here to testify. Now, I understand that Ms. Chuddy is here. Is that right? Sophia De Loretta Chuddy.
Nice work.
Thank you. I've had a little practice, and you're here on behalf of yourself and against HB 2860, is that right?
That is correct.
You go right ahead.
Essentially, I'm just, again, concerned about the increased criminal penalties for local election workers. I worked down in South Texas in Hidalgo County, and we already have so many places where there aren't enough poll workers to even keep a polling location open. We're struggling to get enough people even to just have polling locations where we're supposed to, that I feel increasing criminal penalties is just going to further intimidate people who want to serve their community and serve their county by being election workers. I think we had 5 polling locations that actually were closed in the west part of Hidalgo County because there weren't enough poll workers to simply open them. And that is in a really poor community. It's one of the poorest counties in the entire country. That's a place where people cannot move easily to get to a different polling location. People who don't speak English aren't able to find the next polling location when their local church is not available to them like it had been in previous decades. So I'm really concerned about the people that will be disenfranchised if there are not enough people who want to be election workers, because this is becoming a further politicized and dangerous job for them, and they're simply not making enough to be putting themselves through that anymore. So I urge you to vote no on this bill because of those concerns.
Thank you, ma'am. Members, any questions? Thank you.
Thank you.
The chair calls David Weinberg. Good to see you, Mr. Weinberg. I understand that you're here on behalf of the Brennan Center for Justice and against HB 2860. Is that all correct?
That is correct, sir.
Yes, sir. Go ahead.
Thank you, Chairman and members. County elections workers work very hard to do a difficult and complex job. House Bill 2860 would make that job more intimidating by increasing criminal penalties related to the administration of elections. House Bill 2860 follows a trend of criminalizing the work of election workers in Texas. Senate Bill 1, passed in 2021, made it a crime for election officials to encourage eligible voters to apply to vote by mail, and also threatened poll workers with criminal prosecution. They tried to stop a partisan poll watcher from harassing or intimidating voters. I might also note there is a bill coming over from the Senate, 1911, which would increase penalties for election workers, one Class C misdemeanor to a Class A, 2 misdemeanors to felonies. This bill would create 5 new felony charges for election workers. A state jail felony is a very serious charge that carries a maximum of 2 years and a minimum of 6 months and can upend a person's life. House Bill 2860 would deter individuals from wanting to serve their communities and ensure elections run smoothly and fairly by criminalizing what could be honest mistakes. Further criminalizing election work will serve to chill individuals who may wish to serve as election workers in Texas. The Brennan Center urges this committee not to advance this legislation. Thank you.
Members, any questions? Thank you, Mr. Weinberg. Appreciate you being here today. The chair calls Shou Mei Wong.
Yes.
Show that you are here on behalf of yourself and that you're for HB 2860. Is that correct?
Correct.
Go ahead.
Yes, this bill actually is, I'm for all of this. I think it's a great bill, but here I'm just want to talk about the voter roll. Because currently, when we try to review the voter roll data, if we require the whole voter roll for a county, whatever we got is just the data as of today, as of the moment they pull. So we're not able to see any history on any changing history because there's no log there. If we want to know, we have to request the original document cause the change. So which is normally is the card or some kind of form from the voter or from some other source indicating the voter changing, the address change or their, last name changed, something like that. So we're not able to get that type of data and analysis from the data itself. Actually maintain this kind of a change log is really not hard. The technical is there and not required the device and the hardware, and it's not expensive at all. These things can be done and actually has been done in the private business sector easily. So I was thinking we should have this kind of tools for our election administration authorization, maintain a good and accurate voter roll. So that would.
Thank you, ma'am. Members, any questions? Thank you, Ms. Wong. Chair calls Ken Moore. Ken Moore. I think Mr. Moore is gone, but Ken Moore. I show him as here testifying on behalf of himself and for HB 2860, but not now here to testify. The chair calls Katya Erisman. Ms. Erisman, I see you're here on behalf of Common Cause Texas and yourself, and you're against HB 2860. Is that all correct?
That is all correct.
Now, you've heard the concerns about the increase, or the penalties You know, I hear those concerns. Do you have any other concerns about this bill?
That's largely it. I was going to scrap most of it except for one part, which kind of contextualizes that those increased criminalization penalties and like outside of the vacuum that this bill would be applied in. Largely what we're seeing right now is that this is not only coming on the trend of increased criminalization following SB 1 and other bills that would increase, the felony penalties associated with election administration or voting, but it also comes at the increased, intimidation of election workers and election officials. What we've seen in most recent elections is 1 in 5 local election officials in Texas have felt unsafe doing their job, have felt threatened already, and have felt, intended to leave the job or the profession after a certain period of time, given the increased polarization of election work right now. And so what this bill would enable, in addition to the intimidation factor of being afraid to do the work with risk of the felony penalties, is also enable those bad faith actors that will be looking for the increased scrutiny of their roles and looking for reasons to create vacancies in those offices by way of threatening the felony penalty. So given that kind of additional context, we would urge opposition of this bill.
Members, any questions? Thank you.
Thanks.
The chair calls.
I have one.
Oh, I'm so sorry.
How do you pronounce your last name again? I'm sorry. Erisman. Thank you.
The chair calls Christina Atkins. Ms. Atkins, you're here on behalf of the Texas Secretary of State's office. You're neutral on HB 2860. Is that all correct?
Yes, sir.
You are serving as a resource witness. Members, any questions of Ms. Atkins? Okay, thank you. The chair calls Alan Vera. Mr. Vera, you're here on behalf of the Harris County Republican Party Ballot Security Committee, and you're for HB 2860. Is that all correct?
It's all correct, sir.
Go ahead.
This bill would bring Texas voter registration rolls up to par with those of many of the better states in the country. More robust, more complete, better historical information would help resolve a lot of local disputes. I can tell you, because I'm up to my neck in them, this kind of voter roll data would have really eased up many of the 21 election challenges currently underway in Harris County, because the data would have been there, as opposed to having to fight over it for subpoenas and production. The availability of county voter rolls online required by this bill is a no-brainer. It's necessary. Voters should be able to access the data. And I'm sorry we're into this again, but you, the legislators, the policymakers, have got to decide, what do you do about public officials being paid by taxpayer money who don't do their job? I don't know if it's a state jail felony. I don't know what you do about it, but something has to happen so people understand there's consequences for not doing their jobs. The specific instructions in this bill to the appointed chair of the Signature Verification Committee, the appointed presiding judges of the ballot board, are necessary and appropriate. Members, the newly confirmed Secretary of State in Texas is currently in a deep dive through serious problems with our state's voter rolls. Based on what she's already found, this bill will be critically important to allowing her to fix those things that need fixing. We urge the committee to report HB 2860 favorably to the full House. Thank you.
Members, any questions? Thank you, Mr. Vera. Is there anyone else who wishes to testify on, for, or against House Bill 2860? If not, the chair recognizes Representative Day-Ayala to close on Representative Swanson's bill.
I think I'd like to begin by apologizing if I didn't lay out the bill as well as Representative Swanson would have. But I will say this, if you listen to all of the testimony, the only real criticism of this bill is the severity of the criminal penalty. That's what I heard anyway. What I heard from the overwhelmingly from the witnesses is this is a step needed to improve our roles, and it's in all other cases a very good add to the bill. For those with issues on the penalty piece of it, I don't want to pass the buck, but encourage you guys to speak to the author about that. And I know that her office will be welcome for that. If not, be happy to as well.
No.
With that, I'm happy to take any questions.
Members, any questions? Do you close?
Close.
Thank you, sir. The committee substitute is withdrawn. If If there is no objection, House Bill 2860 will be left pending. The chair hears none. House Bill 2860 is left pending. The chair lays out House Bill 4701 and recognizes Representative Day Ayala to explain his bill. Representative Morales offers a committee substitute. Is that okay? Thank you. Thank you very much.
And the committee substitute does a lot to narrow this bill. Mr. Chairman, Vice Chairman, members, the committee substitute 4701 is limited to ballot language for amending a city charter or voter-initiated referendum. Under those limited circumstances, the language is submitted to the Attorney General for review and approval as consistent with state law. This bill will reduce pre-election litigation, post-election litigation, and will instill added confidence that ballot language is proper and consistent with state law. This bill is proactive, will vet out mistakes in advance, will provide a check on ensuring our language is as good as it can be. And with that, I'm happy to take any questions.
Members, any questions? We will reserve your right to close. The chair calls Susana Carranza. Just to confirm, you are Dr. Susana Carranza, you're representing yourself and you are against the bill, is that correct?
Yes.
Please proceed.
So I was hopeful the sub was going to be helpful, but the actual issue that I have is that it really limits the ability of direct democracy. So the issues of city charter and citizen-initiated propositions are the ones that are really, I think, will be limited by this, and the sub just, it didn't help. So I think this is another way that the state is removing control from the local political subdivisions. And the same thing with the penalties, this trend to remove local control, we're seeing in bills throughout this entire session. And we're supposed to be a state that really values the rights of the local subdivisions by having the Attorney General go through to pre-approve or to kind of have to vet this. And it's that the legislative body usually passes laws to push limits of, constitutionality and things like that. And right now you're just saying like, oh, citizens of the city cannot have ideas of stuff they want to do. And things like, a lot of times ballot propositions are voted on so that they can trigger the legislative to do some stuff in the future. So they might be something not consistent with current law, but they would have language that would allow to be considered in future legislative sessions. So I oppose this bill.
Members, any questions? Thank you. The chair calls Ed Johnson. To confirm, you are Ed Johnson. You're here on behalf of yourself and you are for the bill. Is that correct?
That is correct.
Please proceed.
Yes, I mentioned that this is my favorite state. Okay, wrong time.
I thought it was Valerie Swanson.
Y'all as elected officials here are elected by the voters to come make state law. This bill is saying that a voter referendum charter to a city can't go against y'all's will or what y'all put into place into law. And lately we've been seeing more and more of these crop up in cities where it's a voter charter referendum that's on a, for a city that actually goes against laws y'all have made here for the state. So that's what this bill checks is, is this referendum against state law? If it is, it's going to give the AG authority to remove it because it's against state law. If you want to change state law, you come to this body and do the process that we're doing right now. You get in front of them with measures and ideas. You don't go out and pass an ordinance for your city to come up here to have it brought up for a conversation. And that's not how our system works. So this puts checks and balances into the system for making sure that cities are complying state law and are not misleading people on things that they can't really do.
Members, any questions?
Thank you,
sir. The chair calls Alan Vera. You are Alan Vera. You are here on behalf of the Harris County Republican Party Ballot Security Committee, and you are for the bill. Is that correct?
All correct, sir.
Please proceed.
I don't know how often local political figures deliberately scheme to create misleading ballot language. But when they do, it's a doozy. In 2015, the city of Houston was dragged into a lawsuit that cost the taxpayers millions because of their ballot proposition that said, let's do term limits on city council of 2 4-year terms. The fact is they were already limited to 3 2-year terms, so the language was, let's put term limits on it by actually extending their time. The lawsuits were incredible, wasteful, unnecessary. In 2017, the ballot proposition in Dallas County to close down Dallas County schools was worded so opaquely that former state senator Don Huffines had to spend $750,000 of his campaign money explaining to voters on TV what a yes vote meant, what a no vote meant. So I don't know how often it happens, but when it does, it's a doozy, and people pay a lot of money for it. This bill simply says, let's have one more checkpoint to avoid getting ourselves into that situation. We respectfully urge you to pass that bill on to the full House favorably. Thank you.
Members, any questions? Thank you, sir. The chair calls Kathy Heigler. Is it Hagler? Hagler, I'm sorry. Kathy Hagler. You're Kathy Hagler. You're here on behalf of yourself, and you are for the bill. Is that correct?
Yes, sir, that's correct.
Please proceed.
I really like the bill. I haven't seen the sub, but as mentioned before, I just find it outrageous that our legislature passes bills and then some city or political subdivision passes a resolution or a proposition that's in direct contradiction to our laws. It shouldn't be happening, but if you're not sure if it's still happening, check out Prop A in San Antonio in May. We can't allow political subdivisions to go rogue and exempt themselves from the state law. So I've already spoken to the representative's office about this. I love his bill, but I would make one tiny little amendment, and that is that if the Attorney General does send a letter of approval, that be required to be posted on the website with all the other notices so that anyone can go on the website and verify that it has been approved by the Attorney General. And that's all of my testimony.
Members, any questions? Thank you. The chair calls Russell Hyder. Russell Hyder. We will show Russell Hyder registered on behalf of himself and for the bill and not testifying. The chair calls Andrew Hendrickson. You are Andrew Hendrickson. You're here on behalf of the ACLU of Texas, and you are against the bill. Is that correct?
That's correct.
Please proceed.
I know it's been a long day, so I'm going to keep this confined to just one portion of the bill. In the section when it says the Attorney General finds a proposition is consistent with state law, that is on page 1, lines 18 and 19, or in 21, lines 21 and line 22, a proposition is not consistent with the law. That is a clear violation of the separation of powers clause. A member of the executive branch of government cannot decide what is and is not consistent with state law unless there is express permission granted by the Texas state constitution. That is a role for the judicial branch, and being a member of the executive branch, not within the authority of the AG, because there is no express grant in the Texas Constitution that would allow the AG to engage in that type of judicial review. Also, that is bolstered by the fact that there is no opportunity for this opinion of the AG to be challenged in court or overruled by judicial process. As the Court of Criminal Appeals has said on many occasions, the Texas Separation of Powers Clause is actually enforced. Separation of powers doctrine should be enforced more aggressively than the federal branch. They've articulated two clear reasons for that. One, it is explicit in the Texas Constitution, whereas it is only implied in the federal Constitution by the structure of the Constitution. The other is that there is no necessary and proper clause in the Texas Constitution like there is in the federal Constitution, otherwise known as a sweeping clause, which gives the power of any, branch of government the ability to exercise things not expressly provided for in the Constitution that are maybe necessary or proper to perform their duties. Accordingly, the courts have repeatedly said that the executive branch or any really branch of government really can't do anything other than what they are expressly allowed to do in the Constitution, and there is nothing in the powers that are articulated to the AG in Article 4, Section 22, that would allow them to engage in this kind of review.
Members, any questions? I have just one for you. And it's the same, you highlighted my concern, and tell me if I'm off base here, but this seems like we're taking AG advisory opinions and giving him force of law.
That's absolutely correct. Is that yes, the AG could give an advisory opinion on this, but that would have to be reviewable by a court, and it would it is not. We would be giving them basically the ability to make binding law, which they are not able to do.
Thank you. Members, any other questions? Thank you, sir.
Thank you.
The chair calls Robert Green. Robert Green, we will show Robert Green on behalf of the Travis County Republican Party Election Integrity Committee for legislation and self for the bill and not testifying. The chair calls Elizabeth Miller. Elizabeth Miller, we will show Elizabeth Miller, registered on behalf of League of Independent Voters and self and against the bill and not testifying. The chair calls Emily B. French. You are Emily B. French. You're here on behalf of the Texas Civil Rights Project, and you are against the bill. Is that correct?
Correct. And before I start, I want to ask the lawyers on the committee, do you prefer amicus or amicus brief?
Amicus.
Amicus, okay, that's what I was going to say, but I would have said that if you said amicus too. I'm here to testify against HB 4701. Specifically, we oppose granting the Attorney General's office the power to oversee ballot proposition language in many political subdivisions in this state. This bill would give the AG unilateral authority to determine whether a ballot proposition is consistent with state law. The process in this bill would take power out of the hands of voters across the state and consolidate it into one office. Our current AG eagerly seeks out culture war battles across the United States. In the past year, he has filed amicus briefs, one job, condemning federal investigation of Mar-a-Lago in Florida, opposing vaccine mandates in Arizona, and supporting efforts to halt a deposition of Senator Lindsey Graham in Georgia. We don't dispute that amicus briefs fall within the purview of the Attorney General's office, but HB 4701 would give that same Attorney General full power to strike down ballot propositions. It is hard to believe that an official willing to fight the partisan fights in Florida, Arizona, and Georgia would conduct a balanced, objective review of ballot propositions coming out of progressive counties written by progressive Texans here at home. This bill also provides no mechanism for appeal. If the AG's office doesn't like the content of a ballot proposition, they can reject it over and over. This bill provides no consequence for a bad faith interpretation of the law. It doesn't designate any outside agency or official who can overrule an interpretation of the law. The AG would have the first and last word in building the proposition ballot of many political subdivisions across the state. The Attorney General already has the power to challenge ballot measures. HB 4701 would take that process out of the public forum of the courtroom and push it behind the closed doors of the AG's office. We urge you to stick with the transparency of the current process instead. Thank you.
Members, any questions?
Yeah.
Yes.
What is the transparency of the current process?
I believe that it's just the Attorney General files a court case, as is, I believe, has happened before, and I won't, it's too late in the evening for me to cite anything I'm not 100% sure of, but he would file a court case that would be reported on. People would give all their arguments, all the things that we hear about in regular court cases. That's the process we prefer as opposed to an internal review.
Members, any other questions? Thank you, Ms. French.
Thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 4701? If not, the chair recognizes Representative Day Ayala to close.
The main criticism that I heard was the Attorney General would be stepping outside of his role. The Attorney General provides advisory opinions all the time. Mr. Hendricks' testimony referred to it as just that, as it's an opinion, whether it complies with state law or not, which he does all the time. His office is authorized to do so, and he's doing it again by direction in the statute. There are appeal processes if this is wrong, and there are remedies for it if the Attorney General is mistaken or an error in the opinion that he gives. So with that, I think that resolves the issue that was a main concern of these witnesses. And I think the overwhelming support of what I refer to as the certainty of the language. We've heard bills, we've heard things all over the place where it says, this is the America is a Wonderful Thing bill proposition or whatever. And what's really written in there is something very different. This helps clarify that. When you have a proposition that is a direct violation of state law, it can't be done. The subdivision, the municipality is a subdivision of the state, and this is something that just clarifies that you just can't violate state law. So with that said, I'm happy to take any questions. I think this bill stands on its own and is going to be subject to the legal scrutiny that you heard here today. Not being the one who's going to opine on that ultimately, but at least that's the vision I have on it. Happy to take any questions.
Thanks, sir. Members, any questions?
I asked the committee to look on this favorably.
Yes, sir.
And with that, I close.
Thank you, sir.
Thank you.
The committee substitute is withdrawn. If there is no objection, House Bill 4701 will be left pending. The chair hears none, and House Bill 4701 is left pending. The chair lays out House Bill 3537 and recognizes Representative Manuel to explain the bill.
Good afternoon, Chairman and members of the esteemed election committee.
Yes, that's right.
House Bill 3537 seeks to amend the Texas Education Code to prevent an individual who files in more than one party's primary in a single election year from being a candidate in any primary or general election for that year. During the filing period for the 2022 primary election, an individual filed as a candidate for the State Board of Education District 11 with all four recognized political parties in the state. Current law does not provide a mechanism for the rejection of applications for a candidate who files in more than one political party's primary election, even though the candidate would not be allowed to appear on the general election ballot as more than one party's nominee. This bill seeks to address candidates who run for office in multiple primaries, undermining the primary process, sending confusing signals to voters, and potentially muddying the process for other primary candidates for different offices.
Representative Manuel,
yes.
Do you have a substitute?
Yes, we
There
should have
is.
one. Was it not?
Yes, so
I'll
Vice Chair
back up.
Busey offers a committee substitute. Now, go ahead.
Want me to start over now or continue?
Just keep going.
Okay, all right, good.
Thank you.
The intent of this legislation is to prohibit candidates that file for office from filing to run in more than one party's primary and to ensure that we have fair elections for all candidates. Of course, there is a committee sub. We do anticipate some more changes, so another committee sub will probably be coming. And unless you all have any questions, I will humbly request the right to close. I think we have one witness.
Yes, sir. Yes, sir. Members, any questions of the representative? Thank you. The chair calls Brenda Cruz. You are Brenda Cruz.
Yes,
You're here on behalf of the Texas Democratic Party, and you're for HB 3537, is that correct?
yes.
Thank you. Go ahead.
Thank you so much. I was going to say good afternoon, but I'm sure it's good night at this point. My name is Brenda Cruz, and I am the Deputy Voter Protection Director for the Texas Democratic Party, and I'm here to testify in support of HB 3537. As Representative Manuel stated just now during the filing period for the 2022 primary election, we did have an individual who filed for a run for a state board of education, and he filed with all four parties. Our primary administrator at the time sought guidance from the Secretary of State's office and was advised that current law does not provide a mechanism for the rejection of that application. We did have several conversations with them. Most recently, I had a conversation with Keith Ingram at the beginning of the year to make sure I was very clear on what the situation was. There were two parts of the code that he mentioned would probably confuse people, and those were section 52.034, which prohibits a candidate's name from appearing more than once on the ballot. And then another section was 162.015 that says candidates who fail to advance in the primary election cannot be write-in candidates in the succeeding general election. However, neither of those sections actually address the issue that we were faced with. One of those things was that, for example, for a primary election, they're all separate elections and they're separate ballots. So a candidate would not be on the same ballot for the primary. And so we just had a very difficult time with that, considering that our job is to make sure that the election runs as smoothly as possible for our primary voters. And it is fundamentally not fair for our voters to have the ability to have somebody's name appear on that ballot when they know that they are going to be ineligible for the general. Thank you.
Members, any questions? Thank you, Ms. Cruz.
Thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 3537? If not, Chair recognizes Representative Emanuel to close.
Thank you, Chairman and members. Also, as we know, it is illegal to vote in multiple primaries, so I think this is a good start to making sure that we're having fair elections and making sure that people are doing exactly what they should do and not causing confusion. And unless there are any questions, I request to close.
Thank you, Representative. Members, any questions? You close?
I close.
Thank you, sir.
Thankfully.
Committee substitute is withdrawn. If there's no objection, House Bill 3537 will be left pending. The chair hears none, and House Bill 3537 is left pending. I want to congratulate everybody on a really professional day. That is going to be the end of our business. I appreciate everybody hanging in there with us. I think some good work was done. If there's not any other further business for the committee to address, then I'm going to call that the House Committee stands adjourned, subject to the call of the chair.